Kia ora ki a koutou katoa. Tā kiri mai te ata, ura te ata, kaka te ata. Huru mai te ao o te tangata, ki ana rerenga ki tōna kawa. Ko tēnei te ao, ko te ao mārama, e rongo whakirira. Haumi kui e mai ki ka.
Just on health and safety, before we start the hearing today, the emergency exit from this room are the door to my right and the double doors through which you entered the meeting room. In the event of emergency, please follow the guidance of staff. Toilet facilities, there are male toilet facilities in the foyer immediately outside of the council chamber and female toilet facilities in the main foyer of the building. Thank you. I'll pass this on to Mark Sinclair, our chair of this hearing.
Thank you. Good morning, everybody. The matter being heard today is Te Rūnanga o Awarua, Department of Conservation and Environment Southland applications for suite of resource consents, coastal permits, water discharge and land use for the periodic opening of the Waituna Lagoon to the sea, and this is being heard under the Resource Management Act 1991. My name's Mark Sinclair. I'm an independent Resource Consent Commissioner, and I'll ask the other panel members to introduce themselves.
Kia ora koutou, ko Megan Mackay, te Rūnanga no Taumitu Ahau. I am Megan Mackay. I'm a lawyer and independent commissioner, and I'm based in the Taumitu Takiwā of Southland.
Thank you, and my name is Ian Boothroyd. I'm an accredited independent environmental commissioner. Thank you.
So as you're aware, we're being assisted today and through the hearing by Ms. Onko. Any issues in terms of talking with the panel and that need to go through her to be able to bring to us. So what I'm going to do is first outline the procedure of how the hearing's going to proceed over the next few days. The first thing we're going to do after all this introduction is call for appearances. So that's all the people who are presenting evidence or speaking to submissions, presenting legal submissions, 42A officers, that kind of thing. If you're just here to observe, then you don't need to stand up and tell us your name and that. Then we're going to ask for if there are any preliminary procedural matters that anyone wishes to raise. And this, having addressed that, we're then going to go on and hear from the applicant who are sitting in front of us here today, and then tomorrow when we're hearing from the submitters, they're not going to be there. Whoever's going to be presenting to us will be sitting at the front table so that we can chat with them. Having heard from the applicant, and that's scheduled today, and at the end of each row there's a copy of the hearing schedule in terms of timeframes roughly that the panel is supposed to try to keep to. In my experience, this might not happen because probably the panel's going to ask too many questions, and that might delay things, but we'll work through that. Having heard from hearing from all the submitters, hear from all of them, then we hear from the 42A officer, and at that point, we're going to adjourn the hearing because Dr. Robinson is currently overseas, and we're going to hear from him on August the 13th, and we'll talk with the applicant about working out what time that will be. Having adjourned hearing, then on Friday, all going well weather-wise, that we're going to visit 3 properties that the submitters have identified, so thank them for doing that. That will be most helpful to see the issues that they've raised. Then after hearing from Dr. Robinson on the Thursday, we'll then work out how we're going to work out the rest of the hearing in terms of any additional information we might need. But the last thing in an RMA hearing is always the applicant's right of reply. And as you can tell, we're signalling now that that's probably going to be in writing rather than reconvening reconvening the hearing. So that's all the procedures, and I'll come back to the appearances shortly. There's just a couple of other things to go through. In terms of an RMA hearing, there's no opportunity for parties to ask questions of each other or cross-examination. The only people under the RMA that are allowed to ask questions are the panel. This isn't a public meeting, it's a hearing under the RMA, so it's got more formality, but we will try to keep that to a minimum. What we want to make sure is that each party gets the opportunity to present their views to the panel, and that, as I said, we're likely to have questions so that we can understand the issues being raised. One thing you might observe when RMA panels, we might be asking a lot of questions about conditions of consent. That does, just because we're asking them now doesn't mean that we have decided to grant consent. We haven't, but this is our only opportunity to ask questions about the conditions. So if we were going to grant it, we want to make sure we've got those correct. So that you're aware, yesterday the panel undertook a site visit. We were shown around by Pat Hoffman. We went out on the boat to the lagoon openings. We then went to on public roads and to Dockland to look at various areas on the landward side of around the subject site. And yeah, and as I said earlier, on Friday we're going to have this other site visit to these individual properties. So that we're happy to meet Mr. Duncan at 9:10 at the garage, and that will be the commissioners, and Ms. Onko will be accompanying us as well. So it doesn't say on this timesheet here, but I can tell you now it's going to be a morning adjournment from 10:15 to 10:30 every day, as well as lunch 12 to 1 and the afternoon adjournment from 3 till 3:15. We have quite a few people to get through, so I can also tell you that we have arrangements have been made so that we can sit later than 5 o'clock if we need to. People are taking time out to come and do this, so we want to make sure that we hear you on the day that you were scheduled. The last thing is that in terms of cell phones, if anyone's got one, could you please make sure it's turned on silent and that for the duration of the hearing? That's all I had to start with. I'd like to now move on to taking appearances, and if we could start with the applicant, please.
Tēnā koutou, e nā kaikomihana, nera kamihi, kei kone oho ki nā kaitono, so ko Penny Williams toku wikoa. So I'm Penny Williams, I'm counsel for the applicants, and sitting beside me I have John McCarroll, who is the representative for the Department of Conservation Te Papa Atawhai. Then beside John we have Dean Whanga, who is the representative for Te Rūnanga o Awarua, and two deans far right. We have Lucy Hicks, who is a general manager here with Environment Southland, as representative of Environment Southland. So they are all here now. Mr. Whanga is going to give evidence a little later today. Otherwise, they are busy people. They will do their best to be here for as much of the hearing as they can, but they are going to be in and out
Yeah, that's right. Sorry, and I meant to say, when you're giving your name for the appearance, because this is how it will appear in any decision, could you please tell us whether you wish to be referred to as Ms. Dr.
Yes,
My Lord, whatever.
Ms. is fine. I
Thank you.
am Ms. Williams, so thank you.
And then the rest of your witnesses.
So the witnesses being called for the applicant start with Mr. Whanga. Then we have Ms. De Winton, who will be online. Then we have Dr. Holmes, who is online. Sorry, I need to find my own list. Then after Dr. Holmes, who is also online, we have apologies, I just need to find my way. After Dr. Holmes, we have Mr. Jacques.
Yep.
And I think that takes us through to lunch. After lunch, we start with Mr. Erie. After Mr. Erie, we go to Dr. Schellenberg. So Mr. Jacques and Mr. Erie are in person. Dr. Schellenberg is online. After Dr. Schellenberg, we have Mr. Rebel, who is in person. Then we go to Mr. Measures, who will also be online. And the final witness appearing today for the applicant is Ms. Thorne. And Ms. Thorne will also be online because she just has a few little health issues that's happening, so she's been advised not to travel for the moment. And there is a plan in place if things happen and Ms. Thorne is not able to complete the hearing, so just so that you're aware of that. And as I say, then we're going to ask you at the end of the hearing this week to adjourn and reconvene in August to hear from Dr. Robinson.
Yeah, okay. So just while we're on Dr. Robinson, then shift that to the 13th. And we were thinking
that's fine.
10:30. It'll be like this. It'll just be, we'll open it and go that so 10:30 on the 13th for that, and then at the end of that we'll probably issue a minute so that any of the submitters or other parties who wish to respond to anything raised by Dr. Robinson can do that in writing, and the 42A reporting officer as well. And we'll confirm that in a minute, probably at the close Thursday, possibly Friday. We won't get it out till Friday, probably. Okay.
That's absolutely fine.
Okay, thank you. So if any of the submitters are here and are presenting, could you identify yourselves and we could take your name down?
I'm Quentin Scandrett from Scandrett Rural, and I'm here with Joanne and Ken Crack from Southern Star Farms.
Okay.
And we are presenting tomorrow.
Right, okay. Southern Star Farms, I've seen this. Excuse me, sir, could you say your name again?
Quentin Scandrett.
Oh, right, okay.
And John will be presenting expert evidence.
Expert evidence, yep, okay, thank you.
Thanks.
Thank you. Any other submitters here? Sir?
Ewan Peary,
Mr. Peary?
submitting on Thursday, I believe.
Right. Thank you. Right. Hope that there's no one else here who's speaking to a submission, what have you. That's just going to be turned up on the day at the scheduled time, so we might have to go over some of what we've already presented here, but we deal with that at the time. 42A officers.
Miss Danielle Patricia Batch, Section 42A officer for council, independent planner via SLR consultant.
Could you pronounce your name correctly for me so I know what you're saying?
I say Petrosevic, or
Petrosevic.
Petrovic is fine, yeah.
Okay.
I've also, sorry, I've also.
Yep.
Yeah, sorry, I've got another difficult last name for you. My name's Mike Duisberg. I'm a lawyer from Wynne Williams. We act for Environment Southland in its regulatory capacity and assisting the 42A reporting officer.
So next thing I wanted to do, thank you everyone, is to ask if anyone's got any procedural matters that they wish to raise at this time.
So there are some, I'm not sure if they're procedural or preliminary, but there's some joint witness statements that have been prepared.
I'm hopefully going to deal with them, and there's a few other things that have come in as well overnight, and I'll take those as preliminary matters. So, all right. Right. In the fast-moving world that is RMA, resource consent hearings, there's a few things that have come in, and so that everybody's aware of them, I can let you know what's been handed up to us. So we have a letter dated the 24th of July from Ngāi Tahu, just advising that they're not going to be speaking at the hearing. The other matter was that, yes, overnight, about, I think it arrived 8:30 or something to us, we received a joint witness statement from the planners, and we've requested that that be put on the website and sent out to the parties, which I understand has been done. Because that's in so late, and we're going to ask the planners when we speak to them to ask how the joint witness statement changes their evidence, if at all, and deal with it that way. And on that matter, in terms of when we ask questions about conditions, we're going to be relying on Ms. Thorne's evidence, as that was the last one that came up with a set of conditions, and that's the one that we've prepared all of our questions as to the conditions. Ms. Onko is trying to get us some printed out hard copies, but there's it's having problems with the technology, so she might want to prepare a few more and put them on the side so that other people can access them as well once that works.
So there is another joint witness statement as well, which is from Mr. John Scandrett and Dr. Schellenberg, Mr. Measures and Mr. Rebel. Again, that I think was only finalised this morning, and so I'll actually ask my colleague Ms. O'Connor to just forward that to Ms. Onko
That would be fine, and again, 4 hard copies, that'd be good.
And I'll
Again,
acknowledge that I haven't,
we're not gonna be, we're gonna be asking questions of those witnesses as though that doesn't exist, because we're hearing 9 witnesses today,
yes,
and we will, depending, we might be able to read it during the morning adjournment or during the lunch. But yeah, we'll see how we go.
and yes, I have not done more than briefly start reading the planner's joint witness statement, so I haven't seen it either.
So that's from Dr. Schellenberg.
Yes, so it was Mr. John Scandrett, Dr. Schellenberg, Mr. Ravel, and Mr. Measures.
Was it, just to those witnesses being advised 25 minutes into a hearing is a joint witness statement, not falling into the category of what we call helpful. But we'll,
Yes, understood.
thank you.
I don't think there were any matters of disagreement, so that is
Okay. Very good.
straightforward.
Well, yep, we can come to that when we get there. You haven't taken up more than the 5 minutes allocated. I will now hand over to the applicant to present their case. Thank you.
Thank you, Opoko, and thank you for this opportunity to speak to this application. And I also do want to acknowledge that behind me, we have Thompson, Foster, who are here along with to to support this application as well. So, so Waituna. Waituna is.
Just by
Yes.
the way, we'd like you to take us through your
Yeah.
legal submissions.
You would like me to take you through? That's fine. So Waituna. Waituna is a special place. It is Kine Te Repo, it's a wetland, it's a swamp, it's energies, it's connections between Te Whenua, Te Wai, Te Wai Māori, Te Wai Moana, Te Ara Akiwa. So it's all of these things come together in Waituna. This application is the culmination, well it's not the culmination, but it is a major step along the way of work, mahi, that has been ongoing for many, many years between the 3 applicants here today, but also many other stakeholders. So there's mention obviously of Te Rūnanga and Otahu, Te Waipareira Trust, Whakamana Te Waituna Trust, Southland Fish and Game Council, Southland Federated Farmers, Fonterra through the Living Waters Partnership. Many, many, many people, and most importantly, are born a community of Waituna catchment. And Mr. Whanga's evidence talks about Te Korowai and having the cloak to protect, overarching, and having the whenua and the aho coming together to make different patterns, but all with this intention of protecting and restoring Waituna. The applications seek resource consents to manage opening the lagoon for cultural and ecological purposes, to restore the haora, the mana, the Māori of the Wai. They are part of this aspiration, and I actually have at the top of my legal submissions mana oranga, mana tangata, mana ki uta, mana ki tai, mana waituna. Ensuring the well-being of the people, the land, the waters, the ecosystems, and the life force of the Waituna catchment and lagoon, now and for future generations, through this partnership approach. So there's a new opening regime which is proposed, which is focused on that restoration to a Awarua state. It has a water triggers water levels trigger, and we acknowledge that that is a change from how the lagoon has been managed historically. And so that is part of the purpose for the 20-year term that is sought for this consent, is because it's allowing the time for the whenua, the wai, the moana, all to adjust by having this stage transition over the 20-year phase. Initially, there were 3 stages that were proposed. So sort of a winter opening at years 1 to 5 with, I think, summer openings were going to be at 2.5. I always get this the wrong way around. And winter at 2.3, and then at years 6 to 15 going to a 2.5 year-round for 3 days, and then 16 to 20 going to where the applicants aspire to be, which is 2.5 metres for 7 days. So that's the water levels. There's been a change to that, and that arose because of the concerns that were raised with us at the pre-hearing meeting. So we heard the community's concerns that this was going to be too fast, and the applicants went back to the Science Advisory Group and said to them, what about that 2.4? What would be the impact of having levels at 2.4? And the Science Advisory Group went, still not optimal, but as a stage along the way, it would be okay. So applicants, having taken on board that advice, revised the application, reduced the summer opening level for the first 5 years, so now it's 2.3 or 2.4, and then added an interim step between years 6 to 10 at 2.4. And that is taking on board the concerns of the community while still moving to where we want to be. Other concerns that many people have raised have been around water quality and ecosystem health. And so the applicants have proposed a second trigger, which is focused on that aspect. And there's a mix of primary and secondary indicators, which the Science Advisory Group, and I'll talk a bit more about the Science Advisory Group later, but the Science Advisory Group will assess those matters. There's ongoing monitoring that's happening. If things start to go up, there's a warning level, and if things have really got to a point, there's a critical level. And Science Advisory Group will provide recommendations to the applicants, who will then make a decision to open the lagoon. The third trigger that's proposed is around a fish passage. And again, this is because at this stage, the lagoon is, and that's set out in the evidence of Dr. Holmes, it is not what would have perhaps been the natural fish community that is present in the lagoon. There are many species in the lagoon which do migrate between Te Moana, Te Ara-Akiwa, and Waituna, Waimaori. So that condition is there to meet the needs of those species. And in particular, it's actually for kanakana lamprey, which are a taonga species. Lamprey, adult lamprey are very much attuned to the pheromones of the young, and they will come in if they sense those pheromones, because that's telling the adults that this is a place which has healthy habitat. So the openings for fish passage are proposed to be no more than every 24 months, and that's on the basis that there should be a juvenile cohort of kanakana in the catchment who will provide that signal, that indicator to the adults to come in. I'm not going to talk to the next para because I go on to talk to that anyway. But I have set out in the next paragraph some context about the applicants. And again, I'm not going to go through that because that's in the application in more detail. But again, just acknowledging that the applicants have been working together alongside the community, the District Council, whom I apologise I didn't mention before, Pontiera, Whakamanatu, Rūnanga and others. And this is with this goal of improving the hauora, the ecological cultural health of the lagoon and the catchment. And this is taking a ki uta ki tai approach. That's discussed a little bit in Mr. Whanga's evidence that is also raised, I think, in the expert evidence from Ms. Sanazaro for Federated Farmers. I have been counsel for the Director General of Conservation through all of the Southland Water and Land Plan hearings, and ki uta ki tai, the concept of ki uta ki tai is a key concept in the Southland Water and Land Plan, and that's acknowledged in that first Environment Court decision from 2019. And this application, as I've said, it's a significant step to achieving this goal. So the Southland Water and Land Plan is intended very much to address the catchment inputs and to drive better behaviour. This is managing the lagoon as the receiving environment for what is coming down the catchment in a way which promotes its hauora and restores it. And I've probably already traversed a lot of the stuff that's in my next section, but Waituna, as I say, it's a taonga. And that's also shown by its recognition in the Ramsar Convention as a Ramsar site, and being one of New Zealand's first sites that were recognised. Started in 1976 with the 3, now we have 7. And Waituna was one of the original sites, and then as described in Dr. Robertson's evidence, the site has been expanded to acknowledge the importance of those other wetland and estuarine areas around it, and the expansion in 2006. The Science Advisory Group, Technical Advisory Group, many of those people have been working here in Waituna, and that's shown in their evidence since 2011, 2012, 2013. And that has meant that we have had the benefit of having, in terms of this application, we have had really good science happening in the catchment and in the lagoon for a long time. And so we have very good information about that. The one gap perhaps was actually around the fringing wetland vegetation. There was the report that was done by Mr. Blythe, which Dr. Robertson refers to in 2013. And that really hasn't been repeated since then, and so that's the reason why, in relation to that fringing vegetation, there's the proposal that, and the conditions, that there be a baseline survey to just reassess where we are now in 2025 in terms of that vegetation, and then repeat that as part of the monitoring at 5-yearly intervals, just to see, hopefully, that transition. There's been a lot of actions which have been taken, and I've set some of those out here. And
could you assist us by just when you refer which paragraph
oh,
you're up
sorry,
to? That would
absolutely
be helpful. Thank you.
I'm about to go into the section, the applicants acknowledge the community highly values Waituna Lagoon. So I'm just coming to the conclusion of paragraph 10. And again, just coming back to the co-applicants. So the applicants have come together. This is something where we all have an interest. DOC, because it's a scientific reserve, it's a Ramsar site. DOC has that mandate on behalf of the Government of New Zealand to be the responsible agency for Ramsar sites. Awarua, mana whenua, takiwa, kaitiaki. Statutory acknowledgement from the Crown and not just in respect to Waituna, but also in respect to Te Ara Akiwa Vovo Stream. So Awarua have to be here. Environment Southland obviously has regulatory role, also, however, as catchment manager. And Ms. Hicks is here very much in that role. So we are all here together. We all have roles to play, and that's why we are making this joint application. So moving into paragraphs 11 and following about the community. We have, and I have read all the submissions, we have submissions from people who deeply care about Waituna, who have been recreating, working, observing, celebrating Waituna for generations. And I really, really acknowledge Mihi, the community for that. Some submitters have acknowledged that the Water and Land Plan is driving this change in farm practices and farm management, and have said that they are committed to keeping up that good work. And again, that's part of that ki uta ki tai approach. And again, I acknowledge them for that. As I've already talked to, the applicants have considered concerns raised by the submitters in the pre-hearing meeting and made some changes, in particular around the staging over the water level transition. A communication management plan was actually prepared and drafted in November, was discussed as part of the pre-hearing meeting, and then there was work done with representatives of the community, and that's the final communications management plan. And I say final in the sense that it's final to the applicants, it's not final to the panel, because I acknowledge that, of course, these are still proposed conditions. But yes, that's something that was worked on more to just enhance and make sure that information goes to people who have an interest and who want to know. Another matter that the submitters were concerned about was, this is a three-headed taniwha, how is this going to work? And so that's where we have brought in a draft consent implementation plan, and in particular decision tree, just to step through when this happens, what happens next. And that also is attached to those proposed conditions. And it's Appendix 1B I'm using of Ms. Thorne's evidence. So, yeah. And currently the partners have a memorandum of understanding in place that is about getting us to the consent, and the intention is that we will have a new relationship agreement which will formalise how we will work together going forward. So the applicants are committed to working together with the community and with other stakeholders to ensure the hauora of Waituna, and that's whatever happens, frankly, with this application, because we all have those roles. And I do talk to submitted concerns a little later on. So moving into paragraph 15, the evidence for the applicants shows the lagoon is a place with a complex ecosystem and multiple values that need to be managed. You can't just manage for water quality. You can't just manage for fish passage. You can't just manage for aquatic plants. You can't just manage for recreational values. You actually have to manage for all of these things. And so for Awarua, and particularly more broadly Ngāi Tahu Whānui, Waituna has immense cultural significance. I've already spoken to the statutory acknowledgements. We also have the establishment of Piki Rorahi, the Mahikakai Pā, which is discussed by Mr. Whanga in his evidence, and you would have seen that yesterday, I expect, on your site visit. Waituna is one of the only remaining examples of large coastal water bodies on the New Zealand mainland that is kind of natural, that regularly supports submerged macrophytes dominated by the Rupia plant assemblage, and that's discussed in the evidence of Mr. Winton. It's a productive freshwater environment. It supports a diverse freshwater native fish community and has strong representation of taonga species, and that's particularly discussed in the evidence of Dr. Holmes. More than 90 species of birds have been recorded. It is a place where the arctic migratory species come in our summer, their winter. There's also waterfowl, waders, wetland species. Some of these are of conservation concern, and that's discussed in the evidence of Mr. Jacques. It's a place that people go to recreate, including to appreciate its ecological values and also its cultural values. And the department has some assets in place, and that's spoken to in the evidence of Mr. Erie. It's the only remaining coastal lagoon on the east coast in a natural ecological condition, but it remains at risk of crossing that tipping point without action being taken, and that's in the evidence of Dr. Schellenberg. As I've said, it's the bottom of the catchment, it's the receiving environment, so it is at risk of nutrient buildup from excessive contaminant loads, and that can have an impact on its water quality, and that's discussed in the evidence of Mr. Ravel. Opening the lagoon would have a positive impact on nearby properties in the lower catchment that otherwise are inundated or have reduced drainage capacity at higher levels. Various scenarios have been modelled and validated, and that's discussed in the evidence of Mr. Measures. These 8 out of 9 criteria for a Ramsar site, and I think actually to get recognised you only need 3, so it's up there. It's considered an endangered ecosystem type in New Zealand. There are complex multi-values present. They all need to be assessed to decide the optimal regime for opening, and that's discussed in the evidence of Dr. Robertson. And of course, the resource consent also needs to have regard to all of these matters, as well as the interests of the community in restoring the haora of Waituna, and that's discussed in the evidence of this thought. We're going to use the 1B revised conditions in Ms. Thorne's evidence. I do note that there are the further revised conditions in the evidence, and I'm going to have a go. Ms. Three-Sevich, excellent, as well as Ms. Sanzaro in that joint witness statement. So one of the matters that you raised in minute 6 was around why there was no application for consents from Southland District Council, which is a very good question. And this is where I have then run you through from paragraph 17 to, gosh, where does that finish? 26. Through a discussion about section 4, subsection 3 of the Resource Management Act and section 9, and why it is that for the Department of Conservation to papa-atify as a part of the Crown, consents aren't needed where there would be otherwise potentially a district rule. So that's there. Do you want me to run through that?
So one question would be is the joint application, of which the department's only one arm.
Yes.
Is that usual? Is there?
It's
people rely? Can the other parties rely on that in terms of being granted?
My view is they can, because it is a joint application. I think if it was an application by, and so for example, so the contrast actually is with the emergency openings that were done last year, because that was an action of Environment Southland. That still required the Reserves Act Authority, which I'm going to come to next. And because they did it as a section 330, there was an assessment made that they didn't need to get resource consents. But if they had decided they needed to get resource consents, they potentially also would have needed them from the district council as well as from the regional council.
But it's not unusual that the three parties working together the other two can rely on the departments.
Yes. Yes, and there's a situation actually up, in Marlborough, and I am not sure, I think the department is a co-applicant on that as well, where there's action being taken to restore, and I cannot remember the lake, I'm sorry, but it's a lake on possibly D'Urville Island, which is very polluted, and that involves a discharge of aluminium something to bind the stuff that is otherwise going into that lake to restore it, and that is also yes, and that is also being done with the department and iwi and working alongside the councils. So,
is that consent been granted?
That consent has been granted because there's been at least one application which has occurred, and I'm sorry I can't tell you more than that because I don't know the details.
Can you find out about that?
Yes, I will.
It up tomorrow morning.
Tomorrow might be a little pushy. I'll see what I can do. Yeah.
9 o'clock tomorrow, if you get a copy of that. Just, would be helpful. Thank you.
I'll follow up.
Yeah. In paragraph 19, you talk about the lands owned by held by the Department of Conservation. So what is it that you're relying on for that? Is it just the SO plan that's?
Oh no. So there are gazette notices and things that are in place. Sorry, and I'm not sure if they're in the application or not, but there is so Waituna was first gazetted as a wildlife management reserve in 1971. Was made the Ramsar site in 1975. When the Reserves Act 1977 came in, one of the things that had to happen was a process of reclassification of all reserves, and so for Waituna that happened in 1983 when it was classified as a scientific reserve. So
we'd like copies of the Gazette
copies of
notices,
those Gazette
please, so that
notices.
we can actually see, or anything else that shows the equivalent of a record of title.
Yeah, and then because there isn't a record of title, because it's
the equivalent of, right, in order to who owns the land.
That's fine.
I just had one follow-up question, and that was in regards to the piggy banking. So can you piggyback off? Can others piggyback off the dock? Not requiring a consent, and so you're going to go and look and see, have there been other applications and have they been successful? What would also be really helpful to know is, has that ever been legally challenged?
Not as far as I'm aware, to be fair. So people have challenged, and that was the Jasper case that I referred to, where Mr. Jasper challenged, and that was about a 1080 discharge application, and Mr. Jasper challenged whether there was a need for consents, but that was an activity only of the department. There's been a few others as well before the exemption regulations came in. But no, I don't think there's ever been a challenge to what we're calling the piggyback. And to me, it's not a piggyback. This is a joint application. So the activity is the activity of the department as much as it is the activity of Awarua, as much as it is the activity of Environment Southland. And that's why I say that it qualifies for that exemption.
And so would that Jasper case clearly articulate what law is being relied upon for that?
Actually, all it says is they accept the advice of the planners that Section 4.3 means that no district consents are required. I can provide you a copy of Jasper.
So just a further follow-up question. In that question of reliance, and you mentioned a memorandum of understanding, I'm not sure that we've seen that.
We have not produced that in evidence because actually there's some matters in there about how we work together, which and also some other things which the parties wanted to keep confidential for the moment. So, yeah.
Perhaps I can ask then, but that question of reliance, is that specified in that understanding?
It's not mentioned in the memorandum, no. I think that was just an implicit assumption that we were making at that point.
would it be helpful to have that in there just to clarify for all the parties how that will operate?
Going forward, yes, I think that's something that we should definitely address in the new relationship agreement should a consent be granted.
You might come back to that memorandum.
Yeah. Thank you. Unless you need me to, I'm not actually going to speak any further to that section, and I'll move on to section or paragraph 27 through to 36, where I talk about the Reserves Act authorisation. And really that's the other half, I guess, of this argument, that this is an activity which is a joint activity, and so this is the department acting under its standard powers to take this activity to manage the lagoon in a way which is for necessary or desirable for its proper and beneficial management, control and administration. So from the department's perspective, this is actually BAU. We don't give ourselves authorisations to do our activities, we rely on our powers. And we say that that also applies here. And I have to say that that was perhaps a light bulb moment for myself not that long ago, but I think because we've been so used to other people holding consents to open the lagoon that we were in the habit of thinking that an authorisation was required, and we've gone, no, it's us together with, we don't need that.
Mr. Chairman, just following up, perhaps we'll enter into just some follow-up questions, might be easier to clarify. But my understanding is in the communication implementation plan, there is a 0.8. There is a requirement to seek that authorisation.
Yes. So I'm saying that that's actually not required, and that should come out.
That should be removed.
It's not necessary.
Right. And again, just coming back.
No, fair enough.
Coming back to that memorandum understanding, would something like that be specified in that understanding?
It certainly will, again, in the memorandum in the relationship agreement going forward. And I'm calling it a relationship agreement because, of course, one of the things with the memorandum is that a memorandum is not necessarily legally binding. I think going forward, the intention is that there will be something that's robust.
Thank you. I mean, I dwell on that because we do have, I'm a bit troubled by the governance structure, I guess, of how this will all play out, and how the consents would be implemented from an accountability point of view.
Yes.
And we've understood there's a communications plan and decision tree, but it's the accountability that is less clear to us.
Fair enough. So next I've moved into, and I have not spent long really on the RMA legal matters because it's covered in the planning evidence in many respects in terms of the Section 104 assessments. So I've highlighted some matters for you here. So I've talked first about the Section 104D test, and that's paragraphs 37 to 42. And Ms. Petricevic and Ms. Thorne are both satisfied that both 104D tests are passed. So both that the adverse effects of the proposal are no more than minor, and also that it's not contrary to the objectives and policies of the relevant plans, and in this case we have both the coastal plan and the water and land plan. So unless you need me to speak further to that, I'm going to move on.
Unless you've read the joint witness statement already, worked out whether there's anything to add.
It might be that once I have read the joint witness statement that I will need to come back to you on that, but certainly that's where the applicant start, is that we don't see we consider those tests are passed.
I do have one question on that, and this question's just in regards or potentially in response to what Federated Farmers evidence is, where they say that the overlapping functions of Environment Southland mean that having activity of flood protection has a targeted rate actually does have relevance to the Section 104 gateway test. And so what would is it relevant that Environment Southland's overlapping functions, is that relevant to the gateway test in terms of the objectives and policies? Is there any breach?
So, and my very brief submission, because I am not a local authority lawyer, is that I don't believe that it is. that might be something which you might be better wanting to ask Mr. Duisberg through Ms. Petricevic to address, but I don't consider it is, because that is actually a local authority, local government matter, and I don't believe it's a matter which you should be having to address as part of this process in this application. So then moving on to these, oh sorry, no.
Called that, thank you.
So moving on to my next section, which talks about existing environment, and that's paragraphs 43 to 49. And I referred there to, I guess, the triumvirate of cases about existing environment and identified some principles. So the existing environment includes consented activities that are likely to be implemented, and that's the Hawthorne case law. It does not include the activities sought to be consented, so there's no consent in place. And it does not include water take permits. Not that's so relevant here, but I just wanted to include that. So that's the Port Gore and the Ngāti Rangi cases. What we have here actually is an environment with very little modification. It's natural. There's no activities that require consents currently in place. The activities here are limited to the cultural, the scientific, the restoration, the recreational activities, and those natural processes which impact on the catchment in the lagoon are natural processes. They are not things which someone sort of needs a resource consent because they're going to get the rain to fall. So it doesn't include those previous consents which have all expired. And in my submission, this means that the existing environment is this natural, unmodified state with no consent in place. And I know that that might not be something that many submitters want to hear, but that's in my submission what the law is and what you should be assessing. And again, that is accepted by certainly Ms. Petricevic and Ms. Thorne. Ms. Sanazara may have a different view. Because there is no consent currently in place, that's meant that Environment Southland has had to act twice over the last year to open the lagoon. First there was the opening in January last year and more recently in September. And that's when matters had got to a point where it met those tests under Section 330 of immediate preventive or remedial measures or a sudden event. Now, these were not sudden events because these were building up, so they weren't sudden events, but they were certainly where this had accumulation to a point where immediate action finally had to be taken. Those all took some time. The water quality one, there was discussion happening from before Christmas. It didn't happen until the end of January. The levels, again, discussion was happening from late July, and the opening didn't happen until the end of September. And in my submission, if a consent with the conditions which are sought by the applicants had been in place, in both instances, actually, both things would have occurred earlier. And in fact, an opening would have occurred even before the opening for the water quality, because by the end of 2023, there hadn't been an opening at a time which was suitable for migratory fish for more than 24 months. And so actually there would have needed to be an opening before that for fish passage in any event. So those openings did respond to exactly the matters which the applicants want to manage the lagoon opening regime for. I'm just touching very briefly, if you have no questions about that.
I have a question
Yep.
just on that, and again, it comes back to the federated farmer position. And so what they're saying, or what I understand the evidence says, is that when it comes to flood control, there's no, that the Environment Southland or all of the applicants, whoever it is, does need some type of legal mechanism to be able to open the lake, and not just for emergency powers, but because this application is not specifically framed up as for flood control, then how relevant is that concern to the proposal for us?
It's the very short answer to that. We do not have structures which control the lagoon levels here. We do not have control gates. So, for example, Whangamarino in the Waikato has control gates which manage the water levels there for that which is another Ramsar site. We have none of that here. So the lagoon will either open because the pressure has built up sufficiently that it will breach, or because coming the other way from Te Ara-Akiwa, there's been a storm surge, which means that it breaches. That's the only way, naturally, that the lagoon will open. Otherwise, it requires somebody, these applicants, to come along with some mechanical devices to open the lagoon. I think one of the submitters suggested that there could be pipes put through underneath. Yeah, there's none of that in place either. So from your perspective, no, that's not
It's
relevant.
not included, it's not relevant.
What about there's the Waituna Creek has a it's got a flood control
My understanding,
bylaw that applies to it, and it may also be a flood control area because it's identified on a plan, I think in the regional plan, where flood work controls occur there. Is there any linkage between that and the opening of the lagoon?
well, certainly not in terms of this consent application. So this consent application is not intended to address those matters. That again is very much a matter for Environment Southland in terms of what infrastructure it has in Waituna Creek, and I'm going to again defer to Mr. Duisberg to perhaps come back to you on that.
So we'll just have a follow-up question on that. So my understanding is that's fundamentally what the Federated Farmers evidence is saying, is because there's that flood infrastructure in that particular waterway, that it's a different regulation under the NES, and your position is it's irrelevant. Therefore, you are applying the right regulation.
Yes. And that's also because, again, there's this argument that somehow we need to use the wetland delineation tool to delineate the lagoon as a wetland. Wetland, as defined in the RMA, includes a permanently shallow body of water, which is what the lagoon is. I think if you go to the wetland delineation tool, and I'm not an expert in that, but it talks about a wetland which supports an assemblage of plants. Well, that's exactly what this application is trying to do, is to have a consent regime in place which supports the assemblage of plants, which then support the ecosystem and the habitat, and will restore hauora, cultural health, all of those things. So that's the purpose of this application. I'm a little bit bemused, frankly, by the wetland argument.
Thank you.
Moving on to Te Mana o Te Wai, and sorry, just let you get your note.
Thank you.
Thank you. So moving on to where my next section, where I very briefly discuss Te Mana o Te Wai in the context of the Southland Water and Land Plan. And the Southland Water and Land Plan, of course, it's the version of Te Mana o Te Wai that is applied in the objectives of the plan is the 2017 version, and that's from the 2017 amended version of the NPS. So that does not have the hierarchy of obligations. So acknowledge that for the purposes of resource consents, the hierarchy of obligations no longer applies because of section 104.2F, but because of the history of the development of the Water and Land Plan, it's not perhaps as relevant here in any event. I have set out some passages from the 2019 Court's interim decision, and I'm not going to go through those. And just note also that we do have, what I will say is that in the Court's decision it talks about objectives 1 and 3. In the version of the plan that is now partially operative, those are actually objectives 1 and 2, and there's an interpretation statement which I do draw your attention to as well. But just coming to so in the
objectives 1 and 2.
So in the Court's decision, in the decisions version, these were objectives 1 and 3. In the partially operative version, those are objectives 1 and 2. I just wanted to clarify that. And in the preamble actually is very important here, because what that says is that Te Mana o Te Wai, the concept, is fundamental to the integrated framework for freshwater management for Southland, provides a way of expressing Southland's aspirations for freshwater mai Māori now and into the future. And that, in my submission, is again highly significant for this application, which is part of this, again, applying that ki uta ki tai approach. These other actions are driven through the Water and Land Plan to manage the catchment impact on mai Māori, and this is then managing the receiving environment.
So that's in the preamble to the
Water and Land Plan.
Right. So, and the statutory relevance of the preamble compared to the actual objectives and policies?
It's simply a kind of, I guess I grabbed it as a nice snapshot of a statement about Te Mana o Te Wai, but obviously the objectives and policies are the operative provisions which you should be having regard to. So again, this is about restoring the haora, the Māori of the Wai, the mana of Waituna, and preserving the balance between Waituna, the water body, and this wider environment. I acknowledge again that the hierarchy of obligations no longer applies, but those objectives in the Water and Land Plan still direct you to have regard to haora of the Wai, haora of the people, haora of the community, haora of the environment. Also acknowledge that there is the current freshwater package and other packages out for consultation, and I just remind you, which I don't really need to, that we've had that confirmation recently from that Box property case that the law you apply is the law that is today. And then my last section, really just covering off legal matters in terms of the application is, sorry,
carry on. I think you're legal. That's all right.
No, it's just about this question of, is it a regionally significant water wetland or a sensitive water body? And what I've set out there is actually Waituna is both. And it's the only water body that I could see in the Appendix A list, which is mentioned in both lists, but it is mentioned in both lists. So in my submission, it's both a regionally significant wetland and a sensitive water body. And in terms of what difference does that make, actually it makes no difference, because they flows through into policy 16, which is about managing farming activities that could impact on water quality. And then there's a suite of rules sitting underneath that which implement policy 16 in terms of particularly more intensive farming activities and requiring greater setbacks from both sensitive water bodies. And I'm not saying that Waituna gets a double setback, because it doesn't, but it gets the same setback.
That's in Appendix A, listed as a sensitive water body in Southland,
Yes.
and
Appendix A is both.
regionally significant.
That's in both. And I think on the beacon maps, it was perhaps only showing as a sensitive water body, but it's actually recorded as both. Moving on
Yep.
to submitted concerns, and I'm just wondering, perhaps if I go into that, it's 10:10, is now a good time perhaps to take a break?
I just have one question.
Oh, sorry, go for it.
Sorry, I just had one question on that. You mentioned, so you have said that because it's either one or the other or both, the sensitive regionally significant wetland or sensitive water body, that it triggers land use restrictions, and you mentioned setbacks, and I just wanted to understand, was outside of setbacks, are there other limits around intensification or prohibiting certain types of farming activities around the lagoon? Like what other restrictions are there?
I guess from my perspective, because actually the setbacks are still there relatively small, I think it's 10 metres. So other than potentially the small bit of private land on the bar, I don't think there's any private activities which would be close enough to the lagoon to trigger those setback rules in any event, because
And it doesn't, the land and water plan doesn't limit things like intensification.
it does limit intensification. So one of the things that the land and water plan does is for new dairy intensification that has to essentially show that it would result in a reduced output, if I put it that way, but that's not relevant to this application
because it's not specific to a sensitive
No.
Water
No.
body.
Yes, so there's a suite of rules around, for example, sacrifice paddocks, pasture-based wintering. Oh gosh, what's that other one? I can't. Yeah. So there's a suite of rules and controls around those matters. There's actually a rule that's still under appeal about modified watercourse maintenance, which I'm having another meeting with people on Friday. So yes, there's a whole heap of rules in there which are intended to drive better behaviour.
You also talk about the farm management plans and having the certified farm management plans, and I wanted to understand how enforceable are they, and so do they bring in binding requirements on things like nutrient caps?
So the farm environmental management plans that were originally should have been in place did not come in because there's been wars on that. There's freshwater farm plans that are, as I understand it, still due to come in, I think, by mid next year. The way those will work is that there will be, I guess, controls in place. Whether they actually have nutrient caps, I don't think they do. I think we've moved away from using overseer, partly because we're not sure that overseer is such a reliable tool. And so that's not the approach that is taken here. It's more that the intention is that the contribution and changes in farm practice should mean that nutrient loads are reduced. Yeah, we now have got to 10:15, and so I'm wondering if now is a good time to take a break.
Take them on your adjournments and reconvene at 10:30. Thank you.
Thank you.
Yeah, I know.
We'll reconvene the hearing. So either the acoustics are not that good, or that we're not speaking loud enough. Thank you for those in the gallery for pointing that out. Ms. Williams, could you please speak up, and also because you're facing away from everybody else?
Yes.
Yeah, thank you.
Yes, I understand that. So I will attempt to speak up and hopefully be able to be heard better at the back of the room.
Yes, thank you.
Excellent. Okay, so moving into submitters' concerns,
What paragraph number are you at?
I might start with the consent water level open threshold, so that's at paragraph 64. So many submitters oppose the proposed water level regime, most seeking that the lagoon be opened at 2.2 metres or lower. I will just note in passing that actually the submission from the Royal Forest and Bird Society wanted us to accelerate and move quicker, but most did seek a lower water level trigger, and many also tied that to having a 5-year consent and opposed the 20-year term which is sought, as well as having a, once it hits X level, thou must open it. So from the applicant's perspective, submitters say that they're concerned that there will be a detrimental impact on the lagoon. The applicants consider that that is not the case, that the consent sought together with the monitoring regime and the other matters that are put in place, including the other triggers for water quality and fish passage, will address environmental impacts. So that's the intention around having those suite of triggers to open the lagoon. There's been that comprehensive technical assessment, which I've already talked to develop this transitional regime, stepping it over 20 years. And in response to some of those concerns, as I say, the applicants have introduced this interim step at years 6 to 10 and lowered the summer level for years 1 to 5. And there's the assessment about what that means, which is in that further response, which came in, I think, in the June, further information from the applicant. And I think Dr. Robertson discusses that also in his evidence. So that's what is proposed by the applicants. It is intended to provide the opportunity for the lagoon to adjust. It's also intended to provide the opportunity, by having this staged transitional regime over 20 years, to allow others in that surrounding environment to adjust as well. So that is the purpose of having those stages. I've referred to the evidence of Dr. Robertson about the 2.4 not being the optimal level ultimately, and that's why we have remained at 2.5 as the optimal level, which is sought for that last stage of the consents. I've already talked about the stages. I'm not going to talk to those again. Nā kōtona, the applicants, we acknowledge that submitters still do not agree with this proposed water level trigger. The applicants have taken expert advice in putting forward this regime, and they are also seeking a 5-yearly review condition, and that's in addition to the standard ability for councils to trigger review under sections 128 and 129 of the RMA. And so that provides that opportunity to assess, to see if what has been achieved is what was intended, whether there are some unanticipated effects which need to be addressed going forward. So that 5-yearly review is also really important in ensuring that we are achieving this aspiration of achieving Awarua for Waituna, improving its cultural and ecological health. Moving now to paragraph 75 and the hydrological modelling used in the application.
So just before you get back to 72, when it says in the different A to D, And it talks about for 3 consecutive days or 7 consecutive days.
Yes.
So from when?
So it's once the level reaches that height. So once the gauge,
24-hour clock.
yes, there's a 24-hour clock on the gauge, and so once the levels hit 2.3 metres for 7 consecutive days on that first trigger, 1B, well 1A2 for the winter opening. So it's the levels are at that or above for that 7 consecutive day period.
Do the conditions tell you that it's a 24-hour period?
I don't think
Or
they do
6 or
say that it's a
7 working days, or
24-hour
is it
period, but
calendar?
it's understood. So it's literally, so if it hits that level at 10:35 a.m. on the 29th of July and remains at that level or higher until 10:35 a.m. I'm having to count days now, Wednesday, Thursday, Friday, on Friday, the 1st of August, then that would trigger that summer opening. So that's the intention of that.
You're going to put forward conditions and they should probably reflect that.
I'm sure that there can be amendments made to reflect that.
Can I follow up? Just turning to paragraph 74, they're seeking a 5-year review condition to assure that it's the best pathway. What's your expectation that would happen if it wasn't showing it was the best pathway? Would that be some amendments to either the triggers or the levels? What would happen in your mind?
In my mind, what would happen is exactly that there would potentially be amendments to the levels and, well, the levels are that trigger, that first trigger, the water level trigger. So essentially it's the same thing. And it might be that it's a duration change. So it might be that there's a concern about it kind of hitting and then bouncing up and down a little, and maybe that's the issue, but not actually staying sustained. Or it might be that it's going up, it's coming back down, it's going back up, and kind of staying for 2.5 days rather than 3. So maybe that's when we would look again. So it might be both the actual level and the duration, and those both would be potentially up for discussion and amendment if that's what the concern is.
So currently there's no mechanism to adapt to a pathway that's not delivering in the consent, or as I understand it, in the monitoring plan. I'm correct in understanding that?
Yes, you are correct in understanding that. So what the application proposes is, as I say, the stages, and it sets what the stages are. And the intention around that, as much as anything else, is to give everybody certainty, because we want people to know what they should expect in terms of that monitoring regime. In our view, actually having a more flexible water level trigger actually becomes problematic as well, because no one knows what to expect when.
But it may play out, of course, just with those submitters' concerns that you've identified, that at a higher level is where the adaptation may be something different and lower even.
We would be surprised on the information we have to date. And we also, the focus of this application is on Waituna and the lagoon. So that's what our focus is, and on what the effects are there. We really do not expect there to need to be a change, but we wanted to build in the opportunity to review to make a change if necessary. But because we do have, as I say, this quite sustained effort of scientific and technical information, we're not anticipating we'll need it, but we should have it there.
Sorry, if the 5 yearly reviews show that something hasn't been met, you're going to change the triggers.
We would look at changing the triggers.
So how are you going to do that?
That's the purpose of having the review in place, to allow the discussion between council as the regulatory authority and the applicants to look at amending the conditions. And that might then...
But under 127, if this was a notified application, you'd have to include all the submitters as well, wouldn't you?
Yes, we would.
So wouldn't you need to apply under 127 to amend the application. So the 5-yearly review would be, you do that and then make a decision on whether you'd need to potentially visit the trigger levels again. That's the intention.
If that's what we have to do, then that's what we'll do. As I say, that's not anticipated, but it's provided for. It's just making sure that the option is there. And again, that's actually in response to concerns of submitters that there was this concern that, and that I think was also why many of the submitters were saying it should only be a 5-year consent. We do want to have this working towards that 20-year consent, but we've built in a process which allows for, if necessary, that trigger to be, or that, sorry, not that trigger's not the right word here, that outcome to be looked at.
If I may, Mr. Chairman. Yes, so what you're saying is if that were the expectation, if that did happen, that we'd be back in this room, perhaps. So it strikes me it might have been an option was to put forward a more adaptive plan which specifies some of that early on, of some indications of amendments that might need to occur, which might avoid that particular event happening. I appreciate that that's uncertainty, but it also provides certainty to a process.
I think that was something that was considered in preparing the application, but as I say, the evidence and the advice has been very strong for some time that 2.5 is where we need to be, and that's the reason for not having perhaps a more flexible, adaptive process.
Of course, the adaptation may be on the triggers, not necessarily the level, but thank you anyway. I'm sure we'll pursue that questioning with some of the experts.
Thank you. So moving now to paragraph 75 and validation of the hydrological model. And this was a concern that was raised by many submitters about the validity of the model, about the validity of the inundation maps that have been included and provided in the application. And so Mr. Measures was brought in November last year to do that validation of the model and also to provide that, I guess, ground truthing. And at that point, because that was in November, we'd had those elevated levels over winter last year. So there was drone footage that Environment Southland had showing where water levels were, and Mr. Measures was able to, it's a great name, he was able to measure the and compare the actual event with what had been modelled, and his view was that the model held up very well. A couple of factors that he did note were sources of uncertainty, and that's around the gravel barrier seepage percolation rate. And that's something which it looked like there had been a change last year around the barrier seepage rate. So I think if you go onto the Environment Southland website, it's still showing, I think, 4 or 5 different potential lines which the lagoon could follow depending on, and in part those uncertainties arise because of this uncertainty around the barrier seepage rate. The expectation again is that that will refine itself as the because it's live monitoring that's happening all the time, and that there will be better information, and that will then inform the model, which will mean that the model will be more accurate going forward. And then the other thing is climate change, which is a factor of life for all of us. Mr. Measures' view is actually those are factors which are uncertainties, whatever happens, whether there's a lagoon opening regime consent in place, whether there isn't a lagoon opening regime consent in place. And so he's assessed those essentially as neutral to the application. And again, there was a submitter who helpfully did acknowledge that the water in Waituna comes from up catchment. It's the rainfall, the meteorological events. Last winter, spring, Southland had a very wet winter spring. And that did mean that water levels everywhere, not just in Waituna, were high. But that is a natural occurrence, and in terms of water levels, that is something which the proposed consent would address. And for that reason, we do have confidence in the hydrological models, and of course you're going to hear from Mr. Measures later today. So moving now to the water quality concerns, and that's at paragraph 81. Again, many submitters had concerns about water quality. There was the suggestion that the lagoon needed to be opened annually to flush the nutrient inputs. So again, I come back to the purpose of the Southland Water and Land Plan actually being to drive improvement in catchment practices to reduce nutrient inputs. It might not be happening perhaps at the rate which was initially intended under the Water and Land Plan, but it is still intended that that should happen. And that should in itself reduce the inputs for the lagoon and reduce the need for these openings. Again, Mr. Rebel's evidence assesses that, and we've got these parameters around water quality triggers. So we've got chlorophyll A, these primary indicators, chlorophyll A, and I'm on paragraph 84, cyanobacterial biovolume and bottom water dissolved oxygen. Those are directly linked to water quality. Then there's also some secondary indicators providing early warning around total phosphorus, total nitrogen, water clarity. So Mr. Rebel's evidence assesses those indicators and the proposed warning and critical levels, because there's two sets of levels set in there for them. And that also runs alongside the monitoring regime. And his assessment is that compared with having no consent in place and frankly having to go to an emergency opening, this consent with a structured monitoring thresholds and having then also the ability to go to a science advisory group to get recommendations is more likely to protect the lagoon health under current and future conditions. And that's also addressed in the evidence of Dr. Schellenberg. Openings are a key mitigation tool for preventing excessive nutrient buildup. And Dr. Schellenberg also acknowledges, however, that frequent openings and prolonged low water will have negative consequences for other water values, other lagoon values, sorry. And he supports the proposed water quality triggers to safeguard the water quality and ecological health of the lagoon, providing that mechanism to avert potential adverse effects due to elevated nutrient concentrations.
Paragraph 82, with the reference to certified farm plans by 2026.
Yes.
Sorry, the footnote, Southland farm plans dash.
Sorry.
Sorry, I don't know what it is.
Yeah, no, that's fair enough. So it hasn't shown up properly in the footnote, but it's from the Southland website, which talks about having to have certified freshwater plans in place and provides guidance to farmers on how they should go about doing that. It also, I think, steps through the certification process.
By 2026.
Yes,
Particular day?
I think it was mid-2026, is my recollection. I think it was June.
And that's all set out in the Southland plan.
It's a combination of the Water and Land Plan and the freshwater farm regs, because actually the plans were due to come in and then there was an amendment so that they didn't come in last year.
Yep, thank you.
Turning now to fish passage concerns, so I'm at paragraph 87. A number of submitters had concerns about diadromous fish passage being impeded, and I use diadromous deliberately here because they're going between the marine environment and the freshwater Y environment, and whether that was impeded by the proposed open lagoon. And so this is where Dr. Holmes' evidence is very important. So we have, as I've discussed, the third condition around openings for fish passage every 24 months. And that's even if there has been an opening within that 24-month period, but it has not been at a point which has been suitable for those migratory fish species, diadromous fish species. The focus is on threatened or at-risk native species. There are trout in the catchment. It's a regionally significant trout fishery. The trout will be fine with what's proposed. They will benefit from it, but they're not the species which are the focus for the applicants. Dr. Holmes provides comprehensive evidence in support of this condition. He notes in particular the requirements of, and he runs through very helpfully the requirements of different species in the catchment. So for giant kokopu, the Waituna catchment is a stronghold. He discusses smelt, inanga, bullies, banded kokopu, flounder, tuna, longfin and shortfin eels, kanakana and other species, and assesses both the existing environment with no consent in place against having a regime. And his conclusion I've set out at the top of page 21 of my submissions, and I might just leave you to read that. So as stated by Dr. Holmes, the 24-month period proposed for that condition is a balance between the environmental values with the other ecological objectives and cultural objectives for Waituna. And as I've already discussed, it is particularly around having the needs of kanakana lamprey addressed by having a juvenile cohort present. And so in my submission on behalf of Kaitono, the applicants, these concerns are addressed by these conditions and by the monitoring which is proposed. I think there was some questions raised in the technical peer review about fish stranding. Because the intention actually is that we will move to less openings, the applicants would say that there's going to be less issues with fish stranding. The species which were getting stranded are, I think it was the common bullies and others, which are not they're not strong swimmers, basically. And so they won't get away, but they are relatively common, not just common bullies, but they are not at risk, I put it that way. And they're not a conservation concern. Moving then to higher water levels on the fringing vegetation communities, and I'm at paragraph 92. And that again is a concern, I think, which arose particularly because of those elevated levels last year. And it was particularly, there was discussion at the pre-hearing meeting about the Manuka shrublands dieback, which was showing in March when that meeting happened following those levels. And so that's discussed by Dr. Robertson in his evidence, and he's also attached the report of Mr. Blythe from 2013 assessing the vegetation communities around the lagoon. And as I've already said, Dr. Robertson supports having a condition to monitor fringing vegetation with that baseline assessment, really just to get that information, build on Dr. Blythe's information from Mr. Blythe's information from 2013, and then have that repeated at 5-yearly annuals as part of that, 5-yearly periods rather, as part of that review.
How's that reflected in the conditions?
Sorry?
How's that reflected in the conditions?
I think that is, the intention is that this would be part of the monitoring review. So the monitoring and reporting conditions. I'm just trying to find, and the monitoring plan which has been prepared.
So when I look at the conditions, it just says monitoring of fringing vegetation within 6 months.
Yes, so
what
that's
are they monitoring? Doesn't say anything.
right. So that is intended to be the baseline monitoring.
Yeah, how regularly is it, or are you proposing just to do
So-
it in a management plan?
So the baseline monitoring is to occur as set out within 6 months. And then the intention is that the further monitoring in terms of fringing wetlands would occur as part of the monitoring to support the 5-year review.
All of that needs to be specified in the conditions in a far greater detail than the version we have before us.
And I might add in the monitoring plan, where it's not clear.
Yep.
Oh, there is actually.
Yes, there has been a
There is,
monitoring plan prepared. I'm sorry, I can't actually see it in the conditions, but I'm sure it's in here.
It is in the plan, actually, I apologise.
Thank you. So coming back to that, there was a suggestion, I think, to do a 2-year review. The issue with a 2-year review is that actually there may only have been one opening in that time, and the applicants are concerned that it's just not long enough to show a change, which is why we would prefer that to be as part of the 5-year reviews. Moving now to rupia and the importance of rupia as an indicator of ecological health, at paragraph 96. So submitters have concerns about rupia, which has sensitivity to light levels, and that's discussed in the evidence of Ms. De Winton, who confirms that rupia is a keystone for Waituna. It's unusual for a coastal lagoon to still have this rupia plant assemblage domination as we do have in Waituna. And that is typical, and it's historically of coastal lagoons. It's been lost elsewhere. It's important to retain it here. So there's been annual monitoring since 2009, and I understand that actually the 2025 survey report has just been released, so I will make sure that that comes to you. That shows that sequence of monitoring that's been happening across the plots, which are shown by Ms. De Winton in her evidence annually since 2009. So now we have 16 years of surveys showing us rupia.
Will that be continued?
Yes.
Under the consent? Is it in the conditions?
I don't know that it's in the conditions because I think it's actually something that the department intends to continue anyway. But it can be
If
put
the
into
department
conditions.
changes its mind, we might reach a different view as to that. So my question is should it be in the conditions?
Potentially it should. There were concerns that the higher levels would mean that rupia would basically suffer because it is photosensitive. However, if it's well established, Ms. De Winton's evidence is that rupia can manage for up to 4 months. So I think she says 1 to 4 months with higher levels. And that's because it's already grown. So actually the top of the rupia is within the distance from the surface of the water to still receive the light that it needs. And I can see Mr. Boothroyd nodding with me, which is great. So that's good. Good to know the lawyer can get this right, because I'm not a scientist. Ms. De Winton also talks about the opening locations, and again, historically, rupia has been more prevalent in the eastern ends of the lagoon, and that's one of the reasons why the applicants would prefer to have openings at the western end at Walker's Bay, which you've visited, and that's because it means that there is that less disturbance to rupia. And in addition, of course, there's the importance of the water quality condition here for rupia survival as well, because macroalgae and phytoplankton blooms are not good for rupia because, again, they block the light. They're also going to reduce the level of oxygen. So that's another crucial condition actually for the health of rupia. So unless you have any questions, I'm going to move on. Okay. Pest waterfowl, the big birds, Canada geese and swans. So a number of submitters have raised concerns about waterfowl, these what I'm calling pest waterfowl, so Canada geese and swans, and that if the lagoon is higher, I guess the surface is bigger, that will attract these birds, and it causes damage to their properties. And so again, this is a matter which is actually, it's not like the applicants kind of go, do the duck call to bring them in. We don't do that. They just come when they come. These are birds which, as Mr. Jacques has said, they're opportunistic. They will go where they go. What I have set out here in the submissions are actually that there are options to control. So black swans are game birds. The hunting season finished on the 13th of July this year, but during the season you have the ability to shoot swans. And I did note when I was checking the hunting regulations for the season that Fish and Game encourage people to take 5 because there's plenty of them. They're in a healthy population. They also mentioned Canada geese as being a valued bird that could be hunted as part of the hunting season. Outside the game bird season, there are options that people have in terms of seeking an authority to control black swans, that's game birds, where these are causing damage to stock or crops or land, or it's likely that that could arise through the presence of those birds. And that then is an authority which, if granted, is held by the landowner but can be exercised by any employee or contractor acting on their behalf on their land. Canada geese are no longer protected. That change was made in 2011. And what that means is that actually you can control Canada geese at any time. You just have to do so in a way which is humane. Moving now to other avifauna, so I'm at paragraph 110. That's the evidence of Mr. Jacques, who sets out and discusses the bird communities of the lagoon, because there are submitters that are concerned, and I think the concern is primarily around the wading birds. And that perhaps is where it's also relevant that the Ramsar site that was originally gazetted was expanded in 2006 to include Awarua Bay to the west, Toitoi's estuary to the east, and the New River estuary as part of the Ramsar site as well. So those are all areas, if I put it that way, which provide wading bird habitat. And so Mr. Jacques' conclusion is that ultimately the lagoon opening regime is neutral for those birds. They're going to go where the habitat is. It's not that far away, and they will be satisfied. There were also some concerns around, in the technical review, around the swamp bird breeding. And again, Mr. Jacques' assessment is that actually, because ultimately we're probably going to create more swamp-like habitat, that this would be better for those birds as well. And built into the triggers, if I come back to the triggers, we do have that additional change which has come into both 5B and 6C, which is around receiving not just relevant scientific information, but considering the habitat for threatened and at-risk bird species during critical life stages. And that's particularly around bittern and bitterns breeding season, which starts October, November, and just making sure that that is considered when we're looking at an opening for those fish passage and water quality purposes. Moving on now to access concerns, and I'm at paragraph 113 and not that far from the end. So there's concerns about access to the dock recreational assets, that's the lookout, the loop track, the car park, etc. over Waghorn Road Bridge, Waghorn Road Bridge itself, and there's the small plot of land on the barrier bar, which you can see in the map here, and whether there was access provided for that. And so our submission is that actually the modelling suggests that yes, there will be restrictions on access to those places. I've had a go at working out what I think the probabilities are, and it seemed to indicate to me that there was still potentially likely to be an opening annually, and potentially not an opening, the levels could be at a point where access over Waghorn Road would be impeded every year, and potentially for a number of days at a time. So yeah, Southland District Council have submitted, and I see that they are due to present, I think, Thursday. So I'm not going to speak further about Waghorn Road and the road infrastructure. That's a matter for the District Council to address. From the department's perspective, there are many places which, for various reasons, people do not have access to 24/7, 365 days of the year. Waituna is no different, and that's something that we will manage. In terms of Te Waipareira Trust, which now owns the other land that is accessed across the road, it's discussed in Mr. Whanga's evidence and also in their submission that they are comfortable that this is part of that natural restoration, which they intend anyway, as part of Piki Raurahi Mahinga Kai Pa developing that. So that's where that sits. And that's further discussed in the evidence of Mr. Erie, whom again you're going to hear from later today. So moving to consultation and working with the community in the future, I'm at para 123. Many submitters have concerns about the consultation and what the place of the community is under the proposed consent. And we had a robust discussion about that at the pre-hearing meeting back in March. So one of the concerns that submitters had was that if the Science Advisory Group was only made up of people that were appointed by the applicants, even though those experts should be independent, that there would somehow be, I suppose, an influence. And so one of the things that the applicants have agreed to is to have an independent chair. So that's someone who will not be employed by any of the applicants. In the application as initially filed, I think there was a proposal to have a representative of the Lake Waituna Control Association, and Mr. Piri is here today. So Lake Waituna Control Association is the organisation which has held the most recent consents to open the lagoon, and that was why that condition was put in place, was actually because they do have and do hold expertise around opening the lagoon. My understanding, and it might be that Mr. Piri can address this more, but my understanding is that the purpose of the association was actually around holding a consent. Because the association no longer holds a consent, they're not meeting very often anymore. And so as a replacement for the LWCA representative, we proposed instead the catchment community can put forward someone. They still need to be suitably qualified because we want whoever is on that science advisory group to have the requisite and appropriate skills and knowledge to make appropriate recommendations. But that's something which also has been put forward in addition to having an independent chair, and that means that the community can know that there is another person in addition to the chair who is there sitting on that science advisory group and providing that advice and recommendations to the consent holders, which comes back to particularly conditions 5 and 6 around the water quality and fish passage. And so that's those aspects, and there's also, and this is in the draft proposed conditions, Appendix 1B, the community management plan, and that's something that was worked on with community representatives after that pre-hearing meeting to get consensus upon what would be helpful information, helpful ways to provide that information to the community. And that's something that is going to be and is proposed to be funded by the applicants on an ongoing basis, just to make sure that people are aware of what is happening and can see that information and know what's to happen. And that brings me to the conclusion of my legal submissions. So unless you have any questions.
Yep, I probably do. So,
Yep.
Commissioner Mackay.
I do have a few questions.
Sure.
The first one is quite an overarching question, and what through all the evidence has been quite challenging to clearly see is who is ultimately responsible for delivering and overseeing the activities that are proposed,
Mhm.
and how those arrangements will function over the course of the consent period if it's granted. And so what would be really helpful to understand is the relationship between whakamana or Te Waituna Trust and Te Waiparira Trust, how it all kind of knits together. Is there a governance framework
So
sitting below that? So just so I give you the context, sitting below that, is there an operational framework as well? So quite often you might see something like a joint officials group or a technical advisory group. And then what are the legal and governance arrangements that pull it all together? And how do those arrangements then impact on this particular consent? And if there's a diagram anywhere that shows it all, it would be really helpful as well.
don't have a diagram. Can pull that together. I think that probably is something that I might want to address in the right of reply, just to make sure that I'm not just speaking off the cuff if I say put it that way, because I need to make sure that I have, and I am certain I do have my parties, but you're asking for a level of detail that I don't think we've thought through as yet, so we need to do that properly. The intention is that it will be jointly held, so if there is an issue with the consents, it would be all three, which would potentially be up for some kind of compliance enforcement action. The intention in terms of how the activity would be undertaken is that we would work together. Probably we would be using the respective skills and expertise of each organisation. So I think the physical activity of opening the lagoon would probably be undertaken by Environment Southland with assistance from the department and Awarua.
Do they have their own diggers and what have you, or is it contracted out? How
I think it would be contractors, but I'm sure that they will correct me on that. But that's because Environment Southland actually holds that expertise, but it's something that then would be done, as I say, in conjunction with the department and with Awarua, to make sure that it's done in a culturally appropriate way as much as anything else. In terms of receiving the advice, I've already talked about the Science Advisory Group, and that, I guess, is an entity which is intended to really be a resource which is available on call, if I put it that way. So my expectation is that, particularly around the water quality triggers, that it would be, we've got the ongoing monitoring, which is actually being undertaken by all of the joint applicants. So as I said, the Rūpia DOC is responsible for the Rūpia monitoring. Other aspects, Environment Southland is responsible. We're working together on that, on those monitoring matters. We're already doing it. Potentially not quite at the level that we need for the consents, but that is ongoing work. Similarly with Awarua, in terms of cultural indicators of health, that's something that is ongoing. And that then would mean that, as I say, when those warning or critical levels are getting close to, that's when you would invoke the Science Advisory Group to say things are not looking great.
And look, I see that part. The part that is challenging is we've got some submitters who have criticised the ability to work together and the ability to work together well. And it might be a question that Mr. Whanga might be able to answer, but that's to say, has the whakamana to Waituna arrangement, is that working, is an example of it working, and how would that existing arrangements, which the evidence suggests have been in place for some time, shows how it can continue to work.
Yeah.
So that's really the purpose of the question.
Yeah.
And then the second part, because then when it took, so some of the criticism has been from submitters has been around the delay in the emergency opening, and quite a bit of that has been landed on the department.
Yes.
And I wanted to understand, was the department, was there some issues with how the department was responding?
So that was, as I say, I mean, the department does not have that ability to do the emergency opening. It is a matter for Environment Southland under Section 330. So the department and Environment Southland certainly were talking. The Science Advisory Group that we've had a lot of evidence from, they were meeting, including with Mr. Rebel and other scientists from Environment Southland, to discuss what was happening. That was happening, I think, pretty frequently leading up to both of those openings. I can tell you that the department turned around the authorisations in no time, so that they were in place and ready to go, including providing an authority to actually close public access to the bar because there was the concern about safety whilst the operation was underway. So that the department, the criticism of the department as being somehow a barrier is misconceived in my submission.
Okay, thank you. And it would be helpful if there was, if you were able to show some of that arrangements that are in place and have been for some time as an example of working well together.
Yeah.
I only have one.
Sorry, just so in relation to that, you'll address those matters in reply.
I will address that in reply.
Okay, thank you.
I have one question, and it earlier when we were talking about the Federated Farmers submission, there's only one part that I didn't really test with you.
Yeah.
And that is, so my understanding of their submission is that they're saying the FMU planning process sets some tailored rules and limits for Waituna, and that policy 40 of the Southland Land and Water Plan says that if you're going to have a consent, it must match up to those whatever that will look like in the future, because it doesn't exist now. And I want to know what is therefore the relevance of that argument that they're bringing forward to us, and what weight should we give them?
So again, one of the things that the department advocated for, I think it was a fishing game appeal point, was to have Waituna as a separate catchment rather than separate FMU, rather than part of the greater Mataura FMU. So definitely supportive of it being a separate FMU. We have not been through that limit setting process yet. I do not understand how the limit setting process would actually have any impact at all on what is sought in terms of this consent application, particularly around limits for water quality parameters, because that's actually something which is specifically addressed by this consent. And the consent is actually about addressing the impacts for Waituna as the receiving environment of activities which had happened up the catchment. It's those activities up the catchment which are going to be subject to those limits. And in my view, therefore, this means that this is just not relevant to this application process.
Thank you, that's helpful.
Yeah, I've got 2 or 3 questions. Thank you very much, Ms. Williams. How do I start with these ones? My colleague mentioned the kind of governance structure, and one of the things that I would have expected in the conditions, from my experience, is that the decision-making authority or role within each of those three agencies would be named, like expressed.
Yep.
Not as a person's name, but as a role, which
position.
might be some kind of director of some department or something like that. Clear to everybody who is accountable for a decision.
Sure.
As I understand it, once they receive advice from the Science Advisory Group.
Yep.
And again, that might be addressed in reply. So I think that would be helpful. In paragraph 29, you also talk to principles agreed between the consent holders,
Yes.
and I think they're listed in the implementation plan. Are they the same?
So
three principles.
yes, so that collaboration, trust, and collective integrated decision making. Those are very much core principles which we have been operating under for some time, and that intention is that would absolutely continue going forwards.
Thank you. And again, whilst they're in the implementation plan, that's helpful. Would they be in this relationship agreement as well? Just to
yes, so they're in the
reinforce
current relationship
Thank you.
agreement,
Yes.
and the intention would be that they carry over to the next relationship agreement.
Thank you. And I think it's in paragraph 8, and this is just to clarify. I think the words are used, applicants are members of the Lagoon Technical Advisory Group, also known as the Science Advisory Group.
Yes.
I just want to clarify whether there's two entities exist or there is one single group.
So I think what happened was that initially it was a technical group. And for example, I think there's reference at some point to the technical review of conditions and things. That has morphed. It's the same entity. It's not a formalised entity, and that's discussed a little bit more in Dr. Robertson's evidence. So the Science Advisory Group going forward in terms of the conditions is the Condition Science Advisory Group. So that's the 3 suitably qualified representatives of each of the applicants, together with the independent chair and a suitably qualified representative of the community. So that's what's proposed going forward. What we've had up to now is a collection and assemblage of qualified people who have information, who have knowledge that the applicants and others have relied upon to provide advice and information to support their management of Waituna and also other actions in the catchment. And it's been called at various times a technical advisory group and a science advisory group, but it is the same thing.
Landing as a science advisory group. That's thank you. That's good. 2 more questions. So one, we talked just about, or you emphasised in response to the question by my colleague that the monitoring will be carried out, or different parts of the monitoring will be carried out by each of the 3 agencies.
Yes.
Will the costs of that lie with each of those agencies, or is there another funding body or a rate that's being struck for this?
It certainly won't be a rate. I think the agencies at this stage, there's some sharing of costs and there's some we're bearing our own costs. So for Environment Southland, for example, it's stated the environment monitoring, which will contribute to this. That's actually something that Environment Southland will do anyway. And so Environment Southland will take responsibility for that. I think going forward, and Mr. McCarroll is going to correct me if I'm wrong on this, but the expectation for DOC is that the annual Mrukia surveys will be something that DOC will continue to be responsible for. And then the intention is that some of those additional monitoring programs that are proposed, that will be shared and that will be part of the relationship agreement that will be agreed by the parties should we get consent.
Understood. So that's going to be landed somewhere. I think that's important. And my final question is more of a crystal ball gazing.
Mm-hmm.
If we were of a mind to grant the consent for 20 years, and if everything went, and I'll use the pun, swimmingly, and that the triggers all played out, and the activities in the catchment delivered some improvements to water quality and other matters that have been discussed, what in your mind would happen at the end of those 20 years?
So at the end of those 20 years, we will then have that information in terms of the vegetation, the fringing wetland communities. We will have information about any changes in the fish diversity, fish populations. We will know what's happening with the avifauna. We will know what's happening in terms of the cultural values, Mahinga Kai, and all of those things. And I think the proposal then would actually be, there would be a kōrero, a conversation between the applicants and others to see who would want to take this forward, because ideally we would like it to see it going forward. Because we still have, and I'm interpolating, but because we would still have the need for fish passage, I think we would still be looking at openings happening on a more natural but still facilitated basis every 24 months. I think the 2.5 metres is also, in terms of rupia health, it's probably about as high as is recommended. So, and again, it comes back to we're managing for multiple values here. So I think the intention is that whatever would happen post 20 years would be something similar. I don't think we'd be looking at then transitioning to 2.8. That's not what we are about. What we are about is actually managing for the values, but also the values as hopefully they will be in a way which is optimal. And really the purpose of this consent is to return to as close as we can to a natural regime, but having the ability to respond to and manage those other values in the way which is best for them to achieve that overall goal.
Thank you. I guess I was wondering whether it might even come down. Crystal ball gazing, as I said.
Crystal ball gazing, at this stage the advice is very firm on the 2.5, but crystal ball gazing, I guess we'll see.
Thank you. That's all, Mr. Chairman.
Thank you. I have a couple of questions. For duration, the evidence and also some of us have referred to, some of them are talking about five to 10 years. Is there any case law around duration of consents that you can direct us to?
No, is the short answer to that. It's not something I've looked at. What I can say obviously is that because this involves, even though it's actually a diversion, but it involves a water take. So obviously under the RMA, it's a maximum 35-year consent in terms of water take anyway. This is such a unique proposition that I'm not sure any case law would be particularly helpful.
The land use consent is being referred to in the application. That's section 13 of the RMA. This was a bit of the
because it's the bit of the lake.
Just when I read the application and the evidence and Mr. Winter's reference to preferring opening at Walker's Bay rather than in the application that there are grid coordinate marks on Walker's Bay where it's opening, but there are no coordinates for the other bit.
Yes, and that is simply because those, apart from there was that opening at the fence last year, and I imagine we could provide that, and I'm sure we could also for Hanson's Bay, but the openings have been so rare at those locations that they can be provided.
Okay, so when could you do that?
I will follow up. It might be something I can do before the end of this week. I just need to check.
By when we adjourn on
certainly
Thursday?
Certainly before we adjourn on Thursday. Actually, that was one matter I did want to check was there was the plan or the map which has been prepared which shows certainly the Walkers Bay and also the potential opening sites at Hanson's Bay and the fence, which is over to the side here, and I'm just hoping that you have seen that. I know you had also asked for a cross section. Yes, that's on the floor there.
Right.
Yep. You'd asked for a cross section of a typical opening, and we just don't have that information, and that's simply because Environment Southland has done those 2 openings last year, but we weren't, I guess, thinking about that in terms of, because what I interpolated you meant by a cross section was you were actually looking for the bar comes along, a portion of the bar is dug out, we've got water coming both ways, then the bar continues. That's what I understood.
So it would be a cross section
Yeah.
through the opening.
Yeah, that's
So
what I
that
thought.
you can see which part is like land, section 13, which part is
Yeah.
coastal marine area.
In coastal
and
environment.
something. So,
Yeah.
so just so that everybody knows that the plan Ms Williams is referring to is this one, and it's available for everybody under the map to my left.
Thank you. Yes, so I think we just didn't have that, and so we could provide you a typical cross section of the bar, but not a typical cross section of the bar as opened, which I didn't think was particularly helpful.
So by Thursday, you can supply a map with the specified coordinates for the openings of the other at the other 2 locations.
We will look that up. Thank you.
In the section 42A report, paragraph 1.24, it refers to the Awarua Water Trust versus Meridian Energy case.
Sorry, I now have to find a 42A report in my large bundle of paper. I do have, but I'm just not finding it quite right at the moment. So paragraph, sorry.
1.2.4.
Yep.
It's referring to the Awarua Water Trust versus Meridian Energy case 2005. Yep. Could you provide us with a legal explanation as to that, please?
So my understanding is that what that case says is that the fact that you hold a resource consent doesn't mean you have to actually act under the resource consent. And this is actually coming back to the Hawthorn discussion in terms of existing environment as well. So the existing environment does not include all current resource consents. What it includes are the resource consents that have been acted upon and those which it is likely will be acted upon. And I think this Awarua case is saying something similar. I have to say that I would have to go back and read it, so that might be something I need to just cover off a little further in the right of reply.
And a copy of the case would be helpful as well.
That I can get to you by Thursday, probably tomorrow actually.
If we granted consent, would there be anything, and that consent is in place, would there be anything that would prevent the regional council from applying for a 3:30 emergency opening?
No, there wouldn't, because that's a power that the regional council has in any event. What I would say, however, is that the presence of the consent being in place is that we shouldn't get to the point where a 3:30 would even be an option that we'd be looking at. So the section 330 powers are a little bit like the department's powers. Those are powers that the department has, that the regional council has, irrespective of whether there's a consent in place.
In terms of the Soil Conservation and Rivers Control Act 1941, are any authorities under that required?
I am going to defer again perhaps to Mr. Duisberg on that. I did look at that legislation some time ago. My recollection is that I didn't consider that there was any need for any kind of authorisation, or indeed that it was relevant to this application, but if you have concerns, that might be something that Mr. Duisberg can address.
Mr. Duisberg, no doubt you're keeping a record of all the deferrals. Thank you. In paragraph 9 of your legal submissions, going over to the top of page 5, excuse me, the improving creek bank stabilisation to reduce sediment. What you or one of your witnesses tell us what's happened in relation to that?
That is something that certainly I think Dr. Robertson probably will have some knowledge of that, and potentially also Mr. Rebel. That is part of that longer running, particularly through the Living Waters Fonterra partnership that expired in 2023, which provided funding for some of those works.
As possibly slightly more convoluted question, the applicants applied for the lake lagoon to not be open until 2.5 after a transition. Some of the submitters have suggested that it should be opened at 2.2 or other. If we came to in coming to a decision on the application, is 2.2 the lesser one version within the scope of the application as it's been put to us as a something that could?
No, it is not.
Why not?
And the reason it is not is because the applicants have, as I say, had that technical advice. And that technical advice has actually been in place since, I think, around 2017. And that's particularly Mr. Winton, Dr. Schellenberg, Dr. Robertson, and others will be able to talk to that because they were all people who have been involved with it.
I'm not asking in relation to what the effects or whatever might be. I'm asking whether, in a legal sense, can we go to 2.2? Could if the submitters sought 2.2 as though it is just an issue of a condition of consent, but the applicants applied for 2.5 for the purpose of ecological
restoration
reasons, that sort of thing.
Yes.
Is putting it in 2.2, is that within the scope of the application, or would that be a condition that might frustrate the application? And I'm talking from a legal sense. That's what
absolutely. So yes, sir, I agree with you. From a legal sense, that absolutely.
Sorry, I'm not suggesting anything. I'm asking a question. I don't know. That's why I'm asking.
Okay, so the purpose of the application is to restore the Awarua, the ecological and cultural values of the lagoon, balancing all of these multiple complex factors. From the applicant's perspective, 2.2 was the level that was the last consent. 2.2 was not successful at achieving the outcomes which the applicants seek pushing in a level of 2.2 absolutely would frustrate the purpose of this application and the consent.
Is there case law to say that we can't do that?
I don't know.
Duisburg, yep, you're in attendance, so, the lawyer from Federated Farmers, who I understand is also appearing online. You've got anything to add from a legal perspective as to that question? That would be helpful. Right, I don't have any further questions, thank you. We're now going to start with Mr. Rūnanga as your first witness. As was set out in minute 1, we don't want any of this experts to read their evidence because we've already done that.
Yep.
You're welcome to present us with a short summary. Half an hour is not short. So everybody understands.
It's helpful. I have had a kōrero with all of the experts, so we have addressed minute 1.
And just one sort of pedantic thing. In terms of the experts, as I understand it, work for the Department of Conservation and Environment Southland, while it's worded that they don't speak on behalf of their employer, I'm interested to know, have they the authority from their employer to provide the evidence they're giving, fiduciary duty and all that sort of thing?
Yes, they do. And in each case, again, we've run through with all of the experts, including those employed by the Department Te Papa Atawhai and Environment Southland, that they are still bound. And well, it's not an environment court hearing, but we have directed all of them to the code of conduct and the relevant provisions, and requested that they confirm that they are providing impartial evidence.
Thank you. Thank you for clarifying that.
All good. And what I would actually like to do is I'm going to invite Ms. Hicks and Mr. McCarroll to step back at this point.
Right,
but we will stay with Mr. Whanga as he is the first witness to be called. And
so just some other thing to think about, because we were going to leave the question until we heard from all your experts. There doesn't seem to be a lot in terms of the evidence in regard to the operational matters of how do you get diggers out there. There doesn't seem to be any, no spill management plan that's required as a condition of consent. There's nothing about where minimising disturbance. There's nothing about where you're going to undertake refuelling or anything like that, which we would have anticipated would have been standard in a consent should it be granted in regard to that matters, just in the same way that anyone else extracting gravel from a riverbed or if there are shorebirds present and you're going to dig it up at that time, there must be a protocol for doing that, and that should all be in the conditions of consent, which, as we understand, it's not subject to the joint witness statement. We don't think there are at the moment.
I don't anticipate that either of the joint witness statements would address that unless, as I say, I still haven't seen the planners one. So,
thank you. Welcome. And over to you.
You don't mind if I stand for 1 minute? So that you
No,
know?
not at all.
Tēnā tātou. Kia tika te mea tuatahi mihi atu ki tō tātou kai karakia Mike Trendy tēnei wā, te mata tō tātou hui ki rungi te kupu te atua. Ana hoki, huri ki a koutou, na tipu pai pai, ana he tia mana, mihi atu ki a koe tia mana Mr. St. Clair, tēnā koe. Huri noa ki a koe i te rangatira no taumutu, ōriti te roto o Waihora, ara Wairewa ki tō tātou roto Waituna. Reira mihi atu ki a koe te kaitiake o tō tātou whenua. Ana hoki mihi atu ki a koe te Mr. Commissioner Boothroyd, anei te mihi atu ki a koe. Huri noa te whānau. Kia koutou nā pau wahine, Evelyn, Gail, Louise, ki tai mai wanganui a mātou, he kora wai mō mātou, e puta atu tēnei kōrero o te atua, o te whānau, o Awarua, o te whānau, o nai tahu whānui, nā reira mō tō kora wai ki a au, tēnei wā, mihi atu ki a koutou, huri no. Huri ki te hapore o Waituna i tēnei wā, koe tai mai ki rungi te kaupapa, o oriti te aroha mō tō tātou roto o Waituna i tēnei wā. Ana e tēnā koutou, a tēnā tātou. Thank you very much. It's a privilege to present evidence on behalf of our whānau and my expertise, and just wanted to acknowledge the conversation you had just then, Kia mana, about the authority that allows myself to speak as an expert evidence, and that we have our rangatira here and behind me as a kora wai to that have passed on their knowledge mātara and our tūpuna. We call that taonga tuku ihu. So I'd just like to acknowledge that.
So Mr. Whanga, perhaps if I can just turn you to your evidence, which is dated the 11th of July. And so your name is Ben Tyler, which you have told us, and you've already provided some explanation about who you are, where you come from, your rangatira. You're employed by Te Ao Marama as the Kaipakahaere Kaipapataio, and you are an active member of Te Rūnanga o Awarua, and paragraphs 3 to 7 of your evidence set out a little bit more about the various roles and knowledge, maturanga, that you hold. And I'm going to also just quickly move to paragraph 13, and what we've set out here, and I just want to acknowledge that it does say impartially, but actually impartially does not apply for Mr. Whanga.
No.
So
Understand. Yeah, thank you.
Just to clarify, but in this role, he is here as a maturanga expert and not as a representative of the applicants. And I will then leave it to Mr. Whanga to perhaps take you through a short summary and then answer questions.
Thank you. Okay, I'd just like to read paragraph 1, 2 and 3.
Sure.
The Waituna Lagoon is unique and a vital part of Murihuku. It nourishes the health of our whānau and communities, the environment, economy and the quality of life. For generations, Kaitahu whānau have used the resources of the Waituna catchment in ways that sustain the mauri of its ecosystems. This evidence outlines the deep cultural, spiritual and ecological significance of Waituna Lagoon to mana whenua, highlights the mātauranga that underpins our relationships with this place. This evidence sets out from a cultural perspective why the proposed application helps achieve the cultural aspirations and restoration of the mana and the mauri of the lagoon and its hauora. This evidence emphasises the importance of an opening regime that is more natural and that supports both ecological and cultural health, and that anything less than this will have impacts on cultural values. So I'm happy to take questions.
Thank you.
Great. Kia ora, and thank you for that acknowledgement, and I do the same from Taumatu back to you and your rangatira in the room. Because your evidence is quite thorough, I've got quite a lot of questions. So I'm just going to start there. The very first question is the question that I asked to Ms. Williams, which is about really understanding how whakamana te Waituna currently works, how it knits in with Te Wai Parira Trust. What is the governance structure? What does it look like in an operational sense? And therefore, how will it connect into this consent? Or are they actually completely separate?
A little bit separate. Yeah, they've got separate. However, the Whakamana Te Waituna partners have been a past co-chair of that and set up to form leaders of their prospective organisations to undertake some the mahi that was required in the lagoon from Q to Kitai from the top of the catchment down to the bottom to help achieve some environmental outcomes and cultural outcomes that the partners and the communities were seeking in terms of the well-being and the concerns that were being discussed at the time around the Waituna. So that was, and the Whakamana Te Waituna set up to also support an application to the Freshwater Improvement Fund. That being successful after all parties had contributed to that, that was used to sort of undertake a program of work. Where the Te Wai Parira Trust comes into the equation is that they are a group that presently made up of Rūnanga members and an independent member. It's a trust that is a land holding trust for the property that's been referred to as Pikirodahi, or the Mahinga Kai Pa. That is all our parties, as I said, contributed in various financial contributions into the Freshwater Improvement Fund. And that was used to purchase properties as one part of the project that could alleviate some of those concerns around hydrological levels. That was one part of the mahi. There's a whole lot of other mahi that happened within the catchment, but other projects, but that was one of the outcomes for iwi, was to get that reconnection back to a significant statutory acknowledgement area where we were unable to access our mahinga kai due to scientific reserve status over the top of the lagoon. So some of those traditional foods had been, we haven't had access to the traditional way that we would have in the past. We didn't own any properties around the outside of the lagoon. So our input into the project as such, we become a landholder, and now we can undertake those values that have been very important to us, and Mahinga Kai reconnection being the biggest outcome for us.
Great, and we did go to the site yesterday, so we had a look at where the Mahinga Kai current existing site is.
Yep.
And it's good to get an understanding that this is like the land ownership arm. And so if that's the case, then is the aspirations or anything that's actually moving and in train to get back any other land parcels that, because it's so far in train, we need to take into account for this?
I think you would have read maybe it's about this quarter-wide concept right from the very start. Well, it's a more natural functioning system, and potentially the borders or the adjacent land next to the lagoon would be quite valuable in terms of owning to make that connection. So that's back. Can you just repeat the question again? Sorry.
So you said there's an aspiration to own all lakeside.
Yeah.
Are there any negotiations that have taken, like, that we should be considering that are so far along that we should take them into account in our decision?
I think probably the whakamana to Tuna partners do see that as part of ongoing negotiations. If there's any land that's coming up for sale, that we would look at ways of trying to purchase those properties, or any land or that comes up to achieve the ultimate outcomes of a quarter wide. Whether that's there are properties here that have there are properties here that would be valuable in terms of the wider quarter wide if they come up for sale.
And
would perform that purpose that we're.
So one of the
Interested
things that I'll be asking the submitters as they come up is to point out their properties, tell us if it's owned, tell us if it's leased, when the lease expires, is there any discussion for that's already taking place to actually bring together that overarching aspiration. And so that was the purpose of my question to you, because I'm going to be asking each of them as they come up as well. And particularly around the leasing part of it, because that seems to me might be part of the more of the opportunity from what I'm reading through the evidence that you've presented.
Yeah, well, the leasing side of it's probably a better question, probably for environment itself, and I believe the ones you might be referring to in terms of lease land.
Yeah, that's really helpful. And the submitters themselves, what their plans are. The next question, you did touch on it. You've talked about how Mahinga Kai practices have been, because of the scientific reserve, somehow there's been a disconnect with ability to practice Mahinga Kai. And I wanted to know why does the science reserve do that, and how has it done it, and how has it impacted and been made out in practice?
I suppose it's some of the species that we would traditionally want to harvest inside, you aren't able to harvest inside of that a scientific reserve, like tuna, for instance. So generally, those Tonga species, because of the scientific reserve designation, we were unable to harvest. So there's that disconnect. We haven't been able to do that.
Okay. Right, okay, no, I understand that, and I was trying to understand what connection that would actually have to whether or not we grant an opening of consent, but effectively that's still going to remain, so it doesn't actually have that doesn't change your ability to harvest more Mahinga Kai on the site. Okay, thank you. So now in paragraph 38 of your evidence, you outline some core values that are important from a Te Ao Māori and Mana Whenua perspective. And there are a couple of things in there that I am not familiar with, particularly around water. And you've talked about the different types of wai, and that there's some that are really desirable and some that aren't from a cultural perspective. And I wanted you to just explain what that means and which ones are and not and why.
So just to clarify, that's para 38C on page 10.
Yeah. So some of the place names you'll see down, our traditional place names on the lagoon are named wai, like wai tuna, wai parira, wai para, wai paka, and wai hao. These are all names of the different creeks that come into the lagoon. So it was important for us to let whānau know, or the commissioners know, to this consent, that these are the landscape has the names inside of a landscape are significantly important because they tell a story. Now, most of the names down there are wai stories, or water names. So Waitai, of course, is the ocean, which is right over the other side, Waitai, or the takiwā of Tangaroa. So there's that association. Waitai, Wai Māori, the fresh water. We have Waipaka, which can be translated as a sort of a brackish water that one would expect down there, but also a as a form of eel in one of its life stages. There is, which isn't referred to here, but waipuna, which is the different puna or tarns that are at each end of the lagoon. There's Te Waipuna at one end and Ngā Waipuna, which is a whole lot of tarns at the other end. So these are old traditional names. Now, these are, and these names are indicators that of our association over 700, 800 years. They're not written in any particular documents because those place names have been changed to other names since contact. I call it contact period, when our Pākehā tūpunas arrived on the southern coast. There are two types of, there are waitapu areas where one might say, well, they should not go there because that water is, there are none that I know of down that place, but there are other places within Ngāi Takiwā where there are, and I know at Taumatu, for instance, there is waitapu places up there. Waiora is, you will hear that quite a lot in Ngāi Tahu and also Māoridom, where it's very healthy waters. That's what we want. So that term is in there as we want healthy waters. And the opposite of unhealthy waters is waikino. Now, I refer to waikino as a bad water that we don't want. So something that's infected by substances that shouldn't be there. So in reference to my evidence, that's what we're calling waikino. Waimate is in reference to water that should not be drunk, not necessarily because it has contaminations, but it's just not good to be drunk or used by people or iwi. So that's those are the general ways that I'm referring to. The good ones, the references to old names that tells about our strong association in the past and our desire for a real strong reconnection, and then that water that's changed down there as a result of activities further up the catchment and the way that we have managed the catchment. But also waimate is just water that shouldn't be used by us.
That's really
it doesn't necessarily need to say that it's because of human impacts, that one. It's just water that's generally shouldn't be used. Stay away from.
Yeah.
May have had an incident that happened there, so it becomes topic. But it also might just be bad for jumping in and bathing or that sort of thing.
It's really helpful. Yeah, thank you. The next question I have is in regards to your evidence. Oh, it's actually the same, but it's 38. It's the last one. Maramataka.
Maramataka?
Yeah, and talking about the traditional moon phases. And what I wanted to understand is, so it's quite clear in this application and potentially the conditions of consent, what things are going to be tracked from a westernised science perspective, but what is less certain, and I wanted to know if there was a desire to make it more certain, is how you use those traditional environmental signs to determine lake opening, because otherwise it might get, the Western science might outweigh the Mātauranga Māori.
Yes. So, as you correctly state, maramataka is a cycles of environmental cycles or moon cycles, and in terms of maramataka. Some of these traditions around southern maramataka have been lost, but there's a desire, and there are hints and records of some things that did happen around maramataka down here in the south. So just in terms of what some future thinking might be around how we incorporate maramataka in terms of our thinking and use of and management of the properties that have been acquired. how do you use traditional knowledge to undertake the management of that? And you mentioned the opening. All I can say is around that, we don't have enough knowledge around exactly how maramataka might work in terms of the opening, but we do understand it or know that some of our other whānau throughout the Ngāi whānau throughout the Takiwā know when the right time is for the tuna heke. Now, the tuna heke is very important, kaupapa, very important to us. We haven't witnessed the tuna heke down here on our lagoon for I've never witnessed it for all my life. I've only heard anecdotal evidence that people have seen the tuna heke down here, but I'm suggesting that the tuna heke hasn't been seen for quite some time, potentially due to the opening being open at a regular every year. So going forward, I think the whānau would love to understand whether a tuna heke happens at the right time of the year. This is a real opportunity around why potentially delaying openings and all that based on an ecological model or cultural model would allow us to undertake tuna heke again. So that is a value that we have lost around tuna heke, but that is a maramataka sign. It's a certain time of year that happens. And we're also aware that certain, as Māori, we haven't had that connection back to Waituna for a considerable amount of time, but we would understand that there are parts of the year when there's going to be more water in the lagoon. You're expecting some of those times of year when the lake is lagoon lake, can be considered both, are the right time to harvest certain species. Now, that's some of the research that we want to do going forward. We have lots of researchers out there, and we will look forward to undertaking more research now that we've got a connection back to place. There are other signs that one should be aware of around not just moon cycles, but star cycles and matariki and those sorts of things, for instance, bringing in the signs of the new year. We intend to do a star. I think there is an intention to reconnect to space and learn to reconnect around the star signs and all that allow us to see the tohu. And I think I've got that on 42, that the tohu are very important to iwi, the signs that are the right times to harvest, the right times for migration of fish, etc., etc. So there's not 100% understanding of, because of our disconnect of life cycles, annual cycles, and longer time frames around what was called maramataka or maramataka, but it's a real desire of ours. But there are enough information that are existing, not just a little bit in our place here in the south, but other whānau that are undertaking maramataka signs and yearly cycles to practice their cultural needs, cultural values, and mahanga kai gathering.
In terms of how those matters are reflected in the conditions as to, I'm going to call it how in exercising kaitiaki, who's going to be involved in terms of feeding into the conditions of the consent, and how that someone's going to undertake that task so that that aspect of is addressed. How's that reflected in the conditions?
I think that sort of, Ms. Williams talked about how we frame that up. Watch partners frame up their particular piece of work going forward. We would, I think there's a commitment from Awarua, from iwi, that to be good kaitiaki, that we support an appropriate framework that we can get information out, undertake information collection that support our ecological and cultural values that we're seeking as a result of allowing the water to be higher. So that hasn't been framed up yet. We're doing a little bit of cultural monitoring, not as much as we intend to do should the consent be successful. And if that were the case, but even in that case, we've only just got reconnection back to this landscape. So the intention is to continue to build a program that will support some of the outcomes or some of the changes that we'll see as a result of understanding the hydrological levels.
What I'm thinking is that because that's not available at the moment, but that would have been much better for us to have in terms of understanding that, in terms of how that monitoring would be contributing to, and it's, if we were of a mind to grant it, would sit in a consent so that we could ensure that it is done.
Right.
Yeah.
Well, there are models out there that other people are using, but our intention is to do a local model.
Yes.
Yeah.
And I think that was the purpose of my question, was to go, well, how do you, so you've got all of this knowledge and you're building knowledge, and I was going to use the tūnahiki as a question specifically, so I'm pleased that you raised that and talked that one through, because I have the same question here as the chair, which is these conditions of consent are really quite skewed in terms of Western science, and there is a, like, I can't see there that it expressly says, and we're going to be working with mana whenua to take into account mātauranga Māori, and if the consent condition said that, you have the time then to build your cultural monitoring program, but it still is considered if the consent was granted. And so I was just checking if you had read the conditions of consent and you felt like mana whenua ability to feed in was reflected, or does there need to be a change in those conditions of consent?
Just have to refer to Ms. Williams just about that. There was always an understanding that we would commit to doing cultural monitoring. Now, where that sits in terms of, because I suppose a really important point is the financial commitment of iwi going forward to what they consider is not necessarily a problem that they created in terms of their health and well-being, but a commitment to kaitiakitanga, a responsibility of our people, of the iwi to safeguard and look after our environment for future generations. So there's strong commitment, and the iwi have been involved in this project for over 15 years when we first heard that the lagoon was in trouble. Sorry, I might not quote the 15 years exactly, but around that amount, maybe 10, 11 or 12. But we have been involved for a considerable amount of time, wishing to support the health, the whole of the lagoon, to be pikiaki to increase, and to be able to provide these opportunities to support our values. Yeah, so
it's actually, just to let you know, I'll be asking the same question of Ms. Thorne later today, to ask her, does she believe that mana whenua and mātauranga Māori voice is reflected in those conditions? So we can get her to actually answer that from a planning perspective.
I think that's.
I suppose we could definitely look at that.
Yeah.
It's just that I was just sort of just reflecting that there's a cost to doing all this. We're committed to doing it, and as a Rūnanga, some form of or other, but to undertake our kaitiaki responsibilities, but so there's time, effort and cost associated with that, and that's where we've got to continue to go back to the powers or the rangatira of the marae just to ensure that we're capable of those inputs that we require.
yeah, there's not unlimited
Yes.
capacity.
Yes.
No, that makes sense. My next questions are actually around the trust land that you've talked about. So that's paragraphs 66 to 72. You talk about the trust, and so for me, I'm trying to get an understanding of. So you've bought the land and you're using the land, and you've talked about retirement or a change in how you actually the concept of eco-cultural restoration. And I wanted to better understand that, because traditionally there's two worldviews going on here: land use for productivity, and that's what most people buy land for, as opposed to land use for what the trust is doing. And I wanted to understand, is this productive land that's sought for a commercial outcome, is it something else? And what is the something else? Because what I'm trying to understand is, why are you so comfortable with your land being flooded where others aren't?
I was very comfortable with that because there was a transition of through the Freshwater Improvement Fund that would go into the landholder trust that Awarua, the Waikato Trust are managing. And those covenants that were put on that, so there's covenants on the property that you must manage it for freshwater outcomes. Now, we, knowing that, but we already knew that, but we were very grateful and very happy to be able to receive that property so that we could manage it in a way that that looks after our ability to practice values around mahinga kai, kaitiaki tanga, and the transition was a very quick transition away from the farm being stocked with sheep. So there are paddocks on there, grass paddocks and all that sort of stuff that we just use to create an income, so that we can then plant out those areas of the property, to bring back how do I describe those areas? Those areas are the first areas that we've identified that are easy to turn back into a more natural system, because they're the wet areas, and they're the areas that are going to get wetter at the higher level. But we're very comfortable. Well, there's real comfort in those areas being wet, because in our mind that is places for mahinga kai, that is places for the different species, and I'm just trying to think of the word, it's just gone from my head, but the young ones, the habitat for young ones, and yeah, those sorts of things. So yeah, we want those places around the margins, and we were happy that there's places on that property that should be like that. That should always be like that. So having a wet property is something that we 100% knew was potentially wanted to happen, and desired to happen, because it increases your opportunities around undertaking your values, especially the mahinga kai value.
Right.
Yeah.
That explains it, because you're fundamentally saying the commercial return wasn't as important as this other value, and we put more weight over here. And so that really helps me understand.
So the thing about commercial return, you still got to pay the rates, and you've still got to do a whole lot of other things. So as a member of the trust myself, we have to look at other ways of providing income. Now, one of those is through education, bringing people back and creating an education space for our whānau to be re-engaged, or not just Ngāi Tahu whānau, but to educate our communities around what a beautiful place the Waituna is. And we have created a place for that to happen, a building, and it's our desire that would love to reconnect whānau, communities, schools back to that space. So it's potentially a small income stream. So there are other opportunities around wild foods, like honey, those sorts of stuff. that you got your manuka down there. There are other opportunities that that whānau have looked at what you would do with a space like that in terms of creating an income. So need an income, but it's the transition over time to be able to fill the desires of our old Rūnanga of iwi.
So then, that's a really helpful answer. And for me, what we've had from other submitters that I'm trying to balance the competing kind of views or values is how does mana whenua view personal property rights, and what value does personal property rights have when it comes to the decisions on land purchase?
100%. We 100% understand personal property rights. I think you're probably Naito. And yeah, we understand personal property rights. I think some of the evidence, and just in terms of some of the whenua that might have become a little bit more wet. Majority of a lot of it is in terms of the property that's been purchased, especially the Te Waipareta Trust property. We've captured a lot of those areas downwind in terms of things that might get wet, but I totally acknowledge property rights.
I guess it builds on your last. It builds actually on your last, and I think you potentially answered it in your last answer. So I was trying to better understand like the view of private property as opposed to collective property, and ultimately, I don't think it actually shifts the dial on what you've said already, which is you bought this for a purpose, and the purpose is restoration. So I won't take that question any further, but I do have just one more. It is just moving and going. Which one's? I've only got one more. Which one is it? Oh, so this is now paragraph 88 to 91. You talk about climate change and the impact, and that Awarua have been planning for, have been mindful of climate change and doing some climate adaptation. And I just wanted to know, how does this lake opening consent build into that existing work you're doing or views about climate change? Does it complement? Does a lake opening consent complement what your adaptation plan?
I think it complements, basically because there's an understanding that climate change, but there's also an agreement from a majority of iwi, Awarua, that climate change is a true and relevant thing to take into account, especially around the whenua down at Waituna, and when the conversations around the Waipareta property come up, so do we have concerns about climate change? And we said, no, we've got to, the whānau said we've got to adapt to climate change. So there's a property that this is a property that we can learn from in terms of climate change. If that sea in time broke over and become the next, that property then become where the sea was, where the seafront was, then it was like, well, that is part of the natural cycle. And that our whānau, or our children or our children's children that will have to deal with that is something that we would be quite, it is their kaupapa to deal with. So it's just part of working with our environment, not against it. Just in terms of the opening, I think there are, allowing through climate change, we think there's going to be more flooding, and it's we don't think we was probably understand there's more flooding. There's examples of some major flooding going on at the north, the Taui, with the Taurapa, and that we've got to prepare ourselves for these sorts of things. This consent allows us to prepare ourselves, giving us an idea of what higher levels, how it's going to support our mahinga kai, but also might allow us to understand high levels through climate change and more water coming down catchments at a quicker rate.
Great, that's really helpful. Thank you. That's all my questions.
Nothing from me either. You've answered my question. Thank you very much. Thank you.
Thank you.
We're going to take the lunch adjournment, and sorry, because we've still got a large number of witnesses, we're going to reconvene at 1 o'clock. So, thank you. meeting. Ms. Onki, the copies of the joint witness statements, are they available?
Only for the panel at the moment.
Only for the panel, right, so that's three. Is that the planning one or both?
Only planning at this stage. The rest are being.
Okay. Right. Okay, we'll let people get on with that and we'll carry on. So if we have Mr. Winton as the next witness.
Yes, and Mr. Winton's online, so
Okay,
hopefully he will pop up.
magically appear.
Ahi ahi Marie, Mr. Winton, nice to have you here. So just to confirm, your full name is Mary Dorrington de Winton,
Yes, that's correct.
and you are now employed by Earth Sciences New Zealand, previously employed by NIWA, and your role as a freshwater ecologist.
Correct.
And you've prepared evidence dated the 11th of July 2025 in support of this application.
Yes, I have.
And paragraphs 3 through to 9 of that evidence set out your experience and qualifications.
Yes, that's correct.
And if I can just get you to go to paragraph 13. So paragraph 13 talks about the Environment Code of Conduct. And in that paragraph, you've acknowledged that you do have an overriding duty to impartially assist the hearing panel, Ngā Kai Kamehana, on matters within your area of expertise, and that you're aware that this is an impartial assistance.
Yes, I am.
Mr. Winton, I know that you've prepared a summary statement, which is in addition to the executive summary at the start of your evidence. We do have copies, Commissioners, and I'm not sure if those have been handed up, but we can.
This is the executive summary at the front.
It's not the executive summary, it's a summary statement, which I think Mr. Winton, I'll let her tell you about it.
Right.
And she's just going to speak to that, and that does also attach the updated table for the Rūpia monitoring through to 2025.
Okay. Yeah. Thank you for that. Is it possible to have Ms. De Winton fully on the screen by herself so that we could see her? Sorry, you're rather small in the.
The other one?
And that one. Screen, please. Thank you. Thank you. We've got your summary statement. Over to you, Mr. Winton.
Thank you. Te koutou, everyone. So I'm just going to give a brief summary statement, which leads to 3 points. My evidence relates to submerged macrophytes, and I define these as easily visible plants that grow permanently submerged, and also macroalgae, which are multicellular algae visible to the unaided eye. So Waituna lagoon vegetation mostly comprises 2 species of Rūpia megacarpa and Rūpia polycarpa. And Rūpia only dominate submerged vegetation in brackish water lagoons and coastal lagoons, and this is because they are more tolerant of high and fluctuating salinity than most other submerged plants. For Waituna lagoon, sediment pollen records confirm that these species were present before the beginning of the artificial openings. So most of the coastal lagoons in New Zealand have lost their submerged vegetation, including the best known example of Te Waihora or Lake Ellesmere. I'm also noting that Rupia megacarpa has a national threat designation of at risk, naturally uncommon, because of its limited distribution and abundance. So Waituna Lagoon is one of the last few remaining large coastal water bodies on the mainland to regularly support rupia-dominated vegetation, but this vegetation is at risk. Too many stresses can easily overwhelm macrophytes' ability to survive, to reproduce and re-establish. And in this respect, nutrient enrichment and or high sediment loads from the catchment can cause a water body to flip from a macrophyte-dominated state into a state with blooms of algae, macroalgae or phytoplankton, meaning microscopic plants. In this state, in this new state, there is insufficient light for macrophyte growth and recovery, and their ecological benefits are lost. So this is things like the provision of habitat and food, shading, nutrient uptake, and sediment stabilization. So my first point is that rupia-dominated submerged vegetation would be the typical natural state at Waituna Lagoon. It is valued, and that loss of this rupia vegetation would leave the lagoon in a significantly more degraded state. So in Waituna Lagoon, there's been submerged vegetation surveys made in summer annually over the last 17 years, and this has been done at over 45 sites monitored lagoon-wide. Surveys have also been made in spring over 3 years and winter over 2 years at 16 of these sites. In my opinion, this level of monitoring provides for a robust understanding of rupia responses to lagoon opening regimes. Rupia was present year-round when environmental conditions permitted. Rupia seed was present year-round, and seed bank viability is unlikely to be depleted over greater than 1 to 2 years or more, even if there's no fresh seed that's added. Seed germination has been seen within the lagoon, and I would consider that seedling recruitment is the way that rupia recovers after a large disturbance. Successful summer flowering and fruiting is needed for rupia seed replenishment, and the greatest summer flowering success is seen when rupia cover and height are well developed. So macrophyte monitoring results at Waituna Lagoon have been assessed against 6 ecological targets. These are provided in table 1 of my evidence. 4 of the targets relate to the development of rupia species and their reproductive success. 1 target describes macroalgae development against an upper cover limit, so above that limit is considered bad. And 1 target considers if the lagoon has been closed for the previous 3 months before monitoring. So in my opinion, these ecological targets are relevant for assessing the well-being of rupia at Waituna Lagoon. In table 2 of my evidence, we consider monitoring results against the 6 ecological targets, whether they were met during the 17 years of monitoring. So in years that were not closed for 3 months before monitoring, only 1 or no ecological targets were met. And this was the case for 8 of the 17 monitoring years. So I've concluded from this monitoring results that an open lagoon condition during the critical spring-summer period for rupia leads to poorer growth and reproduction, and to greater vegetation disturbance and loss via drying, disturbance by tidal currents, and also waterfowl grazing. In contrast, 4 or more targets were met only in the 2nd consecutive year of meeting that lagoon closure target. So consecutive years of favourable closed conditions during the critical spring-summer period allowed greater rupia biomass, plant height and reproduction. And noting also that it's been no more than 2 consecutive years meeting that lagoon closure target during the last 17 years of monitoring. So my second point, in summary, previous resource consents with an opening trigger water level of 1.8 to 2.2 metres above sea level did not avoid open lagoon conditions over the critical spring-summer period for Rūpia. And almost half of the monitoring years were open during this time and leading to impacts on the Rūpia vegetation. So now talking about the resource consent conditions. Firstly, I do take note of the existing environment. So that is one without any artificial openings. And for Waituna Lagoon, this would be closed for most of the time, and openings would be very short in comparison. Under this scenario, water levels would be higher, the lagoon would be deeper, be fresher for longer compared to artificial openings. I do recognise that nutrients and sediment enter the lagoon from the catchment. It has poor water quality, and it is considered at risk of phytoplankton and macroalgal blooms. So opening the lagoon would disrupt phytoplankton blooms and flush nutrient-rich water. This would be at the cost of also disturbing the macrophytes. However, not opening the lagoon under these bloom conditions would also mean that plants would be excessively shaded, impacting plant growth, reproduction, and survival. The application proposes the lagoon would be opened in the event of an algal bloom. In my opinion, this provision is important to maintain a light climate for macrophyte growth. Secondary indicators in the proposed application also consider macrophyte and macroalgal status. So in my evidence, I consider actions from hydrological modelling based on different water level triggers. My understanding is that water level triggers at 2.4 to 2.5 metres above sea level would provide more opportunity for water to recede naturally without unnecessary openings. A trigger of 2.5 metres above sea level for 7 consecutive days would reduce the frequency of lagoon openings compared to the past lagoon trigger levels of 1.8 to 2.2 metres above sea level. And importantly, it would reduce the number of openings in the key spring-summer period for Rūpia growth. This application proposes a transition regime over 15 years leading up to the trigger level of 2.5 metres above sea level for 7 consecutive days. This transition regime would also provide some reduced risk of opening in the key spring-summer period for Rūpia growth compared with the past lagoon trigger levels. The current application would increase consecutive years of favourable closed conditions for Rūpia during the critical spring-summer period. In my opinion, and based on the monitoring results, this would act to protect the dominance of Rūpia. So hydrological modelling also indicated there'll be short periods of time at high lagoon level under the proposed consent conditions, but these would be less than about a month above 2.4 metres above sea level. Based on the literature and my experience, macrophytes can survive periods of insufficient light of a longer duration. Plant welfare during high water level would be supported by a higher biomass and a height expected under the proposed opening regime of the application. So my main conclusion is that I consider this application would progress the lagoon towards a more natural state with a more stable, sustained presence of submerged vegetation comprised of salinity-tolerant plants that would be typical of a healthy coastal lagoon in New Zealand.
Thank you. I'll see if the panel have any questions for you.
Thank you, Mr. Winton. I'm just checking you can see and hear us okay?
I can, thanks.
Thank you, that's all right. Well, thank you for that summary, and thank you for those 3 points. It's very helpful. I do have 2 or 3 questions. Just understanding your last point about the insufficient light. We were out on site yesterday, And it was very apparent, and I think the submitters have raised the matter of the tannins in the water, the darker peaty tannins of that water, and that was very apparent. So would a higher water level, or would the tannins, I suppose, in a higher water level, influence the rupia with that reduced light regime?
I think, yeah, a good question. Tannins, along with any other kind of material that's suspended in the water column, will reduce the light that gets down to the macrophytes. Tannins, I would consider to be a natural component of Waituna Lagoon. Tannins tend to build up in water bodies that are very closely connected to wetland, which obviously Waituna being, part of the wider Awarua wetlands would receive those tannins naturally. I'm also aware that tannins do break down over time, so wouldn't necessarily be collecting in Waituna Lagoon, but certainly they do influence the light environment for plants. I think does that answer the question?
Well, I guess what I'm trying to understand is if it is retained at the higher 2.5 level, would that be create any kind of adverse effect on those rupia beds because of that light regime? And I note that you say they can seem to survive a period of some weeks with reduced light. Just trying to understand, with that higher level, would that likely influence or have an adverse effect on those rupia beds?
Right. The hydrological modelling that I referred to did predict that the time above sort of 2.4 metres would be very short. So much less than the month that I'm sort of considering in the evidence, or the shortest period that macrophytes should be able to survive in sufficient light. So from that perspective, I wouldn't expect a large impact on rupia at higher water levels. The other thing that I would point out is that under the consent, with less disturbance of the rupia vegetation during that spring-summer period, we would expect plants to be more robust and be growing taller. The height of the plants obviously is very important because the plants need to get their photosynthetic tissues up into the light climate that's going to support their growth. So biomass of the plants and the height of the plants is going to be important. So we're considering that we're providing the plants with better opportunity to survive any high water level periods.
Thank you. What height do they grow?
So just to give you an idea, in a very successful year, that was the year of 2023, the average height of the plants, the rupia plants, was 0.65 of a metre tall. The sizes obviously ranged, and the tallest plants for Rupia megacarpa were above 2 metres tall.
That's much higher than I was expecting. Thank you for that. And just next question refers to actually paragraph 32 of your statement of evidence, but you did mention it in your summary, which is regarding the case where the lake could flip from a macrophyte dominated to a phytoplankton dominated environment. So the question is, can that reflip back, and what would be the mechanism for that to occur if it was available?
Right, I believe this is going to be covered by Mark Schellenberg in his evidence, and probably to a greater depth than I can do it justice. There are, regime shifts or flips can be permanent, and they can shift back and forth in the event that a water body is sort of teetering on the brink, so I'll probably leave it there and suggest that Mark Schellenberg would be covering that in more detail.
Thank you, that's fine. That's a question for Mr. Schallenberg. I also understand that the regime of opening, or the consent for the opening, is suggesting every second year an opening for fish passage purposes. And you made it clear in your evidence that a 2-year consecutive period of non-opening is actually very beneficial for rupia and the macrophytes. I guess my question is, does that lead to, and I'll use the term boom and bust kind of example of, you know, very good growth and then a very poor year and then a good year and a poor year. Is that a scenario that would play out with that regime of opening?
Yes, that the regime that the consent conditions would be trying to achieve is avoiding an opening either within the spring-summer period or one that extended into the spring-summer period. To my mind, an opening for fish passage would still potentially be compatible with avoiding that spring-summer critical period. So that would be my first point. I think the second point would be around how rupia vegetation recovers from disturbance. And it would be primarily from seed bank. One of the things that we want to avoid is a number of years that don't allow rupia to grow to the biomass and height that it has a successful flowering and fruiting event. So as long as it, as long as there are regular flowering and fruiting events and the seed bank is kept replenished, then the vegetation should be able to recover from the seed bank.
Thank you, that's helpful. My final question really refers now to the proposed monitoring and the triggers. And the macrophytes, as I understand it, are a secondary trigger, which would be looked at in association with the primary triggers. My question is more around the timing of those monitoring events and understanding how a primary trigger, which might be a water quality trigger, is triggered, and then referral to the secondary trigger of macrophytes. But that may have been done many months prior to the primary trigger, if that makes sense. Would the suggestion be that you go out and do more macrophyte monitoring to test that primary trigger, or just reflect on what has gone before?
It would be more reflecting on what's gone before and letting the status of the rupia in the recent past help with the decision making around an opening. So if the macrophytes had been in a poor condition for a period of time, then another opening for another purpose might need to be considered in that light. However, I don't rule out the necessity of undertaking more monitoring for a specific purpose.
Okay, thank you. That's no more questions.
Great. Thanks, Kia ora. I have a number of questions for you as well. And I will refer to the paragraph of your primary evidence. So if I start with paragraph 44, and at 44, you're talking about those ecological targets being met in that really good year, the 2003 year. And what I wanted to understand from that is your evidence links that to the fact that there was a second consecutive year of lagoon closure in that spring and summer period. And I just wanted to know whether there were any other factors that might have actually also led to that result, like rainfall or differences in nutrient inputs or any catchment management that might have occurred or been different in that 23 year that you're aware of.
I'm not sure I can speculate here because I possibly don't know enough about everything in the lagoon environment that may have been different in that year. So I'm not sure that I can really comment without speculating. I guess the conclusion that we came to that a second consecutive year was of closed conditions during spring summer was beneficial for Rūpia is just from the history of those 17 years and looking at those the pattern of responses by Rūpia. So there are other occasions where there were consecutive years providing those really favourable conditions over spring summer, and we did see higher numbers of targets being met and also an expansion of Rūpia over those consecutive years.
Great, thank you. My next question relates to your paragraph 58. And so at 58, you're saying that's where we're talking about the openings can be triggered if there's an algae bloom breakout, if they last for over 14 days. And what I wanted to understand about that is whether, why 14 days? Like how quickly, how significant of an algae bloom breakout is required, and what type of time frame is appropriate to be able to intervene to prevent the flip occurring? Right.
Again, I don't think I'm the best person to answer that specific question. I think it would be best addressed to Ash Rabble or Mark Schellenberg, because their evidence, specifically considers the phytoplankton communities. From a macrophyte perspective, algal blooms could be, very deleterious and be shading out the macrophytes if they were sustained. So that provision of opening in the event of an algal bloom would serve to protect the macrophytes.
Yeah. Okay, so I'm just trying to get a perspective of how, and maybe it is a question for somebody else, but how quickly then it shades and impacts on the plant life.
Right.
So I'll ask about the speed of growth to somebody else. My next question is, it's in relation to paragraph 60, where you talk about Walker's Bay being the preferred opening site. And you've explained about, because at this point in time, the Rūpia is more in the eastern lagoon. And I was trying to get an understanding of, there's been the speaking of an adaptive management response, but it seems to be you monitor, you get the information, and then you decide the only response is whether or not to open the lake. So it's not a full adaptive management framework, but in terms of that, do we open or not? Over a 20-year period, it's quite possible, given climate change and lots of changes in the environment, that the Rūpia might shift and move in the lake. And I wanted to know how important it is to have kind of each of the opening sites as a bit of a toolbox to manage different scenarios for Rūpia. Is it likely that Rūpia will shift over that time? And therefore, is it necessary to have the different sites to respond to that?
My understanding is that the consent does consider, or will be able to consider, other opening sites when a proper assessment is done. So I don't think that there's I don't think it's necessarily closed off that there are those other opening sites, or at least that's my understanding. The recommendation that Walker's Bay is the opening site now is based on the recent history of the macrophyte abundance and composition in the eastern part of the lagoon. It appears to have been a refuge for sort of a higher number of species, and for greater abundance of the rupia and other species.
And so why does the rupia grow more in that eastern site at the moment?
We can't rule out that it is related to the current opening site, like the opening site being located more centrally in the lagoon, away from that eastern site. I think I would have to speculate. There doesn't seem to be any significant differences in the habitat in terms of, substrate, depth, etc. There may be a little bit more shelter in the eastern end of the lagoon, but really, I'd have to speculate.
Right, okay. And the reason I'm asking the question is to go, right, well, so if we were to say, grant the consent, and we would say, well, does it need to be at all 3 sites or not? And trying to get an understanding of is it likely rupia growth will shift over that time period, and is the 3 sites to respond to that? So that was more trying to understand the impact of site specific on rupia. But I think that you've answered that and taken that as far as we can. My next question is in response to paragraph 65, and it talks about the changes that may slightly reduce the likelihood of achieving the consecutive spring-summer closures and potentially affecting rupia recovery. And what I was trying to understand with that is if, and it's probably quite similar to the bust and boom kind of question that was asked before, but if there's a 1-year opening in the summer and spring, does that essentially completely remove all the benefits or the gains that you've had from closing it the year before? So how bad is a summer spring opening?
Right. I think there's some context there. So definitely, for preservation of a viable seed bank, then, you do want to have good fruiting events to keep replenishing that seed bank. So from that perspective, 1 open year is not so bad. It's when you get a sequence of openings during that critical period of time that would worry me. A single one-off, not so much, because we know that there's a mechanism for the macrophytes to recover from that seed bank. The transitional regime that's proposed, it won't go as far as the final 2.5 meters above sea level for 7 days. It won't go to that level of protection against having those spring summer openings, but it will certainly be a step in the right direction.
Great, thank you. And I just have 2 very quick questions left, and they're more about getting my understanding. It's in regards to the NIWA vegetation status report, the first one, the 2009 to 2023. Rather than take you to a specific reference, it's quite a generic question. It talks in there about water temperature having an effect, and I wanted to know what effect does water temperature have on rupia, and therefore how does that feed into a lake opening consent regime?
Right. Okay. So rupia would be more responsive over sort of spring, summer water temperatures. Warmer temperatures mean faster growth. When the lagoon is opened and there's a ingress of oceanic water, that water is cooler. It's not going to make a huge difference to growth. It's not a massive temperature difference, but there could be some slowing of growth under an open lagoon situation for Rupia. And to my mind, that would make it more susceptible to removal by disturbance. If the plant isn't regenerating itself and there's parts of the plant that are being sloughed off by tidal currents or removed by waterfowl, then the plant isn't growing fast enough to replace that its own material.
Great, thank you. That was helpful. And my last one was just, I don't understand references to dissolved oxygen levels. So it talks about having very high levels of dissolved oxygen at most sites. And I didn't know what that meant. Is it good or bad, or, you know, what happens with it? Please explain it.
Yeah, so dissolved oxygen is good. Essentially, levels over sort of 80% are considered, you know, fairly reflective of a healthy water environment. The dissolved oxygen means that there's oxygen dissolved in the water that's available for other biota, be it fish or macroinvertebrates. It's those sorts of animals would be stressed if dissolved oxygen was very low in the water, like less than 20%.
Yep, I get it now. I understand. Great, thank you.
Thank you, Commissioner. I just have a couple of questions, Mr. Winter. In terms of your evidence at paragraph 60, where you were talking about the preference of opening it walker over the fence, because there are three potential opening sites that are consents being sought for, what's your view on the difference between the fence and Hanson's Bay in terms of an opening location?
Right. I would include Hanson's Bay as being part of that eastern part of the lagoon where we are seeing more of a sort of refuge for Rupia and for the macrophyte species. So sort of same argument for Hanson's Bay as the fence. Currently, given the distribution of macrophytes, an opening there I would expect to have more impact on the macrophytes currently.
From your expert perspective then, in relation to that, should there be is there a preference in terms of how the consent conditions operate, in terms of that those matters are considered as part of when the decision about opening is made?
Given that there is going to be ongoing monitoring of the macrophytes, I think that any changes in the distribution pattern for the macrophytes should be detected. I could see that could be taken into account in decisions around where to open. I can't speculate whether it would lead to a change or not at this stage, but I can see how it could be considered.
Okay, thank you. And then just on I have no idea where the camera is, referring to your summary statement and the table 1 and 2 in red on the back, how is that different at all from your tables 1 and 2 on pages 12 and 13 of your evidence in sheet?
Oh, it's copied directly across.
Copied directly. Okay. Any follow-up?
I do have one follow-up, yeah, if I may, just, Mr. Winton, yes, thank you. Does anything in the proposed transition and the regime increase the risk of any biosecurity incursions that would affect the aquatic macrophytes?
Don't believe under the proposed regime that the lagoon salinity would drop to a point where, for example, your typical freshwater weeds would establish. In fact, previously there has been a shoot of Lagrosiphon major. It's one of the bad auction weeds has been found at the lagoon. It was fortunately dead, but I think that the salinity levels when the lagoon is opened would either rule out incursions of sort of freshwater weeds, or would essentially kill them due to high salinity. I can only consider freshwater weeds. That's from my perspective. I can't talk about other pest species.
Thank you.
I have one. When you say spring, summer, I'm not trying to sound pedantic here, but if it was in a condition, spring and summer doesn't have much relevance to a specific time. If you were suggesting that the conditions applied so that there weren't openings, as I understand it, during that spring and summertime, what months of the year are we talking?
Right. I would probably broadly bracket it as September through to end of March. But I would point out that calendar constructs are not really relevant to plants that are growing, and they're going to sometime within that time frame they are going to experience better meteorological conditions, higher radiation, warmer temperatures, and that's going to be their key growth period. So that would be my suggestion. September through to end of March, key time, but I'm not saying where within that time would be key for the plants.
Okay, thank you. I don't think we have anything further. Thank you. So next, Ms. Williams.
Yes. Thank you, Mr.
We'll just
Winton.
shuffle the paperwork here.
Yes, so next up we have evidence from Dr. Holmes, and he has also prepared a short talking summary, which is not quite the same as his executive summary. I think he's attempted to make it a little bit more plain language, but he will tell us about that, and that's also being provided to you now. So Dr. Holmes, you're here on screen, thank you. Is your full name?
Ms. Williams, could you put a stop while Ms. Onko makes the screen here?
Yes, sorry. So there's just an adjustment in the room, Dr. Holmes, just to make sure that the commissioners, because they're only looking at a laptop screen and they want to see you properly and not what I'm looking at, which is a large screen behind the commissioners where you are quite large enough.
Yeah.
Oh,
Has that come up now?
not yet.
Not yet.
Yeah. Yes. We can now see you, Dr. Holmes. And can you hear us?
Yep, I can hear you. Can you hear me?
Oh, good. So can we.
Awesome. Okay, ahi marie, Dr. Holmes. So your full name is Robin James Patrick Holmes.
Right.
And you are currently at the Cawthron Institute, where you are leading the river and lake ecology team. Have I got that right?
Yep, that's correct.
And you prepared evidence dated the 11th of July 2025 for the applicants.
Mm-hmm.
And paragraphs 3 through to 7 of your evidence set out your experience and your qualifications.
Yes, that's correct.
And again, I direct you to paragraph 11 of your evidence, which discusses the Environment Court Code of Conduct, and that's where you acknowledge that you have an overriding duty to impartially assist the commissioners, Kai Kumihana, on matters within your area of expertise, and that the views are yours and that you are not speaking on behalf of the applicants.
Yeah, I know that. Yeah.
Thank you, Dr. Holmes. I would now ask you to go through that talking point summary that you prepared and then answer any questions.
Okay, thank you very much, and better go to the panel. Yeah, my talking point summary is very much my executive summary, just slightly modified to be read out loud. So there's very little change there. So just to start off, Waituna Lagoon has a very diverse fish community by national standards with 12 species of native freshwater fish. The lagoon's hydrological connectivity to the sea via the barrier beach is a key factor influencing the life cycles of fish species within the catchment, including those that require access to the marine environments for spawning or juvenile development. These fish that require access include Rūnanga and long finial or tuna, and they're both listed as at-risk declining, and also lamprey or kanakana, which is listed as nationally vulnerable. So prior to this current consent application, none of the previous consents had provision to allow for fish passage. When consents were held, mechanical openings were undertaken roughly annually to facilitate mainly drainage for surrounding farmland, and fish passage was provided for as a sort of byproduct of these opening events. The current fish community, or the fish community over the past few decades, with its high representation of ocean migratory fish, is a product of those previous opening regimes. And the makeup of the fish community today is likely quite different to what the fish community would have been in its natural state when the lagoon was closed more often. In its past state, it would have had lower relative abundances of ocean migratory species and a higher proportion of fish that can complete their life cycle entirely within fresh water. Under the proposed barrier beach opening regime, if lagoon closed periods coincide with the key migration periods for these ocean migratory fish, obligatory ocean migratory fish, there is potential for reduced recruitment in the wider catchment for species such as lamprey and Rūnanga, or kanakana, lamprey kanakana. Conversely, other fish species that do not require access to the ocean, such as giant cockapoo, may benefit from the increased occurrence of the large productive freshwater lake environment that's created when the barrier beach is closed. In the case of giant cockapoo, closed lagoon conditions, especially during spring and summer, are likely to improve recruitment in the wider catchment because the lake environment provides a better larval rearing conditions for the species compared to when it's an open, more estuarine environment. So improving the recruitment of the giant cockapoo in Waituna Lagoon, in Waituna catchment, would improve the resilience of one of Aotearoa New Zealand's most important populations of this at-risk freshwater species. So from a whole of ecosystem perspective, this potential benefit can be seen to compensate for occasionally weaker recruitment during some years for the ocean migratory species such as lamprey kanakana, which also have high cultural and conservation values. So to address the potential for reduced recruitment of ocean migratory species, provision for fish passage has been built into the proposed conditions. Should openings to manage water levels or water quality not provide for adequate fish passage for key species, there's provision to open it every 2 years, as has been talked about. The proposed conditions allow for the needs of ocean migratory native fish populations to be considered alongside other key management goals, such as supporting the development of healthy macrophyte beds, including the rupia species, as you just heard, so, and also restoring a more natural water level regime. There's long-term quantitative fish population data for the lower Waituna Creek, which provides a sound baseline for detecting changes in the fish community structure and abundance when paired with ongoing fish population monitoring, as is proposed in draft. Thank you, and yeah, I now invite any questions.
Thank you, Mr. Holmes. I've got 2 or 3 questions. I don't know if you heard my question to Mr. Winton. I'm interested in the 2-yearly cycle of opening for fish passage and what that means for the fish populations. And I addressed that by, does it lead to a kind of boom and bust scenario of population growth and then population decline? And does the 2-yearly regime smooth that out? Or is that particularly detrimental, and what does recovery look like if that was the case?
So there's 2 there's 2 parts to answer that question. One is the effect on individual populations of specific species, and the other is the effect on the wider connected fish community, which is linked through the food web, etc. So in terms of the individual species, the 2-yearly opening regime, if it actually plays out that way, bearing in mind that a lot of it won't openings for water quality, etc., will probably allow for fish passage in many of those 2-year blocks. That makes sense. But say water quality isn't an issue and we do get up to triggering the openings for fish passage, that will have meant that there would have been a year when Rūnanga would have been largely absent from the catchment, and we know that already from when the lagoon is closed during the upstream migration phase for Rūnanga. So that's Rūnanga, one of the whitebait species, the most common whitebait species. So there's one effect. They are likely to bounce back very quickly, and because they have done in the past, we know that in the past. So from monitoring in the Waituna Creek, when the lagoon was closed for the duration of that upstream migration period, we found 6 Rūnanga. And then when it was open for the full period, we found something like 6,000, which was basically the next season. So those are rough numbers, not indicative of the population of the entire catchment, just 1 point, but it just sort of shows that you can have like 2 or 3 orders of magnitude difference in Rūnanga populations from year to year based on that opening regime. So that's one thing that will happen. But as I outline in my evidence, the lack of Rūnanga will be to some degree compensated for, I believe, by an increase in the recruitment of giant cockapoo. Giant cockapoo are actually also a whitebait species. So we will essentially replace the ocean migratory whitebait with a freshwater lake whitebait, if you like. So I believe that there'll be a compensatory mechanism there from a wider sort of ecosystem perspective. Does that answer the question? Is there another aspect?
Well, it's helpful, certainly. And then do you have the confidence in the recruitment from other Rūnanga spawning areas in the wider complex that there'd be sufficient recruitment into the lagoon when it is open for that fish passage at the right time of year?
Yes, yeah, because we've got large major rivers in close proximity which have a lot of larval Rūnanga drifting around. They are sort of Rūnanga show a sort of let's say accidental site fidelity. So if you have an area of embayment, you'll have a population that's roughly recruits to itself. But say on the west coast, you've got longshore drift of all the larvae, so one river actually populates the river to the north. And so in Southland, we've got a lot of, it's not a particularly invade environment. There'll be a lot of transfer from the likes of the Mataura and other rivers nearby.
Okay, thank you. And in paragraph 57, I think it is, of your statement of evidence, you talk about a degree of fish stranding that may occur, such as common bullies. And you make comparison of the effects of the opening. Let me just get my question sorted here. Yes, that's right. The strandings and the fatalities that go with a population of such things as a common bully. I don't know what other fish might be stranded. You might like to respond to that as well. But you say that will be less ecologically damaging than a mass fish mortality that may occur as a result of extensive algal blooms. And I assume you mean from that some major deoxygenation effect or something of that like.
Yep.
Because my question is, has there been evidence of that mass fish mortality from algal blooms in the past that we know of?
Okay, not from Waituna Lagoon. It's one of the few coastal lagoons where that actually hasn't happened yet. But we got close, which is one of the main reasons for that emergency opening that occurred a couple of years previously, with the, I believe it was nodularia bloom amongst other, so the cyanobacteria bloom that was about to occur certainly looked like it was occurring to the extent where it would drive oxygen to the point where you could have a mass mortality event. And that really would be worst case scenario, something that I would rather manage cautiously to avoid ever happening, rather than wait for it to happen and use that as evidence that it might happen in the future. So certainly opening the lagoon to prevent those toxic algal blooms, to prevent mass fish kill in Waituna, is something that we can manage to stop it ever happening in the lagoon. And so I think this is one of the things that one of the reasons why we can say the lagoon is in a relatively pristine state is because we're not in that situation yet. So there's no evidence specifically from Waituna of toxic algal blooms, but there's plenty of evidence from the likes of Lake Forsyth, other similar lowland coastal lagoons which have high nutrient levels equivalent of that of Waituna. So I would suggest that in a no consents environment, if you left the lagoon closed for 3 years or more, and again, I should probably defer to Mark Schallenberg on this, but a toxic algal bloom is quite likely. So under that regime, it's quite likely that we would see mass mortality events of fish. So that's my reasoning behind saying that some strandings is better than that.
Okay, thank you. And in terms of the strandings, I mean, the common bullies have been mentioned. Are there any evidence of other strandings of other fish?
No evidence. It's certainly possible, and I imagine that it has happened over the management of the lagoon in the past 100 years. I think that every opening event will result in some strandings, certainly of common bullies, because they tend to sort of stay put in any areas of slight depression that aren't, a smooth transition. Any areas of ponding that are left over behind will confuse bullies because they hug the bottom and they might not go up over a lip, and they'll get left over in puddles. Trout, eels are pretty good at trout are good at getting out of there fast. Eels are less vulnerable to stranding because they can actually travel over a moist surface to find the deeper water anyway. But small eels certainly would be vulnerable to stranding. I'm sure that small eel stranding has been an issue in the past. I don't think anybody has noticed this because gulls, predators, etc., scavengers move in pretty quickly and clean up all the evidence within hours usually of these sort of stranding events. So I think it's sort of a necessary feature of the lagoon. I mean, even under its natural state, strandings would have been somewhat of an occurrence, perhaps. So does that answer your question?
Yeah, thank you. And there's no evidence that giant cockapoo have been stranded or affected their populations that you're aware of?
Because the giant cockapoo, when they're in the lagoon, are very, very small and very, very hard to see. So they would be essentially larvae, and you'd have to be really looking carefully for them. I mean, it's not to say you couldn't find them. One of the concerns about opening would be a lot of them get drained out to sea, so that's maybe not the best thing. They'd have to find their way back in, which they possibly could do. So yeah, I'm sort of no evidence for that, but they're probably a component of the fish that get stranded, yes.
Thank you. And then another question relates to paragraph 55 of your body of evidence. And I just want to tidy up any confusion of terminology, probably, because you talk through in the latter part of that paragraph, manage fish populations through an adaptive management approach. and yet we haven't seen beyond the openings any other measures or mechanisms of adaptation that might be put in place. And I just want to clarify with you whether you do mean that there's a whole suite of other adaptations that could be in place other than the openings, or do you mean just those openings?
In this context, I just mean those openings and the timing of those openings.
Okay,
and frequency.
That clarifies that, and I think it's just important that we understand.
Sure, there's plenty of things you could do to boost the fish population in the catchment, but I'm not talking about that in this context.
Okay, thank you. And I think we're okay with that. And I've got another question. I think I'm probably okay. Thank you, Mr. Chairman. Thank you.
The majority of my questions have been answered, and I've been going through ticking them off as we go. So that's really helpful. And it's just left me with one, and it's off the back of the evidence of Mr. Whanga earlier today, where he talked about that mana whenua haven't really gotten great information of being able to use traditional Mataranga Māori practices on fish migration because of the previous regime being open quite consistently for land drainage purposes or flooding purposes. And I just wanted to know from your perspective, does this new regime, will this new regime, if it is granted with these conditions of consent at the moment, enable mana whenua to start to recover that information? Will it provide better and more information on fish passage?
Yes, because it will ensure, well, to some regards, yes, but insofar as Western science can contribute to that knowledge, which I believe it can. So this consent will ensure the ongoing monitoring of the fish population in the catchment, which is knowledge for everybody to tap into. So there's that. And then in terms of changing the regime, if you look at the way the regime's been run so far, it's been one sort of type of opening regime, closing it for attempting to close it for 2 years at a time will perhaps elicit a response from the fish community which might be more closely related to natural conditions, which might actually in fact be more closely related to traditional conceptions of what fish did in the catchment, I guess. So perhaps the previous regime, sorry, not the current state where there's no consent in place, but the previous one, essentially would have disrupted any catchment scale fish population response that would have aligned with the way the fish would have behaved in the previous, 600 or 700 years, right? So in that regard, I think it could do that. Yeah, sure. But bearing in mind that this is well outside my warehouse in terms of knowing how that could match up.
I know that's really helpful. It does, because it's getting an understanding of how you might use Westernized science to enable more understanding of Te Ao Māori worldview. So thank you for that.
I can give you an example of how the reverse has happened in this particular catchment. When I was looking at the response of Kanakana to the lagoon opening regime, I used the fish calendar, and it wasn't until I expanded that on local knowledge about when the Kanakana actually run that I got sufficient correlation with the numbers, because they actually run in a wider window. So the reverses are already happening, if that helps. So there's not a transfer going on at the moment in this catchment.
I think a lot of people do find it sometimes difficult to understand how the connection does work between Westernised science and Mataranga Māori. So giving examples is helpful. So thank you for that.
Thank you, Dr. Holmes. I've got a couple of questions. Could you just explain when the fish run, is that a time when it's not proposed to have the opening, the location of the opens actually open, if that makes sense. So I'm trying to understand, are we encouraging fish to run, or when is the openings sort of proposed or not proposed when the fish are running?
So so again, there's different migratory requirements for the different fish, but the vast majority of them require sort of will require access to or from the ocean, whether they're adults running like kana adults running to the ocean, or juvenile eels running up into the freshwater environment. The window that most of them require access to the ocean is sort of late autumn to mid-spring. So the proposed condition is for if the lagoon's been closed during that period for the 2 years, then we can consider all the other things as well, because bear in mind we're trading off values of maintaining rupia, etc. But we'd want to see the lagoon open between 1st of April and 30th of November, as is stated in the conditions. So if the lagoon was open during that period, it is likely that the migratory requirements of the obligatory ocean migratory fish would be satisfied.
Thank you. What's your understanding of there's a 5-yearly review that the applicants are going to undertake to look at the success as they're transitioning through on the consent. What's your understanding of what involvement someone like yourself would have in terms of that review?
Well, I would hope that someone, either myself or otherwise, suitably qualified with respect to fish, would look at the fish population data that's been collected over those 5 years and use that to sort of determine whether there's been looking at the trend data based on the previous 10 years of data that we have, and look for signals in, say, the juvenile kana, whether they are, if they're decreasing at an alarming rate, then you would think that perhaps that 5-yearly review would revise the fish passage conditions. In that same breath, it might be that there is no response from the kana. The populations remain perfectly healthy, and then you could review that fish passage review provision to say we might not need it until every 3 years. So that's my understanding of the review. The data collected subsequently, if this consent was granted, could reshape the need for opening the lagoon for fish passage reasons. As I outline in my evidence, it's a complicated beast, the fish community. It's interconnected. There are many indirect pathways by which these effects might happen. And just because less fish are getting into the system doesn't mean that we'll have less fish in the system because of, say, density-dependent effects. So if those are in play, and we could either relax the need for fish passage openings or perhaps increase it. So that's my understanding. As to how that goes about in terms of what legal and planning implements are in place, then you have to talk to the planning experts.
So in terms of that, the fish monitoring that's done at the moment, it's probably written somewhere, but can you tell me what it is? What's the fish monitoring that currently is undertaken?
So since 2015, there's essentially an annual record of the fish population in the lower Waituna Creek. It's in several sites, so up to 11 sites of data have been collected, but it's usually between 2 and 6, and it's using quantitative depletion count electric fishing, which is essentially the gold standard of fish population monitoring. We net off 50-metre reaches of the stream, and then we use 2 electric fishing machines to fish systematically down that entire reach. And then we do that multiple times until we get a depleting number of fish each time. And then we use that for a curve to estimate if we've done an infinity amount of fishing, an unlimited amount of fishing. We can use that to estimate the total population of fish in that reach through that depleting curve. So that really is the gold standard. That was supported by the Fonterra Living Water program, and we would look to continue monitoring in a way that that allows comparison with those data. So and then the additional monitoring suggested is that setting bite nets and traps in the lagoon itself, which we have far less data from, to look at if the giant cockapoo respond positively to the increased lagoon close periods.
Have you seen the draft consent conditions?
Yes.
Okay. Does that fish monitoring that you're referring to and the additional part, is that referred to in the conditions of consent?
Briefly, not in the consent conditions, no, sorry. The monitoring plans referred to in the consent conditions, and in the monitoring plan, which is an appendix, it says collecting data in a way that's, I think it says compatible with the previous data.
Right.
It's not in the consent conditions itself. It's yeah, I believe that to be the case. But maybe you need to direct that question to one of the planners who's got better across the conditions. But yeah, I think it's an appendix.
Okay, no, that's helpful. Thank you very much. Do you have anything? No. No, that's very good. Thank you, Dr. Holmes.
Thank you.
Thank you, Dr. Holmes.
Mr. Jacques.
Mr. Jacques.
Kia ora. Slide on that so you can hear.
No, they did.
Okay.
Kia ora. So your full name is Sean James. Now, am I saying this correctly when I just say Jacques?
Anglicised it slightly. Jakes. We say
Jakes.
Yeah, yeah.
Okay. Mr. Jakes. Right, so your full name is Sean James Jakes.
Yep.
Currently, you are employed by the Department of Conservation Te Papa Arapāi, and that's in the Murihiku District Office, which, just for a little bit of context, Murihiku District includes most of the Southland region and the southern Antarctic islands, does not include Fiordland or Rakioi. And you are a supervisor of biodiversity with the district.
Yep, that's correct. Yep.
And you've prepared a brief of evidence which is dated the 10th of July 2025. And paragraphs 3 through to 9 set out your qualifications and previous experience. And you are a keen amateur birder with professional qualifications. Would that be fair?
It's fair to say. Yeah.
Okay. And looking particularly at paragraph 13 of your evidence and acknowledging your role with the Department of Conservation Te Papa Arapāi, you acknowledge there that you, again, have an overriding duty to impartially assist the commissioners on matters within your expertise. These are your views, and you do not speak for the applicants, and in particular, the department.
Yeah, absolutely. The data that this evidence is drawn from is essentially most of my own observations in my own time, and also information I've drawn as regional recorder for Southland for the Ornithological Society. But equally, I don't speak on behalf of the Ornithological Society with this evidence. I'm speaking as an individual. Yeah.
That's fine.
Thank you, Mr. Jakes. You do have an executive summary. Would you like to read that?
Yeah, certainly. Yeah, so just to touch on a point that's come across a couple of times, we've talked about management for multiple values, macrophytes, fringing wetland communities, avifauna, fish. When we look at birds specifically, the same question arises: there are multiple values within the bird community, and they all have slightly different but overlapping requirements. So yeah, it's not necessarily an easy answer in terms of what the effects are. But just to read through my summary, this evidence summarises my views on the expected effects upon avifauna of the proposed resource consent application for periodic openings of Waituna Lagoon. In coming to this view, I have drawn upon personal knowledge of the bird life of the site and surrounding landscape, and the observations of others as recorded in eBird, which is a global database of bird observations that we use. The evidence considers the current bird communities, species, their life cycles, distribution and abundance, and the effects that the proposed changes in water levels may have upon their foraging and or nesting habitats. The effect of the proposed transitional regime are considered, in the context of the current environment where no consent exists, and of previous approaches in which the lagoon was managed primarily for land drainage. Consideration has been given to the range of bird habitats present at the lagoon and their importance within the wider context of the approximately 20,000 hectare Awarua wetlands Ramsar site of international importance. Particular attention is paid to species of conservation concern using those being birds listed under either or both of the IUCN, International Union Conservation Networks, or the New Zealand Threat Classification Systems. In making an assessment of effects, birds are divided into functional groups, i.e. groups with common foraging or nesting requirements. While provision is made for both open and closed lagoon phases under proposed consent, the proposal entails a gradual reduction over the 20-year period in foraging opportunities for shallow water specialists such as wading birds and terns. This is mitigated, however, by availability of suitable habitats close by within the wider protected area. Swamp nesting and foraging species are likely to benefit the most from the proposed consent, with stabilisation of habitats and increasing feeding quality expected. In this respect, the proposal addresses local and national drivers of decline for swamp birds, whose populations have fallen drastically due to habitat loss and degradation. And in summary, I expect that the proposed consent, driven as it is by an intent to restore the lagoon to as healthy and naturally functioning an ecosystem as possible over the term, will provide a net positive outcome for bird life. One recommendation is made regarding amendment of conditions 5 and 6 with respect to timing of openings and the breeding seasons of threatened and at-risk species. So that's my executive summary there.
Thank you. We've probably got some questions for you, Commissioner. Sure. Okay.
I do. I have one kind of overarching question, and then I've just got some specifics to the paragraphs of your evidence. But my overarching one is just trying to get an understanding of, we've had like a period where the lagoon was opened regularly, a period where it wasn't, and then a period where it's going to transition to these openings. And so what I'm trying to understand is from a bird perspective and bird watching. So the birds will come and go in each of those different scenarios. So what makes this particular scenario better for birds?
Yes, it's a good question. It's the fundamental question really in this respect. And as I alluded to initially, it's not necessarily an easy thing to answer, because if the lagoon stays closed for longer and water levels are higher, then wading birds, for example, will have fewer opportunities to feed. However, there's plenty of habitat for them in the rest of the Ramsar site. And a lot of those species are species of conservation concern. Some of them, they're trans-equatorial migrants, birds that migrate all the way from the Arctic and find non-breeding refuge all the way down here. However, the drivers for decline for those birds aren't to do with an absence of non-breeding habitat. They're not to do with, they are they're largely to do with other effects through the flyway. So a warming Arctic and then this drastic and quite rapid loss of staging habitat in East Asia, the Yellow Sea. So a small loss of foraging opportunities here is not a problem in the big scheme of things. We can assume, given the declines in those species, that the rest of the Ramsar site is nowhere near at carrying capacity. Bartel goblet, for example, is declining at a rate of about 3% per annum. So there's plenty of room in the estuarine areas for those birds. If we were to choose one cohort of birds to manage for from conservation concern, it would be the swamp species. So bittern, crakes, fernbird, particularly bittern, and that's because the drivers of decline for those species, and the decline is quite drastic for bittern, are exactly what we're talking about. They are the availability of large areas of high quality wetland habitat. That's what they rely entirely upon. So yeah, that's you know, if we were to choose one species that to aim this at, it would be bittern, and this proposal actually aligns quite well with management for bittern.
And what do you mean from a bittern perspective when you say they require a high quality habitat?
Yeah.
What's high quality for bittern?
Yeah. So in terms of these are quite difficult birds to see and study. They're cryptic wetland birds, highly camouflaged, adapted to skulking around in vegetated wet environments. So our information and data sets are quite patchy, but from what we know of them, they're highly prone to starvation. And they're fish specialists really, but they're fairly broadly carnivorous. They eat mice and they eat frogs and things, but they really specialize on fish. So they're highly prone to starvation. They're highly prone to loss of wetland habitat and loss of nesting sites and fragmentation of wetland habitat. So really, the adults need to have 3 or 4 young in the nest. They need to provide, quite a lot of fish to the rapidly growing young, and they need to do that and be able to forage for those fish in as healthy and intact an ecosystem as possible, which also provides them lots of cover to be able to. They don't feed out in the open really. You occasionally see them in paddocks in the winter time, but that's probably driven. That behaviour is probably driven by need. They're starving really. So that's what they require really. They want and predation of nests is a big problem. So really, they're selecting as far as we know, they're selecting their nesting sites based upon availability of cover, availability of foraging areas nearby, and kind of fine environmental factors, and rapid change in the environment around the nest isn't good for them. So rapid change of water levels during the breeding season is no good, because that nest either becomes flooded or becomes exposed to predators, and the parents having to forage further and further away, and
Yeah, no, that's really helpful. Thank you. And that was going to be my next question about habitat. Breeding habitat, and you answered it, so perfect. Next is about specifically in reference to your evidence. It's your overall conclusions at paragraph 55, and it's probably not quite specific to that. It's again quite overall to say you've said that there's real value in recreation activities at Waituna for bird watchers, and then that's really important, and we have to balance people's access to be able to enjoy bird watching with creating the best environment for birds themselves. And so I wanted to know, from your perspective, does this lake opening regime balance those two well? Because there will be some periods, if you've got a higher lake, that some of the pathways to be able to go and do the bird watching won't be available.
Yeah, and that's it's a valid point. I guess that's just something that's just a change we'll have to adapt to over time. It's kind of a sort of a kind of circular argument in some ways because from I guess bird watchers want to see habitats that are restored and intact and natural and have lots of birds in them, but equally that might make it a bit more difficult to get into them. So this might be something we have to think about over time in terms of how to better provide for those needs. But yeah, and there's a certain opportunism and spontaneity with the activity as well as the life cycles of the birds. So, for example, when the periodic openings will happen, then waders will come in to feed opportunistically, and in turn bird watchers will come in to opportunistically watch the waders. You know what I mean? So there's a little bit of that. It's not. I think what I'm saying is it's not a consistent activity over time. There's a certain spontaneity to it depending upon how the birds are opportunistically reacting to their environment. Really, if that's
it's helpful.
Yeah, and also there's that whole wider Ramsar site as well to consider, that the head of Awarua Bay, so the isthmus between Awarua and Waituna, that just on the western side there, the head of Awarua Bay is a place that bird watchers consistently visit because you kind of know where you're going to get to a certain extent. It's tidal, if you go there at high tide, the birds will be roosting, and whereas Waituna is probably a little bit more dependent on whether it's open or closed, or so.
And I just have one more question. I'm scrolling through and I can't find it, but I know what the question is. So it's just about, you've talked about some of we've had some submitters talk to us or submit in their submissions about birds going onto their farmland and that being a real problem for them. And in your evidence, you've talked about, well, these are particularly opportunistic birds that will go and do that in any event, or that's how I've understood your evidence. I might have that slightly wrong. And I just wanted you to expand on whether or not this activity you think is going to cause more of that disturbance for the landowners from that bird perspective.
Yeah, my personal view is that it's not so much tied, that kind of occurrence isn't so much tied to the height of the lagoon. It's possibly an issue that's increasing over time and tied more to kind of exponential increase in especially Canada geese populations and also feral geese, feral grey-lag geese, and that's and I believe unless we kind of get some kind of control regime underway and coordinated approach, that problem isn't going to go away in a hurry, and it will probably. I don't think it's reached capacity by any means, actually. And I've flown over that wetland before, and lots of the townland that again is between Awarua and Waituna has small nesting, like loose colonies of Canada geese nesting on it. So, that's not really tied to the lagoon level. And those birds, they're feral birds. They've been introduced from North America, and in their native range, they're long distance migrants. They migrate out of the Arctic in the winter down to the plains of the USA. So they're capable of traveling huge distances. So to travel from those townlands to some nice fresh spring grass on any of these pastures is nothing. So again, I don't think that's to do with the lagoon level. I think it's to do with an increasing number of Canada geese in particular, and them opportunistically feeding on high nutritious grass. Really, that's my view. Yeah.
Great, thank you.
Thank you. Just a couple of questions, but one's a follow-on from that, really, actually. So will the changes proposed and the increasing water level and increasing habitat that we want, suggesting is needed for the bitterns, does that enhance the breeding opportunity for those Canada geese and black swans in the lagoon, and consequently increase those populations which you're suggesting are likely to occur and continue to be perhaps a problem? Or do they breed somewhere else?
Yeah, black swan tends to nest on builds a nest, fringing vegetation, and Canada goose too, sort of sometimes floating nests or sometimes Sometimes nests are actually quite far away from the water's edge. You know, they're fairly, and this is possibly why they're quite successful, is that they're fairly they've got fairly ability to nest in a pretty broad range of habitats, to be honest, even in forest, to be honest, you know, on the ground in forest, capable of moving quite long distances, precocious young that they'll move from the nest as soon as they hatch, really. So I would find it difficult to say whether it significantly increased opportunities for those birds to nest. I suspect they're doing pretty well nesting in all kinds of edge habitats here and there, and you know, yeah. So I would struggle to answer that. Yeah,
I think that answers my question. And my final question is really around. You might have heard we've had some terminology that talks about adaptive management, and one of the things I'm interested in is if we see an increase in particularly in say the swamp habitat, which you're suggesting would occur, and there'll be a better improvement for the breeding of the cryptic species. Yeah. What I'm getting at is, would it need to see an increase in predator control? Because we learned yesterday that does occur out around the lagoon. But would an adaptation also require an increase in predator control to achieve some of those multi-criteria improvements in the overall lagoon?
Yeah, it's an interesting question, and again, possibly quite a difficult one to answer. And just in a, it's you know, it's. I think if you can imagine at the moment, as far as we can tell, bittern is not breeding successfully around Waituna Bay, but possibly is around Awarua in that isthmus again that we're referred to. That's where we see them most regularly, is around the head of Awarua Bay. We do have Department of Conservation has long-term monitoring using acoustic reporting devices, so that you know there's measures in place for kind of trend monitoring and so on. Again, there's a lot of factors there. If you can imagine a bittern attempting to nest in the fringing wetland where currently the water levels fluctuate, possibly annually, they're essentially under stress already, you know, and so that exposes them to other risks, starvation. The nest, as we've discussed, could be flooded out or could be suddenly exposed to predation. These are birds that have adapted to nest in very dense vegetated environments where, you know, the nest is protected by camouflage, really. So I think if over the 20-year term, you know, that some of the aims of this, you know, the concerns were achieved in terms of restoring Awarua and restoring the ecosystem health, I think I don't see that would necessarily increase the need for predator control. I think you would, if bittern were breeding successfully, you know, you would essentially hopefully have an overspill population. We've always got to remember that we're talking about remnant populations in remnant habitats, really. You know, that's what we're talking about, the survivors, essentially. You know, you know, these birds would have been far more abundant in a couple of hundred years ago. Yeah, I think an increase in ecosystem health should increase all of the life chances, really, for those species, and including an ability to remain better camouflaged and keep their nests safer.
Yeah. Thank you. That's my question. Thank you. Yes, thank you.
My questions, just a couple. In the conclusion on page 13 of your evidence in chief, in 65, have you seen the draft conditions that I take it Ms. Williams is about to pass to you? I'm just checking that in conditions 5 and 6, you're happy with the inclusion, in my version it's in yellow, of the habitat for threatened and at-risk bird species during critical life stages?
Yep, I'm happy with that. I think that's.
What are the critical life stages?
Yeah, so again, it comes back to the point around primarily around bitter and cricks as well, and fern, but that nesting season, you know, that breeding season. So,
and then what monitoring's done or proposed to be done in terms of birds and that for the term of the consent relative to Waituna that's going? Are you aware of anything that's included within the conditions as to what monitoring's going to occur?
I'm not aware of anything that's additional to what's happening already, which is, as I referred to already, the use of acoustic recording devices.
Who does that?
That's the Department of Conservation. Yeah.
Department of Conservation does that, funds that whatever, and it does it in Waituna Lagoon?
Yeah, through the Awarua National Wetland Restoration.
And how often is it done?
Annual. Yeah.
When? Sorry.
Yeah.
When is? I mean, what month is it, and is that important for when you do it?
Yeah, it is important. Yeah, September to November, which is the peak period for booming, as we call it, which is the male bittern song. That's when they're defending their territories. It's called the boom. Yeah. It's audible over long distance. Sounds like somebody blowing over the top of a bottle. Yeah. And I believe that if that continues, which I believe is the plan, that would be adequate for.
So if you were doing that, and then what you would, how long does it? You've recorded these things, and then you go and listen, play the whole thing back again, I suppose. And then how long does it take to actually get something useful out of it that you could call information rather than just data?
Yeah, it's a good question, and that probably comes more into my professional role rather than the evidence here, which is drawn from my citizen science perspective. So we, as a district, we work in with the national Awarua team, and bitterns are nationally critical species. So there's a lot of interest in the sites which are considered to be of high importance, and Awarua wetland is one of them. The other two wetlands that are part of that AK scheme are Whangamarino and the other species I can find, but elsewhere in the country. So we work with the national team. We deploy the recorders. My team of rangers deploy the recorders, and then the data is analysed by the national team.
Right.
And I happen to know there's a lot of interest in making that less labour intensive through use of AI to analyse the call, and again coming more into my job. That's something that I'm kind of been working on a little bit to try and link us up better with the national team and to turn that data and information into ability to make management actions locally, for the sake of the species,
My question's about how long does it take once you've got the recordings to getting an answer, so that I can understand how it would fit into the conditions of consent by the applicants who say they're going to do all this monitoring. And whether that should be in a condition of consent. So I need to know, when you've got that, then when would you report that to the Science Advisory Group? When would you report that to Southland Regional Council as the regulator to demonstrate that it's been done?
Yeah, I understand.
So how long after would it be reasonable to, after they've done the work, and remember it's only the recordings in Waituna, because that's all we're talking about, just those ones. How long would it take to get that out?
Yeah, it's a reasonable question, and again, it's kind of out with my control to an extent, but I think it would be reasonable to have that within a year, within 12 months. So that, but bear in mind that this is about long-term trend monitoring, right? So this is, but yeah, certainly, it would be good within a year of those recorders being in to know.
So by November the following year, you'd know what the answer was.
Yeah, that's right.
Okay.
Yeah, and I would say as well, one of the difficulties with bittern is, and again, coming back to the kind of patchy data sets and so on, but when birds like that reach quite low densities, the male doesn't need to put a lot of energy into singing to defend the territory if he doesn't have competitors. Do you know?
Right.
So that's so we are looking at other means of monitoring as well. Passive listening being one of them in other areas.
My next questions are just around the actual gravel extraction opening sites where they're going to occur.
Yeah.
And are there birds that nest on that barrier? What kind are they, and when do they nest there?
Yeah.
And chicks and all that.
Good question. So typically, the species we would expect to see nesting there would be banded dotterel, variable oyster catcher. Sorry, variable.
Variable.
Yeah, the black oyster catcher.
Right.
Yeah. Mantis unicolor. And blackback gull. So
Blackback gull's protected.
Well, are they protected?
No.
They can be. Are they partially protected or
No,
not at all? They're a native species, but they're one of the two that aren't listed under the Wildlife Act, right? Blackback gull and
they're in the same schedule as the Canada geese.
They're a native bird, but yeah.
So these two birds, they nest on that barrier. When do they nest there and have brood chicks until they fledge and fly away? Is that how it works?
Yeah, that's right. Yeah.
So what period?
So banded dotterel can nest anytime from September through to February. That's highly vulnerable to disturbance and predation, and they will often be unsuccessful in their first clutch and re-nest. The incubation period is about 25 to 30 days, and then the young are precocious. So as soon as they hatch, their mum and dad herd them away from the nest.
Right.
So the period that there are eggs and young that would be vulnerable to the action of digger is actually quite small for each pair. The density is fairly low. You might have along a kilometre of coast, you might have 5 pairs, something like that.
Are they easy to spot?
If you know what you're looking for. Yeah.
Not in the same way a bittern is, but
yeah. They rely on camouflage.
Right. And so what about the variable oyster catcher?
Yeah, so probably at a lower density than banded dotterel, so maybe a couple of pairs per kilometre along that coastline, and similar life story, if you like. Nest in a scrape on the gravel, and maybe 30 days incubation, and then the chicks are away.
And is that September to February as well?
Yeah, in a similar period, maybe even a slightly shorter period, maybe more September to January.
September to January.
Yeah.
Does given when those birds are nesting, does that coincide with the times that the lagoons propose to be open?
Well, the proposal seeks for winter openings as a preference. So actually, that would, if that were the case, that's the optimum time of year for those species. Yeah.
So if there was an opening though between those periods, would there be any conditions that would require a survey, for instance, or something like that, to establish whether they're there or not? Given that they're what do you call them?
Yeah.
Some what threatened status do they?
Yeah, they both are. They both are at risk. Yeah. Banded dotterel was at risk declining, I think. So I mean, it wouldn't be bad. Well, it certainly be worth having a check. whether you write that into a condition or whether there's another way of managing that, but it's certainly worth having somebody who knows about birds just having a way check before the digger goes in. Yeah.
That's great. Thank you, Mr. Jones.
Thank you very much.
Thank you.
Cheers.
And next up is Mr. Erie, who is coming up. And Mr. Erie is not appearing as an expert, but is providing evidence to support the application. And he has also prepared a short summary of his evidence, which he's going to read. Before we do that, I'll just go through the thing. So, Mr. Erie, your full name is James Jonathan Erie.
Correct.
And you work for the Murihiku district of Te Papa Arawhai as a supervisor, heritage and visitor. And you have set out a brief discussion about your previous experience in paragraph 3 and 4 of your evidence. And you have prepared those talking points, and I will ask you to speak to those and answer any questions that the panel may have.
No problem. Awesome. Got it. So my name is James Jonathan Erie. I'm currently employed as a supervisor or the supervisor for the Murihiku Heritage and Visitor team. My team is responsible for the maintenance of historic sites, walking tracks, and numerous visitor sites throughout Southland, the Caitlin's, Southern Taiki Islands and Offshore Islands. We also facilitate visitor volunteer projects, and my rangers are the local site experts and ambassadors for DOC. The Waituna Lagoon site is one of our responsibilities, and our assets at Waituna Lagoon include a picnic area and toilet near the main car park, a boardwalk that leads to a covered viewing platform with interpretation panels, and a 4.5 kilometre loop track that also has interpretation panels along it. The lagoon is in a rural location. Access is via an unsealed road, and based on my team's observations and maintenance schedule, I considered the Department of Conservation tracks at Waituna to have low levels of visitor use. Outside a core group of users, the low use and low popularity of Waituna as a visitor destination has led DOC to prioritise maintenance at other locations recently.
Thank you. So if we've got any questions for you?
Yes, I only have a couple. The first is, you talk about the historical data showing only 1 to 2 people using the Waituna tracks daily. I want to know, how do you know?
Well, yeah, a lot of it's based on our observations when we're out there doing our maintenance, or when my rangers are doing the maintenance. It's also based on the historical sort of track, I guess, capture data that we have. So we stopped tracking visitor numbers in 2021 out of Waituna. I've looked back, and over 2019 to 2021, we do have numbers that we captured. And based on those numbers, and also, I guess, the reports of my rangers in the years from that time, they're very similar. So we don't really see a lot of people there at all. And yeah, very similar to what those captured numbers were between 2019 and 2021.
And when you say capture numbers, I mean, I presume you've not got someone standing in a bush.
No.
What is it? How do you capture it?
Yeah, so we've got pressure pads. So when people walk across those pressure pads on the tracks, it captures, one person passing through. So typically we have one pad at one end of the track, and when people go through, it captures them. If they come back the same way, it captures them again. So that gives us an indication of how many people are using our tracks.
Okay, that's helpful. No spies.
No one's hiding in the bushes.
My other question is, so do you currently use tools like measures like signage and seasonal closures, or to manage or restrict public access during sensitive times? So we just heard about the breeding habitat time, and I wanted to know, how does DOC usually manage access to sensitive areas in different times?
Right. And, for us, we use our DOC website a lot. If we need to get information out nice and quickly, we advise our web team, and they put a notification on the DOC website. We also use media, social media, to get messages out. We haven't used physical signs, as far as I'm aware in my time with Doc at places like Waituna. So we do rely heavily on our website and media.
And so, because I'm mindful that Doc, you're talking about Doc assets, and Doc's also the owner of, well, the manager of the lake bed. And so when this opens, I'm trying to figure out who's ultimately responsible for the health and safety of the lake opening as well. And how would does Doc then assign that over to a contractor to manage the site and prevent access, or do you actually close parts of the site during an opening? What's previously happened?
So perhaps I can speak to that.
Yeah.
So previously, for example, under those last, as I say, it was because the Reserves Act authorisation was required as well, and a condition of those authorisations was also authorising closure, so that the actual physical location where the opening was happening was closed, and a condition of the authorisation was that there was signage essentially to say you can't go beyond this point, it's not safe. I think there were also website alerts, as Mr. Erie has alluded to, that were put up as well, just to tell folk that that they could go into part of the reserve, but there was going to get to a point where they could not go in that next bit where that actual work was taking place.
And so the same would be said then if the lake was high and some of the, like the walking track, which we went through yesterday, is the lake's over it. So then it becomes closed, but you don't use signage, you use these other website based.
That's what, yeah, the most recent sort of period where we had to have it closed, that's what we did. We just relied on our website. We didn't put up physical signage.
Okay. Doc does have a closing and opening SOP for which is around temporary closures for health and safety and natural emergency, etc. events.
Okay, thank you.
Is the closure and how that access will be managed and whatever, and what signage and that addressed in the resource consents conditions?
Previously, I do think it's because Doc manages the lagoon, it's actually been addressed in the authority. It's something that certainly could be incorporated into the resource consent.
My question was, is it in the current conditions of consent that are before us?
I just don't know, I'm sorry, I just can't remember. It's something that we can address.
Just one question actually, and you might have responded to it through that opening and closing question of the track. In your collection of data that you've referred to, have you related that at all? And I might add you mentioned in one of your paragraphs, that it attracts bird watchers. I'm trying to get a sense of, do you have any sense or data on, do you get more of those when the lagoon is open and certain bird species being there, as we heard in from the last expert, or when it's closed and there's more open water again for a different range of birds? Any data on that?
No, it doesn't. No, it breaks it down month by month.
Yes.
Okay. The data I looked at between 2019 and 2021, but yeah, it doesn't differentiate really. It shows you, over February or whatever it might be, there's X amount of people. December there's this many, but it doesn't. It doesn't give you anything beyond that.
That's okay, thank you. It might be simply a weather related matter, but worth asking the question. Thank you.
Thank you, Mr. Erie. I don't have any questions. Thank you very much.
Awesome. All good.
So our next,
It's got 5 minutes. So what I'm hoping is that we can adjourn now.
Yes.
And that we can reopen it 10 minutes past, and Dr. Schellenberg can be online, and we haven't caught up yet. So just at the moment, we have Mr. Sims who's online at 4:30, and we're going to hear from Mr. Sims at 4:30. So Ms. Thorne, we might well be hearing from Ms. Thorne after We hear from Mr. Sims,
Sure.
and hopefully we'll get through everyone else before then.
Yes,
And if we start with Ms. Thorne before then, we will still break at 4:30 to be able to hear Mr. Sims because he's coming in online at that time, and then we'll go back. If it's after 5, we'll have a 15-minute break, and then we'll carry on to make sure that we get through everybody today.
That's great. Thank you for confirming that. The only other witness that has a slight constraint is Mr. Rebel, who has a family commitment at 4:30. So, but we should be through Mr. Rebel
You'd like
by then.
Yes. Fortunately, he's on immediately after Dr. Schellenberg.
Exactly. So we should be fine.
It should be fine. Yep. Okay.
Thank you.
Thank you. just before we have talked to Dr. Schellenberg, we have now got copies of the joint witness statement from the planners that came in last night, and also the joint witness statement from, I still haven't seen it yet, so the other group of experts, and Ms. Onke is going to pass those up to us now, and there's copies available on my left under the map. Yeah. Thank you very much. Thank you.
Great.
Potentially. Thank you, Ms. Williams.
Thank you. I'm just checking that you do have a view of Dr. Schellenberg on your screen.
Sorry, yeah, no. There we go. We do now.
Great. Thank you, Ahihahi Marie, Dr. Schellenberg. Your full name is Mark Schellenberg?
Yes.
And you've got a couple of roles. So you are the Director and Principal Scientist of Hydrosphere Research Limited, which is a company you founded.
Yes.
And you also are employed part-time by the University of Otago as an Associate Research Professor. And perhaps if you could just tell us in which department that is.
Yes, that's in the zoology department.
Thank you. And you've prepared a statement of evidence which is dated the 10th of July 2025.
Yes.
And in that evidence, you've set out your qualifications and experience in paragraphs 3 to 8 of your evidence.
Yes.
And do you confirm those?
Yes, I do.
And just as with all the other experts, referring you to paragraph 12 of your evidence, where you acknowledge that you have an overriding duty to impartially assist the commissioners on matters within your area of expertise, and that these views are your own views and you do not speak for the applicants.
Yes, that's correct.
Thank you, Dr. Schellenberg. If you wanted to perhaps start with your executive summary and then answer any questions that the panel may have.
Yes, I can do that. I'm not going to read it per se, because some of my colleagues have already touched on some of the things in my evidence, but I'd just like to read a brief statement that highlights some of the aspects of my evidence that haven't really been delved into yet.
Sure.
So numerous studies have indicated that the Waituna Lagoon ecosystem is under threat from high nutrient loads and from an opening regime that does not adequately account for ecological values and services. The aquatic plant macrophyte communities, especially the seagrasses Rupia, play a key role in maintaining ecological health. However, the aquatic plant communities seem to be in decline in recent years. Although intermittently open and closed coastal lakes and lagoons are vulnerable to rapid degradation, cumulative stressors have not yet resulted in persistent devegetation and a transition to a persistent degraded state in Waituna Lagoon. I view issues of degradation of lakes and lagoons within a stressor response framework. Stressor response relationships for shallow lakes and lagoons tend to be nonlinear, with tipping points being a common feature of their degradation trajectory. Tipping points occur when small changes in stressor levels can result in large changes in condition. Lake Ellesmere to Waihora in Canterbury is an example of a Waituna-type lagoon that tipped rapidly into a persistent degraded state in 1968. Other similar systems, such as Tomahawk Lagoon in Otago and Lake Forsyth, Awarua in Canterbury, undergo frequent shifts between turbid and clear water states. They are unstable and have occasional algal blooms that degrade ecological values and ecosystem services. algal blooms not unlike the one observed in Waituna Lagoon in January 2024, which was alleviated by an emergency opening of the lagoon. In addition to stressors and responses, there are also factors that can mediate the relationship between the ecological condition and a stressor level. In effect, mediators increase or decrease the ecological resilience to the stressors. Lagoon opening, the frequency and duration, mediates the effect of stressor levels on ecological responses. Openings are like a release valve in that they can somewhat reset the system when conditions are worsening and tipping points are imminent. Waituna Lagoon and its associated wetlands are part of a complex socio-ecological system providing multiple diverse values and opportunities to the communities around Waituna Lagoon. High nutrient loads from the catchment limit the opportunities to prudently manage the system because under current loads, movement too far and too fast towards a natural opening regime would present an increasing risk of cyanobacterial blooms and breaching an ecological tipping point. The task at hand is to manage the multiple values of the lagoon within the current constraints imposed by the leaky catchment. This requires careful use of the tool of lagoon openings as an ecological mediator between multiple stressors and the responses to the condition of the lagoon. A modification to the 2017 opening regime conditions, a modification to the 2017 opening conditions is sought, which would increase the water level trigger value towards a more natural opening regime, while also providing mechanisms to alleviate potential ecological stressors that could eventuate, such as extended periods of opening during spring and summer and prolonged periods of closure under the current high nutrient loads. The proposed opening regime is designed to shift the lagoon towards a more natural opening regime while safeguarding the lagoon's diverse ecological values while they are under threat from high catchment nutrient loads. The proposed opening regime is a part of an adaptive management process toward a more ecologically beneficial goal, supported by the monitoring of early warning indicators of degradation, by repeated reassessment of conditions and trends, and by the flexibility to open the lagoon for enhanced flushing and fish passage if required. That's the end of my summary statement. Happy to take questions.
Just before you do that, Dr. Schellenberg, and apologies panel, the other thing I did just need to cover off with you is that we do now have the very short joint witness statement from the conferencing between yourself, Mr. Measures, Mr. John Scandrett, and Mr. Rebel from Friday last week. And just if I could get you to confirm that you attended that conferencing and you've signed this and you are satisfied with the contents of that joint witness statement.
Yes, I am.
Thank you. Sorry about that.
So just a quick question on the joint witness. So this is dated the 24th of July, and that's the day that you met to do this?
We met on Friday, I believe. Right. So that was the 20. Wait, yes, I think it was Thursday, the 24th.
Right. And it was signed on the it's signed on the 24th. So you did the conferencing and signed it all on the same day?
Yes.
Yeah, no, excellent, thank you. Just before we go to questions, the summary statement you have, are you able to forward that to Ms. Williams?
Yes.
By email, and then she can pass it on to Ms. Onko here, and then we've got a copy of it. That way I haven't been scrawling notes as quickly as you've been writing, so I'm just trying to make sure that we've got a hard copy of that. That would be helpful.
Sure, I can do that.
And if I could actually ask Dr. Schellenberg to please forward that to Ms. O'Connor, who is sitting behind me with the laptop, and who will then make sure that that gets to Ms. Onko.
Yep. Okay. No, that's helpful. Thank you. Questions? Yes.
Thank you, Dr. Schellenberg. Hope you can see and hear us okay.
Yes.
Thank you, thank you. Yes, I've got 2 or 3 questions. One I'd like to sort of clarify. I don't know if you've been listening in on the earlier witnesses.
I have, yes.
Thank you, because there's one question that's rolled over to you from one of them, which I'll come to in a moment. But just in your written summary for your evidence, and you mentioned it in your dialogue just now, you just clearing up some terminology really around the term of an adaptive management. That generally has a particular meaning in the RMA world and in my mind at least, which would normally be a suite of monitoring, which is suggested here, and then arguably a suite of responses which adapt to particular monitoring results, if you like. So I just want to clarify with you that your understanding of adaptive management in this particular application only relates to the opening and the timing of the opening of the lagoon, or is it another suite of management responses that we haven't heard?
Well, I guess when I wrote that, I was looking at a bigger context because I was involved in the 2013 guidelines that were developed for Waituna Lagoon, which was really specifically around the nutrient load problem and the threat to the aquatic plants in the lagoon. And in response to that, there have been some actions in the catchment to try and reduce the nutrient loads to the lagoon. And then there's been this further movement to look at the opening regime and to see if the opening regime could be made a bit more ecologically friendly. And so within that context, I sort of see this particular consent application as part of a broader sort of adaptive management framework. Although I suppose it's not really in a formal sense an adaptive management framework as maybe what you're referring to, but I just sort of see it as an extension of a general process which seems to be trying to be more ecologically friendly and protective of the environment.
Okay, thank you. That does answer the question. But in this particular application, it is only about the openings of the lagoon itself.
Yes, it's about this consent application and the openings, yes.
Thank you, thank you. That just confirms that and clarifies that. And then just turning to a question that I asked Mr. Winton, which was regarding a comment or a paragraph in her evidence about the potential for the lagoon to flip under the circumstances of a high algal bloom dominating over a macrophyte dominated ecology, if you like. My question was, can it reflip back, and what's the kind of time frame if that were to occur?
It can reflip back. So in some of these systems, as I mentioned in my summary, some of them do flip back and forth, but others seem to be persistently within a degraded condition. And I don't think we know enough about what specific characteristics relate to those two different behaviors, whether they get stuck and locked into the degraded system for a long period of time or whether they flip back and forth. So I wouldn't be confident enough to say which behavior Waituna Lagoon would follow if it did flip. Yeah, that would be dependent on a number of things that it would just be too speculative, I think.
Okay, thank you. That's fine. That's helpful. And then actually, funny enough, you mentioned in your dialogue, as I said, your opening statement, and that adaptive management about another suite of mitigations in the catchment. Just coming back to that, actually, because you do mention that, I think in paragraph 27, I think it is, some agricultural mitigations. Is it your understanding that those mitigations are progressing in the catchment? And over time, would that change the level of the triggers that have been put in place if they were to improve the water quality?
Yes, so I'm not I'm not current with what the mitigations are that are currently happening in the catchment, but I understand that after that 2013 guidelines report came out, there was a lot of effort being made to try to curb the nutrient and sediment loads, and that some headway had been made against those, but it was more in the range of 10% of the nutrient load could be mitigated rather than 50%, which was what the scientific studies suggested would safeguard the lagoon. And sorry, there was a second question, I think, was follow up on that.
Oh, just would it change the triggers
would it change the triggers? Yes. Well, I mean, the reason I raised that is because there is this desire to move it towards a more natural opening regime, and I see the leaky catchment as a constraint against that. And so basically, to me, the lagoon is between a rock and a hard place. People would like it to go to a more natural regime, but because the catchment is leaky, it can't. It would be too risky. And so obviously, if they could reduce the nutrient loads to the lagoon, then that would provide more options in terms of returning the lagoon to a more natural opening regime without risking it tipping over.
Okay, thank you. And I think I might have one more. Let me just check. Yes, the joint witness statement, which you agreed on the circumstances, I think, if I read it correctly, of high water levels reduce the effectiveness of land drainage networks, which was the gist, I think, of the agreement that was made. So thank you for that. But under those circumstances, does that exacerbate the release of those nutrients into the water and therefore contribute to a worsening of the water quality at those high levels of the lagoon?
It can do that, depending on the nutrient levels in the soils that get flooded. So it could exacerbate, at least in the short term. If it were a wetland that we were talking about flooding, as part of the lagoon shores is wetland, I would suggest that the wetlands could help absorb some of the nutrients in the water. But if it's agricultural soil that has high nutrient levels in it, it could contribute nutrients to the lagoon as well.
So if I understand that correctly, that could mean that the high water level may actually create a worsening situation in the lagoon, in the open water in particular.
I would assume that it would contribute some additional nutrient load to the lagoon, yes.
Okay, thank you. I think that's me, thank you.
Kia ora. I have a number of questions. My first question is understanding the flip or the algae situation, and I asked a question of Ms. De Winter where I was trying to get so it's slightly different than Commissioner Boothroyd's question, whereas he was saying if it flips, can it flip back? I was saying, if algae bloom was identified, how long does it take for it to become a real problem for the plants like Rupia and some of the fish species that don't live well in an algae bloom scenario? And does this consent work well to respond to that from a timeliness perspective?
Yes. So how quickly I think that what you're asking me is how quickly the collapse could occur if it breached the tipping point. Is that your question?
That is it, because
Yep.
what I heard from Ms. De Winton was it's the cover. That means they won't
Yes.
get light, and it
Yes.
will actually cause irreversible loss.
Yeah. So that can happen very quickly, but it really depends on the mechanisms, because there are multiple stressors, and then there can also be disturbances that can tip the system over. So a system that is stressed might tip over because of a natural type of disturbance that could occur that in a healthy system wouldn't tip it, but it could tip it. So I think Lake Ellesmere would be an example of that, where there had been increasing agricultural development in the catchment, increasing nutrient loads. And then it was a storm that actually was the final thing that tipped the lake over. It was the Wahine storm in 1968. So you have this sort of stochastic environmental variability and the disturbances that happen naturally laid over this sort of increasing stressor level. And as to how rapidly it could degrade, the macrophytes could collapse. It really depends on what that ultimate mechanism is that causes the collapse. I would say, and like Ellesmere, it was from 1 year to the next, it was changed. It could potentially be slower, but it's not something that's easy to predict because of this stochastic, weather effects and other things, and multiple stressors. Sort of, you could end up with 1 year where you have very high temperatures combined with high ammonium in the lagoon, and then bang, it just happens. So it's hard to predict exactly how that would occur. And but let's say that there's a range of possibilities from virtually immediately, like within months or a year, to maybe stretched out over a slightly longer period of time. And I do believe that the flickering back and forth can be an indicator of approaching a condition where you do have a persistent, eventually have a persistent degradation occurring. So we've already seen Waituna Lagoon have some years where the macrophyte, the indicators for macrophytes have been extremely low, that the cover and biomass has been extremely low. It's bounced back again, but to me, that's an early warning sign that the system is not healthy.
My very next question to you was, well, what are the early warning signs? So you've talked about the plant growth, being strong and weak being an early warning sign. What are the other early warning signs? Or is it unpredictable?
Yeah, so I think the indicators that are the primary and secondary indicators were selected to be key early warning indicators. The ones that tend to be really important for these sort of coastal lagoons are mostly around nitrogen. So the nitrogen load is quite strongly correlated to seagrass collapse, rupia collapse. And nitrogen concentrations also seem to be correlated with a change between a macrophyte dominated system to a phytoplankton dominated system. But all those other indicators are useful things to examine while you're trying to assess the risk, because they also contribute.
No, that's helpful. So having those test gates of primary and secondary and the resource consent will actually start to give the signs, the signals.
Yes.
I have a specific question on so section 8, so paragraphs 26 and 27 of your evidence in chief. That's where you do talk about nutrient loads, and you say that they're still above safe levels even though there's been some improvements. And you've answered questions to say, well, are there the catchment actions that are making a real difference? So that's answered, but I wanted to know, is the focus now mainly on lake opening? Is that the fundamental work that's going on at the moment?
To me, it's another tool in the toolbox. As I mentioned, the opening to me is like a mediator between the stressor response relationship. If we think of stressor as nutrient load and response as the macrophyte community health, that opening regime I see as a mediating factor, and it's something, because we can control it, we can use it to our advantage to minimize the impacts of the catchment, the leaky catchment. Does that answer your question?
Yes, that's
okay.
Helpful.
Okay.
My next question actually, it's back on paragraph 24, where you're talking about the key values in the ecosystem. And you talk about the key ecological values, and you list what would be most at risk if the lagoon were to tip into a degraded state. And I just wanted to know here, in kind of simple plain English terms, what is really most at risk? Because we've got evidence around plants and fish and birds and mihinga kai, and we're trying to balance them all. But is there one factor that's more at risk than anything else?
Yes, I think there is a key factor, and that is the rupia, basically the macrophyte communities, because these are known in limnology and lake science as the factors that confer resilience to a system to nutrient loads. But you can oversaturate that resilience. You can by putting too much nutrient in, you can collapse the macrophytes, and then the benefit of the macrophyte communities and keeping suspended sediment levels down and competing with algae for nutrients, all of that is lost when the macrophytes collapse. And so you end up in a different regime, which has its own set of feedbacks and makes it very difficult to get it back again. So to me, it's always been about the rupia in the system. And we've seen from looking at the other similar systems along the east coast of the South Island and North Island, is that when those macrophytes collapse, that's when the system really degrades, and often degrades in a persistent way.
Right, thank you.
Thank you, Dr. Schonberg. I've just got one question on your evidence in chief, and then just something about the joint witness statement. Paragraphs 28 and 29 on page 9 of your evidence, you talk about resultant algal blooms in the lagoon, and is that stuff sort of spreadable by I don't know, recreation users using the lake? That I'm kind of thinking, being from the North Island, like Didymo, and there's biosecurity stuff in relation. Is that are the same risk pressures with the kind of algal bloom that you get down there? Is that the same or similar, or is it different?
Okay. Well, I think there are two different types of blooms that are problematic for a system like Waituna Lagoon. One is a phytoplankton bloom, and that's microscopic algae like the cyanobacteria that can cause problems in these sorts of lakes. And I don't think they're a biosecurity problem. I think they tend to be pretty widespread in systems that are degraded and probably get transferred around from water body to water body by waterfowl, just microscopic organisms, some of which have resting stages, so they can be quite hardy and they can be transferred. The other algal risk is really about the macroalgae, is about things like sea lettuce, which can bloom as well, and they can smother the macrophytes. I also don't think those are necessarily like risky from the point of view of them being transferred around, because they exist in a sort of estuarine and ocean environment, and they are probably already spread quite widely amongst the different lagoons and estuaries around the South Island.
Thank you.
Oh, yeah.
Okay. In terms of just referring to the joint witness statement that we've just received, I haven't read it, but can you, as one of the signatories, can you tell me, does this alter anything in your evidence in chief at all?
No, it doesn't. I think you know, it just basically I guess makes the argument, or no, states the fact that when the water levels of the lagoon rise, they flood land, and But not only do they have an effect on the flooded land, they affect the land, a certain amount of land upstream from the flooded land in terms of the way it drains water. And so that witness statement was really just, I guess, clarifying that this effect does extend beyond just the flooded land, but that the flooding effect is also impacted by how well by the size of the drains, by the density of drains that are in the farmland, and by how well they are maintained. So I think that's basically in a nutshell what that joint witness statement says.
Okay, thank you. Just to let you and the other signatories of the joint witness statement in on that the Environment Court practice note, it does move on, so it's 2023 these days.
True.
And it's not section 9.4 that you want to be referring to, duty to confer. So just for
Okay.
next time.
Okay, thank you.
Thank you.
Yes, it's section 8.
Okay. Oh, sorry.
So thank you again, Dr. Schellenberg. Just drawing on your experience, I asked a question of Ms. Williams earlier, and it's a crystal ball gazing exercise, and I'm just trying to understand kind of what is an endpoint of this. And if we were of a mind to grant a consent for 20 years and everything went well, and the leaky catchment achieved the objectives, I think you mentioned 50% or better, and there was a strong resilience in the lagoon, what would happen then? Would that create the opportunity to dial back to a lower, I was thinking of, water level for opening the lagoon, because you wouldn't have all of those stressors acting like they are? And I'm just trying to understand what that might look like at that point in time, that end point, if a consent was granted for 20 years and everything went well.
Well, I think what that would do is give a lot more opportunities for how you manage the system, because it wouldn't be proverbially between a rock and a hard place quite to the extent that it is now, where if it's open too much, then we have a certain type of risk. And if it's closed for too long, we have another type of risk. And no matter what direction you want to take it in, some people want to take it back to a natural opening regime, which is higher water levels. Other people might want to take it to a lower. We are basically stuck at the moment with trying to balance these things. And if the catchment nutrient loads weren't as high, that would provide more opportunities, I think, to do things with the opening regime.
Okay. So it kind of might be if that was the case, it might be a kind of short-term, 20 years, not necessarily a short-term, but a short-term pain for a kind of long-term gain.
Yes.
Yes. Okay. Thank you.
You're welcome.
Excellent. Thank you. Thanks, Dr. Schellenberg.
My pleasure.
Thank you, Dr. Schellenberg. So the next witness is Mr. Rebel. Now, I'm just going to try and get the right evidence statement.
That's always a good start.
Indeed. Right, so Mr. Rebel, your full name is Ashley David Rebel.
That's correct.
And you have changed positions actually since your evidence was prepared, and so your current position is actually shown on the timetable, which is Environment Southland Science Investigations and Operations Manager.
Yep, that's correct.
And that is a change from the role that is set out in your evidence, which was where you were acting manager, Science Investigations and Operations. So you've been confirmed into the role in the interim. Thank you. So you have prepared a statement of evidence dated the 11th of July 2025.
I have.
And at paragraphs 3, with that amendment in terms of your current occupation now to 8, you have set out your qualifications and experience in relation to this matter.
Yes.
Then at paragraph 12, and again acknowledging that you are an employee of Environment Southland, which is one of the co-applicants, You, however, acknowledge that you have an overriding duty to impartially assist the commissioners on matters within your area of expertise, and the views you express are your views, and in particular, you do not speak on behalf of the applicants, and especially Environment Southland and this evidence.
Yes, I agree.
Thank you. And again, you also are a signatory on this joint witness statement that we've just had provided, together with Dr. Schellenberg, Mr. Measures, and Mr. John Scandrett.
Yes, that's correct.
And you have signed that, and again, you prepared to confirm that the statements in the joint witness statement are ones that you are satisfied and agree with.
Yes.
Thank you. If you could read your executive summary and answer any questions.
Of course. So my evidence provides context and understanding of how the proposed consent will manage and respond to water quality in Waitangi Lagoon. It outlines the current water quality status of the lagoon, describes observed changes in water quality after open and closed phases, and explains the water quality related conditions proposed in the consent that would allow mechanical openings to occur. Waitangi Lagoon has a long history of being mechanically open to the ocean. These openings have resulted in two distinct water quality states, open and closed phases. During open phases, a flushing effect occurs where exchange of incoming seawater and outgoing freshwater improves water quality across most measured parameters. In contrast, during closed phases, the lagoon becomes isolated from the sea, leading to accumulation of nutrients and contaminants and a general decline in water quality. Applying National Policy Statement for Freshwater Management 2020 bans to the lagoon during closed phase, total nitrogen, phytoplankton, A, trophic lake and disease are all classified in D band, while total phosphorus and common cyanobacteria are graded as C band. During an open phase, total nitrogen, chlorophyll A, so phytoplankton, and trophic A indices improve by 1 grade to C band. TP remains unchanged, so total phosphorus, and planktonic cyanobacteria improves to A band. Regardless of whether the lagoon is open or closed, E. coli consistently remains in A band. Appendix B of the consent to the proposed outlines water quality triggers for opening the lagoon openings using both primary and secondary indicators. Primary indicators reflect risks to ecological or human health, while secondary indicators highlight deteriorating conditions or potentials for algal blooms. Under condition 5, the lagoon may open when critical levels are reached for primary indicators with flexibility to consider other ecological values and supporting quality data. Excuse me. The proposed monitoring plan is part of the proposed consent for water quality applies methods consistent with Environment Southland's current state of environment monitoring. While it's simplified compared to those, it is expected to provide sufficient information to guide decisions around lagoon openings. All the proposed conditions of the consents are not just tailored to target water quality outcomes. If granted, the consent should not result in further decline of water quality within the lagoon.
Could I remind you, sir, please, to speak up when
you're
asking questions and all
Yeah.
that. It's hard for people to hear. I'll go with the first question, and just as the same as I did for Dr. Schellenberg, does the joint witness statement change anything in your evidence?
No, it does
No,
not.
okay.
Yeah, I do have just a couple of questions. You talked to the trigger levels that have been put in place. I just wonder, because I wasn't clear to me how they were derived.
So those trigger levels were derived looking at the history of monitoring data in the lagoon as well as the National Policy Statement attributes. So it was kind of a marrying together of what historically has been seen towards the upper end of values within the lagoon and comparing them to what, say, national bottom lines are in the national policy statements. So it was weaving those two together to come through with something that reflects the lagoon and national policies.
Okay. So they just agreed amongst the science advisory group.
Yeah, so they
worked out of a book or a list or a standard.
No. So they were developed in conjunction with some of the advice that was in the science advisory group document that's part of the proposal.
Cool, thank you. And you said the upper level, you mean what, in the kind of 90 percentile or something like that?
Approximately. It's difficult to calculate specifically because of the open and closed phases. So it's, within those realms.
Well, that's helpful. I just wanted to know kind of where that had come from. So that's really helpful. I asked a question earlier actually about who will do the work, and I think that was, I don't know if you were in the room when that was responded to.
I was.
Yes. So my understanding is that that's a shared responsibility, but the water quality is Environment Southland?
I can't specifically speak for Environment Southland in the case, but Environment Southland has the expertise and has historically done it. So from my understanding of and the agreements that will be held between the agencies, Environment Southland will likely take those.
Okay, thank you. And I'm not sure you're the right person to ask, but when it comes to the information, the data that's gathered,
yes.
What will happen with that? I mean, will the community have access to that data readily for their own viewing of it all and drawing their own assumptions from that data?
I believe so. So anything that Environment Southland collects under the State of Environment work is open and can be requested at any time. I haven't been aware of anything that says that the consent monitoring might be disclosed to the community, so I believe it is.
Sure, that's something you might be worth thinking about.
So does somebody have to go through official information request and all that to get that state of the environment? Or do
there are data
just
requests.
send an email to you as the head of that department and asking you to send it to them? I'm just, how does it work?
There's essentially two routes. One is data requests by people that we're working with. The other one is official information requests. And if there's just generally sent to Environment Southland. I'm not sure how it would play out in this consent though.
Something might be worth thinking about because it strikes me that transparency and accessibility might be of merit. So
if I can just speak to that briefly, so there is the communications management plan which addresses that, and that's probably more a matter that Ms. Thorne can speak to.
Okay, thank you. That would be helpful. And perhaps my last one is again to the monitoring. We learned yesterday. We were out on the lake and looked at the monitoring sites actually, which was helpful, including the central one. And we understood how the data collection occurs, and some of that's continuous for the water level. I've just come to the dissolved oxygen one, and it's a bit more technical question, I know, but that was a kind of data logger, as I understood it, which is downloaded once a month.
Yeah.
So it's not so continuous. So there's a bit of a lag between the level and that particular data collection.
So the logger is taking measures at a very small interval at all points during that time, and then it's visible once it's downloaded, but during that period between the data being downloaded as monitoring, a fairly continuous frequency. So there is just a slight lag before we download.
It's a month.
Yeah.
Really, between that level. And is that sufficient, or is there a plan in place that if a water level triggers something, you go out and get that data perhaps after a week or two?
Yes. So I think in the monitoring plan, I believe there was actually some stuff around increasing the frequency of monitoring in response to changes observed in the lagoon. That would also be collecting the monitoring data from the logger.
Thank you. I did see that in there, and I think that sort of confirms that. I'm just want to understand. I call it the lag before the SAG, if you like. So the lag time before the SAG gets the opportunity to make a decision from critical primary and secondary. The question earlier between the annual macrofile monitoring could be months before some opportunity to have a look at that. And that just seems inadequate to a little bit to make those decisions.
Yeah, so there are operational constraints on when we can actually access, say, laboratory testing, because the closest available laboratory that does what we require for this kind of stuff is based out of Christchurch. So there is a shipping time and a turnaround time, plus the lab tests take time to be undertaken themselves. And then there's just a little bit of validation due. But typically on discrete water quality monitoring like this in here, that's not from a logger, we can look at about a week's turnaround. So it's not immediate, but there are tests that require time.
That seems reasonable in my mind. But other ones seem a lot longer. But thank you for that. And just a final question again. Sorry.
A week or weeks?
So a week is typical. We can request expedited testing if required.
Yeah. Sorry, I just couldn't hear whether it was you were saying it took weeks or.
Oh, sorry. Apologies.
No. Thank you.
Lost my train of thought now. And the other monitoring I noticed is in the triggers was eDNA. Yes, which we haven't really heard much about in the discourse so far, or even really in the much of the application. But it's sort of in the triggering. Makes good sense to do that. I understand that sort of monitoring technology, if you like. I guess what I'm trying to understand is that a regular monitoring, is that proposed as a regular monitoring or in response to a particular finding?
It would be in response to any form of algal bloom that suggests that we would need to consider that. Yeah.
Okay, thank you. That's helpful to know. I think that's probably me.
Kia ora, I have quite similar questions, but slightly different.
Okay.
So just starting from the monitoring side. So what I got a real good impression of yesterday when we were out on the lake is that we had to sometimes take the boat in different paths because the lake level changes so much around, within the lake itself.
Yes.
I wanted to know that monitoring site, is that in a shallow or deep part of the lake?
I believe there was 4 monitoring sites proposed, so it was spread across the lagoon. From memory, they were representing 4 of the monitoring sites that we have. So east, west, kind of north and central.
So how do we know when it's 2.5? Is it an average before?
Oh, sorry, so water level. Oh,
Sorry.
yeah.
Water level's not
Yeah.
a gauge.
Oh, so the water level gauge. So that.
Because you've only got one site for that.
Yeah, well, there's one site for that gauge, but there has been a lot of historical work in figuring out how representative that is and what that means for other portions of the lake. Noting that there is some variability and that there is mobile sediments in there, but it is our point of reference.
And so then, sorry, I should have said that was the gauge on the bridge.
Yes.
And then if you go to the site for the water quality,
yes,
that used to have, my understanding, there used to be a level gauge there as well, but it was removed because got all of it. It was essentially to figure out wind shift.
Yes.
And to get data for wind shift.
Mm-hmm.
So do you feel that you confidently have all of that wind shift data now that only one gauge is needed?
Yes.
And is that with you? Is that data held with you, or is it held? How is it held? Or is it held with SAG?
No, these reports by Environment Southland in space. Yeah, historic. Yeah, I can't remember when they were done. It was prior to my time being here, but we're doing
But that gauge is delimited and
yes,
straight through to Environment Southland, and then do you have it goes on your website like other regional councils and.
It goes on to Whakamana Te Waikare's website as well. Right.
Yep. Okay. Can I ask a related question to that? In the conditions it says that it used to say if the gauge you weren't going to use the gauge at the bridge, Waghorn Road Bridge, then you'd use an alternative with the approval of council.
Yes. Someone's
changed that to just say with the certification of council. I have to say that I don't know what the difference is, but I'll get to that when I talk to the planners. So if you're not going to use the Waghorn gauge, which one are you going to use?
I'm not sure. Sorry, I'd have to get back to you on that one.
So
yeah.
So then my question.
Yes.
Sorry, your answer means that, well, if you're not using that one, which one are you using, and where is it?
No, so we only have the one currently.
Right. Yeah. Okay. Thank you.
My other question was also related to timeframes. So I think we've got a picture of you get the information, takes about a week to get to turn the data into information.
Yes.
And it's at paragraph 28 of your evidence in chief. You talk about that the SAG must advise within 5 days of whether or not there's going to be a lagoon opening. And so I wanted to understand the operational effectiveness of this consent. So what happens when and how long does it take to respond? And is that response enough, particularly, is that timely enough, particularly in an algae bloom breakout situation?
So depending on the algae bloom, like an algae bloom isn't necessarily homogeneous across the entire lagoon. It may be that we identify an algal bloom in a set location and then there's time before that propagates throughout the lagoon and has an impact on other ecological parameters, in which case this would very much be the case. And given how the monitoring schedule is put forwards, we should be able to be ahead of the curve in terms of how that happens.
Thank you. My next question is, it's in relation to your section 5, which is the comparison of the impact of the proposed consent compared to do nothing.
Mm-hmm.
And it's a question that I actually asked, I think it was Ms. De Winton, and I'm sure she said it would be more appropriate for you, if not.
Yeah.
Wrong person. But going back to that, the closure period, and it was spoken of being a real world test of what would happen if the lagoon isn't opened,
mm-hmm.
and that it resulted in this, great result for Rūpia. And I wanted to know, well, are there other world effects that could have actually given that outcome? Like was there a difference in rainfall, or was there a difference in nutrient input or catchment management? Did anything else happen that was significant in that time frame?
Not that I'm aware of or we've specifically analysed.
Right. Okay. Thank you. Next is paragraphs 38 to 40, where you're talking about agreeing with the section 42A officer response. Oh, this is a discussion on suspended sediments.
Yes.
And I wanted to better understand how that process works and any additional insights that might be really helpful to understand what happens during that lagoon opening regime with suspended sediments.
Itself. So we have noticed that the Environment Southland monitoring data shows that when the lagoon does open, there is an increase in total suspended sediment. The actual mechanism for that occurring we haven't defined, but is likely due to tidal motion and fine particulate matter that's deposited on the bottom being resuspended due to increased energy in the lagoon. And so just capturing to what extent that does would be helpful in understanding what the impact could be from an opening.
So that is going to be monitored as part of the...
I don't believe it was in the proposed conditions. It'd be up to the applicants to decide.
Is it critical to be monitored?
I don't think it's critical. It's just further understanding.
So nice to have.
Yes.
My next question relates to the November 24 report. So I'll make it quite broad rather than... Well, it's paragraph 4 and 5. So that's quite a small report. And it's actually paragraph 3, and it was talking about the modelling of the nutrient loads during the recent lagoon opening and found them to be higher than most other estuaries in Southland. And I wanted to know, well, what does that tell us for this? Why is it higher, particularly higher here than all of the other Southland estuaries?
We haven't delved into the exact reasons, but it's likely because there is a closed period of this lagoon that allows for build up of nutrients, and then when it's open, it becomes an estuarine environment. It's got that legacy effect essentially.
Related question to that, well, part of that, not related to that, but part of that report, you also go on to say that there's no direct modelling of the marine environment, the receiving environment, and I wanted to know, and you've said, so I just want to know, well, how confident can you be that opening in Walker's Bay won't actually cause any environmental harm to the receiving environment? If there's no data collected.
No, I guess it's based on a way like how big the lagoon is and how much nutrients there are in relation to what's in the ocean and the tidal and current flow across that location. Fogo Strait is one of the fastest moving currents around. So there's fairly quick mixing of anything, and it would dilute, is likely to dilute anything really quickly. And just, suspended sediment and what have you would be deposited across quite a vast area. It wouldn't be in amounts that you'd expect to create an issue.
Great, thank you. I have one final question, and that's in regards to the monitoring observations. So in the further information, so it was a supplementary that was provided to us about the effects from the opening event. And in that you refer to condition 20 allowing the alternate sites to be open. And I just want to know from your observations, like what makes Walkers Bay at this point the preferred site, and are the other sites, how likely is it that you need the other sites, and do each of them actually respond to a different need or not? Do they open, for example, does one close faster than the other, and is that really important for what?
Okay, so the first part of that question, Walkers Bay was identified in modelling done by David Hamilton in about 2012 as being the area that increases the likelihood of flushing. So it's going to have the greatest impact on water quality, hence why that's put there. The other couple of locations, I believe, are due to operational requirements and considerations around access and what have you to locations. I'm not sure about closing frequency based on different locations. Sorry.
Okay, great, thank you. That's my questions.
Thank you. Thanks, Mr. Rebel. So, having made the decision that the lagoon needs to be opened, how long does it take to release the diggers?
Apologies, that's beyond my expertise. I'm not in operational matters for that kind of stuff.
Right. Will it now fall under your, now that you're in that job?
No, so my role is science operations.
Science operations,
yeah,
not
so
operations.
Not
operations.
okay, in total.
No,
That's
thank you.
the scientists and the nerds.
No, thank you. In paragraph 31 to 34 of your evidence, page 12, you refer to the various frequencies of 4 representative sites and that in terms of the monitoring. Is that reflected in the conditions at all?
I don't know if it's reflected in the conditions. Sorry, that might have to be something for Lisa or Ms. Thorne, sorry. But it is reflected in the proposed monitoring plan.
I'll probably have a conversation with them about the difference between what's in monitoring plans and what isn't. Right. And then the same for something like the dissolved oxygen monitoring and all that that's currently being undertaken that we saw in the roughly the middle.
Yes.
There.
Yeah.
The teeth. Again, is that reflected in the conditions?
So the stuff that's currently occurring is state of environment monitoring, but the proposed monitoring plan is to have some monitoring in that location.
Mm-hmm.
Whether that's in the conditions again would be.
No, excellent. Thank you. Cheers. So, Mr. Measures, and we're Ms. Hope's got a very short summary statement, and we can spend more time on questions. Yeah.
Indeed. So, Mr. Measures, sorry, let me just find the right piece of paper.
And worst case scenario, if we complete with Mr. Sims, it'd be nice to know whether Mr. Measures would be available at 5. Mr. Sims is running to time.
So, Mr. Measures, the commissioners are just asking, we've got an online submitter who needs to present it at 4:30 and just wanting to check that you would be available at 5 o'clock if we don't get through your evidence.
Yes, that's fine, yeah.
Thank you.
Thank you, Mr. Measures. So just confirming your name is Richard John Measures.
Yep.
And you are currently employed by Earth Sciences New Zealand, which is the successor institute to NIWA as of the 1st of July this year, and your role is as a hydrodynamics engineer, sorry, hydrodynamics scientist.
Yes, that's right, yeah.
And you've set out, you've prepared evidence which is dated the 11th of July 2025.
Yes.
And in that evidence, you've set out your qualifications and experience in paragraphs 3 to 12 of your evidence.
Yep.
And as with the other experts today, you confirm at paragraph 16 that you have an overriding duty to impartially assist the commissioners on matters within your expertise, and your views expressed are your views and you do not speak on behalf of the applicants.
Yeah, that's correct.
Mr. Measures, I will then ask you to potentially read, if you want to read your executive summary, or perhaps actually maybe just answer questions.
Yeah, I can just give a very quick sort of bullet points. So basically my evidence covers sort of 4 points. So it covers the assessment of inundation and land drainage impacts, which I did there's a report describing that, which is an appendices to the application that was done in 2015 to 2017. I then, my evidence covers the validation exercise I did last year. So validating the inundation and drainage assessment against drone imagery of the areas around the lagoon edge from a period of high water levels. And then I talk about the technical workings of the Waituna Lagoon water balance model and the peer review I did of that, concluding that it's good and it's fit for purpose. And then the final part of my evidence just discusses the impact of lagoon opening on erosion and sedimentation, and that was added as an addition to the evidence in response to some of the questions raised in the technical review. So I'm happy to answer any questions about any of that. And then I guess the other sort of relevant thing is the joint witness statement, which really covers some of the points relating to the mapping of drainage affected areas under different lagoon water levels, and there was some overlap between my evidence and the evidence of John Scandrett, and that's the joint witness statement kind of confirms that we're largely in agreement. So yeah, happy to answer questions on any of that.
Thank you.
Kia ora. So because I haven't had the opportunity to read the joint witness statement, I did have questions that were prepared to test that. So I'll just go ahead and do that in any event. So the first one in regards to that was around your paragraph 32 and your statement of evidence. And in that, you model the map drainage influence based on proximity to the creek and the lagoon. And because Mr. Scandrett noted that even drains from a higher ground lose effectiveness when the outlet's submerged, and it all depends, well, from my understanding of his evidence, that the hydraulic gradient's pretty critical in that. And I wanted to know, given that evidence, do you think it's possible that the lagoon backwater pressure could travel further upstream than was modelled?
So I guess, so the way that we modelled the impact of different lagoon water levels on inundation and land drainage was we we used LiDAR data for the ground elevation, and then we extended a different water surfaces sort of intersect with that to map the areas that are directly inundated by the lagoon. And then we did models of the creeks draining into the lagoon, because obviously those creeks have a sloping water level, and we could see the backwater effect of different lagoon water levels on the creeks under different flow conditions. So that gave us the sort of water level in the creeks and the water level in the lagoon, and how that intersects with the land to directly inundate areas. And I think that's that validates really well. There's very low uncertainty in that. And then to map the extent of what we call drainage affected land, we took quite a simple approach, and we said that land within 1 or 2 meters vertically of the lagoon water level, or the creek, the closest part of the creeks to any given land, would be affected by reduced land drainage. And that was to account for this effect of the flow rate of tile drains being reduced. So the ability of those tile drains to remove water from the land would be reduced, and the land would be wetter as a result. And the reason we considered the 2 different thresholds, the 1 meter and the 2 meter thresholds, was that we recognized that it was quite a simple approach we'd taken, and that there was quite a lot of uncertainty. We hadn't looked at the location of all the many tile drains and considered detailed backwater profiles up those tile drains and things. So then in John Scandrett's evidence, he's taken a couple of those tile drains as examples. I think one is quite a low-lying example, and the other kind of goes into higher ground, and he's considered how those specific tile drains could be affected at a water level of 2.5 meters, showing that, you know, that there is an effect which propagates upstream, and it reduces the flow rate of those tile drains. And really, with the joint witness statement, so we discussed the differences between our different approaches, and we really agreed that the area of land within 1 meter vertically of the lagoon water level is strongly affected by reduced drainage, and that's the area that we mapped with that 1 meter threshold, and we all agreed on that. And that sort of for higher land, there would be some effect because drain flow would be reduced. And what that means, that effect is that it takes longer for excess water to drain from the soil. So following a heavy rain event, in a very heavy rain event, the tile drains aren't capable of draining the water from the soil quick enough, so the soil will get waterlogged, irrespective of lagoon levels under sort of very heavy rainfall. But with different lagoon levels, the rate at which the water can drain from the soil for the soil to return to a sort of lower or productive soil moisture is going to be different for different lagoon water levels, and that's kind of what the joint witness statement sets out. Sorry, that was quite long. I don't know if that answers your question.
It was helpful to take us through that, because I was trying to understand whether because I haven't read the joint witness statement, whether there was a fundamental shift, but it seems to me that it doesn't shift the modelling from what you've talked
I think
about.
really, I mean, to summarise, you know, John Scandrett and I sort of took different approaches. The work we did was a sort of a lagoon-wide assessment to try and map and calculate the area affected. And John Scandrett has gone into more detail for a couple of example tile drains. But I think the conclusions we reach in terms that land within 1 meter of the lagoon water level is strongly affected, and land above that, there is going to be some reduction in drainage, and that's going to vary depending on the capacity and condition and slope of the tile drains and the elevation of the land. You know, we're largely in agreement. And obviously you're going to ask John Scandrett about this as well. So just as an example from his evidence, I think his tile line 2, which is the tile line that goes into higher land, he calculates a reduction in flow rate of 13%, and that's with a 2.5 meter water level rather than a 1.3 meter water level, which would be sort of free drainage of the outlet of the tile drain, a 13% reduction. You know, his calculations are, I agree with all of those. So the joint witness statement is kind of, we're largely in agreement.
Yep, and I do understand that point of difference now in the site-specific assessment of it. So thank you. My next question, I'll just go back to your section 8 of your statement of evidence talking about the modelling. So you validated the 2016 inundation modelling using the drone imagery, and then you go on to describe the inundation and drainage affected, the areas that were most affected. And I wanted to know, we don't have any information specifically on impacts on the walking track and the dock walking access. I haven't been able to read anywhere any information that says, based on that modelling, you're not going to be able to use the track for X amount of days, or the bridge. Exactly how long is the closure expected? I just couldn't find anything that precise anywhere.
So in terms of the length of time the lagoon would spend at different water levels, that was calculated using the water balance modelling for different scenarios of opening regime, including the proposed consent and the various stages of that consent. And I think Dr. Robertson's going to describe that scenario assessment in more detail, but I think if I could just point you towards table 6 in the technical review of consent, what's the document called? Technical review of conditions for opening Waituna Lagoon, which I think is in the appendix to the application. So table 6 has the amount of time the lagoon on average would spend at different water levels under the different scenarios, and I think scenario C is the final step of the consent with the 2.5 meter threshold.
Right.
Which appendix is it in, Mr. Measures?
It's in the application.
Yep.
And I'm just trying to remember again. It's appendix B to the application.
Appendix B. Yeah. Thank you.
And then the other thing I would direct you to is as another appendix. It's one of the later appendixes. There is the NIWA report, Waituna Lagoon level impacts on land drainage and inundation, and that has all of the maps of inundation extent at different water levels within it.
Yeah, I have that map, and that's, with reading that map, I still wasn't quite sure where it would, how it would impact on things like the walking track and stuff. But it's probably because it's not, you can't zoom in on it, so it's hard to get that level of granular detail.
Yeah, so those maps are, we obviously have the data sets behind them. So if there's specific questions, that's easy for us to provide those answers. So I guess you're asking what level those walking tracks become inundated at?
Well, I probably should be more specific and said you did some ground truthing of the data based on the photos, and
Yep.
did those photos tell you anything about the walking tracks in particular? that's more what I was trying to say.
Yeah, so I'm not familiar with exactly where those walking tracks are off the top of my head. And when we did that inundation exercise, we were really looking particularly on the farmland areas, because that's where a lot of the submitter concerns were, and trying to validate that to the extent to which the modelled inundation extents matched the drone imagery, which they did match very closely. We did look specifically around the bridge area, and as we had some very good quality drone imagery there, and I know it did match very closely in that area.
Yeah, that's really helpful, thank you. I only have one last question, because there was lots of information, so quite easy to consolidate and get a good picture of the various reports from 2016 onwards. But there was one part that I just wanted to better understand, which is the uncertainties. So section 12, the uncertainties of the water balance model. And so you do talk about, I think the two is seepage and climate change impacts. And I wanted to understand how reliable the model is in regards to the seepage part, because of course I won't concentrate on climate change, but in terms of the seepage, how reliable do you think, or how much confidence do you have in the modelling, given it's so uncertain about seepage?
So I think, it's worth asking this question of Dr. Robertson as well, because I know there's been some sensitivity analysis done specifically looking at this, which he, I think, talks about in his evidence. In terms of barrier seepage, obviously when the initial modelling was done, the model was calibrated based on historic data, and it performed really well. And then subsequently in really the last season, or I guess 2023, 2024, it was noted that there was sort of a divergence between the model predictions and the reality of what was going on with the lagoon water levels. And it's really kind of, Environment Southland have done some investigation into what the causes of those differences could be, and the most likely thing seems that there has been a change in barrier seepage. Now, we don't know if that's going to persist into the future, or if it's going to revert back to what it has been for a long time before that. And that, I guess, if it does persist, that's what's covered in the sensitivity analysis, which I think Dr. Robertson is better placed to talk about than me. If it does persist, what it means is the seepage through the barrier has reduced, which means that lagoon water levels will rise slightly more quickly, and we would need slightly more openings than predicted in the initial scenario analysis. And I guess that would be true for all of the scenarios considered in the comparison. So I think really my conclusion in my peer review was that it wouldn't change the conclusions of the relative merits of the different opening scenarios assessed against each other, but it would mean that the number of openings under any of those scenarios would be slightly higher than the water balance model predicted using the old barrier seepage function.
Yeah, that's really helpful, because from what I read is if you've got more seepage, then the lake's lower. You've got less, the lake's higher. How does it actually impact on modelling, and how does it actually then impact on lake opening consent? And it's that final question that's really important. So it might impact on modelling, but ultimately the triggers are still going to be in place for your opening consent regardless.
Exactly. Yeah. And obviously there's, the biggest uncertainty probably in the water balance model, which I don't talk about, is that we don't know what the weather's going to do in the future in any given year. So they've assessed the scenarios based on, you know, historic inflow data on the assumption that sort of future years will be similar to past years. But obviously, if we have a very wet year or a very dry year, that's not, you know, so I think when we're considering uncertainties to do with barrier seepage and things, it's important to contextualize that in the, you know, within the uncertainty of what future inflows will be. That largely determines the frequency of openings.
Thank you. Thank you. Mr. Measures, we need to move to Mr. Sims, but we still have Commissioner Boothroyd and my questions, unfortunately. So we'll probably be back at around 5 o'clock. So we'll hear from Mr. Sims and then we'll come back to you. Thank you.
Thanks.
Thanks very much. Mr. Sims, good afternoon. Can you hear us?
Yes, I can.
All right, then we can confirm that we can hear and see you,
Thank you.
and understand that you've got a presentation so that you're aware. We've had copies of the presentation printed off, so we're able to follow along.
Yeah, it may have changed a little bit since I sent it because it was a couple of weeks ago, but I've added a wee bit to it. So
Okay.
Can you see the presentation is the next thing?
Yes. Yep.
Cool.
Yes. Thank you.
Got it there? Right. Okay. Thank you for the opportunity to do this. As you'll hear in my presentation, Waituna is an extremely important place to our family. And yeah, I'll go through that shortly. But just quickly to explain the photo in front of you, that's taken from one of our maimais at duck shooting season. It's at the western end of the lake, looking towards the east in the sunrise. The mouth of Waituna Creek is about where the sun is coming up there and runs out into the lake. Waituna, as you may have experienced yesterday, can be an incredibly beautiful and serene place, but it also is a pretty wild and stormy place at times, and it is quite an amazing place to experience, and we're very lucky as a family that we've been doing that, certainly for my lifetime and through 4 generations of our family. Apologies. We have a multi-generational connection to the area, and that's why this application and everything that happens at Waituna is so important to us. We've been coming here to hunt and fish primarily for 100 years. And the submission is made on behalf of myself, my father Ray Sims, who's 93 years old, my uncle Stan Sims, who's 90, and my friend Mark Cook, who is also a Southlander and of Ngāi descent. We've had 4 huts at Waituna over the last 100 years. Our current hut was built in 1954, and it was moved out of the reserve to its current location on the farmland beside Moffat Creek in 1981, after we were evicted from the reserve. All the huts were supposed to have been removed from reserve by 1985, but we were one of 2 that moved the huts, and the rest remain today, still providing shelter and enjoyment for the users. That's a photo of me at the top there, one of my early days at the hut, and the photo bottom right is of my uncle Stan and father Ray Sims. We primarily game bird hunt at Waituna and also do a bit of fishing. Some of the fish that the old boys have caught down there over the years have been pretty phenomenal. But unfortunately, the fishing at Waituna is today nothing like it was back in the 90s when these big fish were caught. That big fish that my dad's holding, the black and white one, that's been displayed at Fish and Game Office in Invercargill. It's in the glass case in the foyer if you're ever in there and want to have a look at it. It's a magnificent specimen, an example of the type of fishing that used to be at Waituna, but we haven't seen for several years. We oppose the current consent application that's before you. primarily because of the trigger level of 2.5 metres and the effects it'll have on the adjacent farmland, our hut, and the lake's health itself. We will lose at 2.5 metres normal vehicle access to our hut, which is essential for my now elderly father and uncle. It's the only way they can get to the hut. They can't walk like they used to be able to. They have to be driven to the hut. At 2.5 metres, our hut and its historic contents will be periodically inundated and flooded, and depending on how long it remains above that level, essentially it will render it unusable and unsafe to use. The applicants and all the supporting reports and evidence make no mention of wind effect on water levels in the lake, and I did pick up earlier some discussion around water levels and the way it's currently being measured, so I'll explore that a little bit further. 2.5 metres just doesn't allow enough of a buffer for wind effect for high rainfall events, which can raise the lake very quickly, or when the sea conditions aren't right at the outlet to open it, even in an emergency. We believe that the 2.5 level will have a very negative effect on the lake's health, and this was evidenced in the 2023-24 period, where it was held at high levels for far longer than it should have been. Apologies. It resulted in toxic algal blooms, which we witnessed ourselves, and the mass dying and rotting of vegetation all around the lake, including the rupia beds, appeared to just die off and were floating around. There was also mass deaths of birds on the lake. Basically anything that couldn't fly away died because of a loss of food, resources, and probably poisoning. And similarly, there was a lot of dead fish at that time when the lake had the toxic algal blooms. A lot of carcasses all around the edge. And I witnessed all that personally. At 2.5 metres, the lake causes significant erosion to the creek banks and increased sediment and debris build up into the lake. And again, we've only witnessed this on the Moffat Creek in the last 2 to 3 years when the lake has been held at higher levels than it traditionally has been. And we've also personally witnessed the impact it has on the drainage of the farmland and the grazing of the sheep in the paddocks. Usually the high water levels and heavy rain event occurs at the time of the year where it's lambing or calving, and it's extremely stressful for the animals and the farmers' mental health as they try and manage the health of the animals with the land available. These photos are just examples of what a high level lake looks like around their hut. In a flood event, the lake can rise very quickly. And once the level is at 2.5, we have water inside our hut. The Moffat Creek is just to the right of that bottom photo normally, and once it gets to that sort of level, it starts to erode the banks, which is a real threat to our hut. We've actually got a problem further upstream, which is getting worse as time goes on with the high levels, as you'll see in a photo in a minute. If the huts flood and are held at a high level for a long period, essentially, we feel we'll have to abandon the hut. It won't be safe to go there, and certainly isn't safe for my father and uncle to access. And that's through no fault of our own. We've already moved the hut once. I don't think we should have to move it again. And there's been no mention by anyone of any compensation for damage to our hut or any other huts that are impacted by high water levels, or the offer to relocate them to higher ground. I just want to talk a wee bit about this wind effect on the lake. The graph I've shown there is from the Environment Southland graph that used to be online. It's changed recently, so you can't go back more than 12 months now, but that's a good snapshot of strong westerly wind and how it pushes the water from the west to the east, and the level gauge at the eastern end reflects that. That is the actual water level, and you can see it's changing by up to 0.5 metre at the eastern end just by the wind and the way the waves and the water being pushed towards the eastern end. And that can go the other way as well on a strong easterly. We've seen it push the water up our end of the lake at the western end and raise the level significantly. So that's another reason to consider a lower trigger level for the lake, because you've got to allow for up to 0.5 metre of wind effect on the lake. And a 2.2 metre trigger level that we've been using in the last few years gives that good buffer and still keeps it manageable. These photos were taken just one day apart in 2020 at duck shooting time, and that difference was purely from the wind, a westerly wind that blew all that water away from where we were shooting on the edge of the lake. So that's not tide, that was just wind. And you can imagine that all that water's gone to the other end and done the opposite down there. The opening of the lake is not a simple process. These photos here show it being done last year in January or February when it was, and also old historic photos of when it used to be open to the sea by hand. And it could still be done that way today. You don't have to use machinery, but obviously machinery is a lot more efficient. But you can only do it in perfect conditions, as is shown in these photos. If there's a big sea running from the south and big storm winds, you just can't safely operate machinery like that down there. So sometimes you have to wait weeks for those conditions. And the best people to talk to about opening the lake are the people that used to do it, which was the Lake Waituna Control Association. And again, 2.2 trigger level just gives you that little buffer to allow for the right conditions to open it, because at certain times there you may not have those conditions that you can safely open it when you need to. The photo of the lake actually being opened there was from the last opening. It's a great photo, and it shows the sediment and tannin coloured water draining out to sea. I did hear the conversation earlier about the effect on the sea and the beach out there of that sediment and material going out to sea. But I think you need to keep that in perspective in terms of its volume compared to what goes down the rivers in Southland and straight out to sea every day of the year. This is pretty small, and it's better out than in, I can tell you that. The impact of the high lake levels over the last couple of years has had a really negative effect on the Moffat Creek banks around our hut and between our hut and the creek mouth at the end of the lake there. And those photos just show the damage that's only occurred with the lake being held high, because the water level comes up, overflows the banks collapse, and then all of that material gets washed into the lake as sediment and debris. And the mouth of the Waituna Creek in those times is just full of great lumps of material, and eventually it all disperses, but it's all gone into the lake. And that's occurring probably at the Waituna Creek as well, and other areas, but I can only speak for what happens at Moffat Creek just beside our hut there. And you can see the threat that poses to our hut as well. It's got quite a bad erosion problem. The impact on land drainage and farming operations. The arrow there is just pointing to where the huts are, where our hut is. And that was taken in September last year, just prior to the emergency opening. I believe later you'll see some drone footage, which this is a screenshot from the Crack family, who will show you the impact of that drainage back further up on their farm. But it just starts to spill out everywhere onto the farmland. And paddocks just get extremely wet and boggy all around the place. The September 24 emergency opening, the lake was allowed to rise to nearly 2.6 metres, as you can see on the graph. With the wind effect again at the eastern end, that got up to 2.75 metres. The questions before that were asked about the impact on the dock walking tracks at the eastern end. I think Doc can probably answer those, and so could the Southland District Council, in terms of the impact on the roading and the bridges, because Waghorn Bridge was closed, as were the roads at the eastern end, and the dock walking tracks also had to be closed because of lack of access, because the roads were closed and the bridge was closed, and the duckboard walkways would have been well underwater, but I'm sure they've got all that information if you ask them. The 2024 event was extremely concerning because there was no consent. We didn't know if the lake was going to get opened. We started getting water in our hut at 2.5 metres, as has happened historically. But common sense finally prevailed on the 25th September and she was let out. So in conclusion, while it would be nice if the lagoon and the area went back to its pre-European or pre-Maori state, it's never going to. That's just wishful thinking. We have to adapt to the new normal. Climate change is a real thing, and the impact of that in the future is probably going to be pretty significant for Waituna. We're seeing it all around the country, more heavier rain events. So we need to be able to adapt to that. And what I'm hearing from everyone really is that we need to work together for the sake of the lake and the users of it and the neighbouring farms. Regular openings for land drainage and ecological health should be the only drivers of its management, in our opinion. And the locals and the people who have been coming here for many generations know what works and what doesn't. The Lake Waituna Control Association effectively managed the lake openings for many years, and they have a lot of knowledge just in amongst that group of people on how to do it successfully and why the trigger needs to be where it needs to be. And a 2.2 metre trigger, we believe, gives a sensible buffer for the reasons I've already outlined. And we would withdraw our objection to this application if the trigger level was changed to 2.2. That would work for us. So yeah, thanks very much for the opportunity on behalf of my dad and Stan and myself and Mark. I'm not sure if any other hut owners or hunters or fishermen are presenting, but as you can see, this place is pretty special to us and has been for many generations, and we would like to continue to be able to use it like we have in the last 100 years. Thank you.
Thank you, Mr. Sims. Would it be possible for you to send your most recent presentation that you've updated and just presented it to us, to the hearing administrator?
Yep, sure, I'll do that. Yep.
Yeah, that would be helpful because then we have a record of it. So yep, that would be great. If you were able to do that, that would be brilliant. I'm just going to see if the commissioners have got any questions for you. Mr. Boothroyd.
I do, thank you, Mr. Sims. That was very illuminating. I was interested in your record of fish kill, dead fish in the lake, in the lagoon, following the algal increase or algal bloom. Are you able to tell me, was that a whole variety of species or was it just one type? And was it throughout the whole lagoon?
I only noticed trout, and it's basically just the carcasses and the odd one you see floating. But the water temperature at the time was also pretty high, so it's possibly a combination of high water temperature and summer and the algal bloom. But I'm not sure whether anyone did any testing of the dead birds or fish at that time. But it was something I'd never seen on that scale before. Yeah, it was quite shocking.
Okay. You don't happen to take the temperature?
No, sorry.
That's all right. No. Just
it was warm. I do remember, sticking my hand in and going, "Gosh, the water is warm," even though it was very high. It was very warm.
And your desire to see the water level retained at 2.2 meters at the bridge recorder, from what you're saying, that suggests that at other parts of the lake it could be 1.7 meters if you take that 0.5. Am I right in understanding?
Yes, that's what happens. It pushes the water from the upwind end to the downwind end, but it works in all directions. We've seen it regularly with a big easterly wind blowing, that big change, half a metre change in level at our end of the lake when we're shooting, or when there's a big southerly wind blowing as well and it pushes it up the Waituna and Moffat Creeks, that water backs up so long as the wind pressure is still there. As soon as that pressure goes away, it lets it back out. As you can see on the graph, it's up and down all the time. The location of the measuring device at the moment isn't ideal. I don't think it gives a very good mean reading of the lake. The monitoring platform used to have that real-time data and you used to be able to see it on the Environment Southland graph, but it stopped working several years ago and it's never been repaired. I think that would give a better mean sort of level of the lake.
And by the platform, do you mean the central monitoring point?
Yes, I think you may have seen it yesterday.
We did, yes,
Yep.
yes. Well, we didn't see a platform, but that's not there, but we did see the
Sorry, yeah.
monitoring itself, yeah.
It used to be a bit of a platform.
Yes, thank you, yes, yes. So if there was going to be adjustment to the water levels, I'm trying to understand it. If it's a bridge under certain weather conditions, it's going to give a misleading level recording, if you like, under certain circumstances. And when it's nice and calm, which very luckily it was for us yesterday, actually, that would be a reasonable measure at the bridge because it's so calm.
Yeah, it is. When there's no wind, it's a true measure there of the level.
Yes. Okay. Interesting.
And you can sort of see that on the graphs. You know, you've got all the wiggly lines depending on the date range you put on. You can, you know, in your mind draw a mean level there, but it does, yeah, show that there's quite a variance depending on the wind.
And what we understood this morning is because the water level in the application would be over a series of consecutive days, but it might jiggle around over those consecutive days as well. From what you're saying, yes. So to get a true measure could be quite difficult in some circumstances.
Yeah, I think you're going to have to think about how you're going to get that mean level over 5 days or however long is decided.
Yeah. Even at the higher or the lower level, actually, whichever level it is, it's always going to be quite difficult. That's quite helpful to know, actually. Thank you. Yes. Thanks. Thank you, Mr. Sims. That's me. Yeah.
Kia ora. I have just a few questions for you as well. When I looked at the NIWA modelling, I tried to see exactly what they were saying about the modelling connected at Moffat Creek, because that's quite specific to where your hut is located. And I wanted to see, so what they've said is that at Moffat Creek, the lagoon backwater effects are mostly limited to the wetlands and they don't impact on farmland. And I wanted to ask, does that match your observed?
No, as you saw in those photos, that was a flood in 1994, some of those photos, which is the highest level we've ever seen, which I think got to 2.7 metres before it was let out. It floods a pretty large area, and you'll see that through the drone footage that the cracks are going to show you, I think, and how far back that backs up into all the creeks and drains on their property further up. It does make that bottom end of the farm essentially unusable for long periods, and then even when it is let out, the grass has all died because it's been underwater for so long and has to be resown and grow, and it just, yeah, it impacts the farming a lot.
Okay, thank you. And so you relocated from Dockland to onto the Cracks land, is that right? Is that
correct? Yep.
It
In
is.
1981, I think it was. Yeah.
Okay, great, thank you. And so now, just about the 2024 emergency opening, I just wanted to kind of ground truth with you, some of the modelling. So you said that at 2.6 the water entered your hut, and I wanted to
2.5 it was, yeah.
2.5 that it entered, and
some of the other huts, I know it was in earlier than that, but our one is a little bit higher than some of those other huts.
And so how long did it take? How long was the water in your hut before the decision was made to do the emergency opening? How fast?
I can't give an exact answer because I live in Christchurch. So I'd gone down and lifted everything when it was coming up, and we looked like we were going to get flooded, and there was no resolution to the consent to open it. And then the Cracks sort of kept an eye on it for me and said, no, it's coming, lapping at the door now. It would have been a few days, and then it was let out on the September 24th or 25th, which was a big relief.
And when it was let out, how long did it take to receive and get the water out of your hut?
Oh, instantly. It's hours, yeah.
Okay, hours.
It drains away really quick, the whole lake.
You've also given evidence and spoken to water quality, and I wanted to just understand. So we've been given evidence that says that long closures, especially over summer, lead to the murkier water and more algae. I just wanted to know, and from what you've observed, does water clarity improve as soon as it's opened, or does it stay the same for quite a period of time?
The main impact on water clarity is, again, the turbulence from the wind. It stirs the bottom up. When you get the wind, it doesn't really matter what level the lake's at. It really stirs it up and gets very dirty. When it's tidal, there's a lot less of that because you're getting fresh seawater coming in and out twice a day, and the water is just crystal clear when the tide's running, and it's really fantastic to see after it's been closed and algal blooms like it was, just to see the fresh seawater in there, giving it a good clean out. The sediment in the lake over the last few years has increased horrendously. There used to be gravel bars in places at the end of Moffat Creek, and they just disappeared under mud. And we think a lot of that was just the debris, the creek banks falling in and getting washed into the lake, and it's just filled the lake up with sediment. But when you open it to the sea, the flushing effect of that over time, the longer it's open to the sea, it actually, needs to stay open and have several cycles of the tides coming in and out, and good tides, and it does clean it up. You start to see wading birds come back. Yeah.
And so
crabs come into the lake, and it just all starts to look healthy again from being a really unhealthy state.
And have you had the opportunity to, or seen the evidence of Ms. De Winter that says for Rūpia, though a higher lake level and less openings actually improves the plant species in the lake?
What we saw in the last 2 years when it was really high was the Rūpia actually dying off, whether it was through the high temperatures or the nutrients, I don't know, but the Rūpia beds just disappeared, particularly at the eastern end of the lake. It was really noticeable because when you're fishing and trolling in a boat, you're always catching the Rūpia because it's a big, long, stringy weed, and it's actually a real pain when you're fishing. But it actually just disappeared at a really high lake level, possibly because it's anchored to the bottom of the lake, and you might be fishing above it. But there was whole Rūpia beds disappeared, and then there was lots of rotting material appeared around the lake edge with wave action. There was dead weed everywhere, and that rotting material was sort of the start of the algal bloom, we thought, as well, because it was all contributing to the nitrogen loading.
So I just have two more questions, but one's just a bit of a check-in. So you acknowledged that you heard that we'd had a bit of a conversation about the monitoring of the gauges, where they're located, and that there's been quite a lot of data that's been gathered over the years on wind effect on the lake, and it's because of the level of data that has already been researched and gathered that the two monitoring sites is no longer required. And I wanted just to kind of check in with you to go, now I think you acknowledged that you heard some of that evidence, and does that give you more confidence that if wind effect is being really closely monitored, does that give you more confidence?
I still personally think the best monitoring position in the lake is what I call the platform. In the middle, the water will go backwards and forwards, but that part of the lake is quite deep and probably stays more constant than having the monitoring at one end like it is now. I mean, as soon as you start having to apply some sort of calculation to, you're starting to introduce errors, I think you'd be better off just having a more central monitoring position, in my opinion. And having multiple points around the lake, there's going to be quite a cost in that. And the weather down there, the reason I think the original platform, essentially it was destroyed by the weather, just like our maimais get destroyed by the weather down there. It's a harsh environment at times, so whatever you build out there has got to be pretty robust and going to require quite a lot of maintenance.
Okay, thank you. And I only had one very last question. It's on your conclusion, where you talk about that the lake should only be opened for land drainage purpose and ecological health. And we've got a number of landowners. We've got landowners around the lake that say we want a higher lake level because we've bought this land specifically for ecological health and to have it a higher lake level. And then you've got other landowners saying we've got our land to farm and we'll do other activities on it. And I just wanted to kind of ask you, given that you've got these two groups of landowners with competing values, how do you, and you acknowledge that Mr. Cook has whakapapa, how do you balance those competing views and other community aspirations or the wider aspirations of some community members?
Yeah, I certainly acknowledge Ngāi Tahu and their connection to the area. And like Mark and his dad, who used to come down as well, they are Ngāi Tahu descent, but their view is, and they were farmers in Southland. We're all from Southland. They can see the impact of the farming operations, and it has a real impact on the farmers' revenue, which I don't think that's quite as important to iwi. Perhaps they've got other options for their revenue, whereas the farming operation is what it is. They have to make money off the land. But I acknowledge there's definitely differing opinions, and that's what I said. We all need to find a solution to this that is going to work for everyone.
Okay, thank you.
Thank you, Mr. Sims. I've just got one final question. In your conclusion, you say about a 2.2 trigger level is the safe buffer. In the submission, it talks about the trigger level of 2 meters or 2.2. I'm just confused.
Yeah, that was the recent historic Waituna, the Lake Waituna Control Association, and the changes to the consent that they held for a number of years changed. That crept up, and then between 2 and 2.2 was the last consent that the Control Association used, and that's gone. And we've essentially the last couple of times, the lake has been allowed to get higher than that, and we've seen some quite negative impacts from having it higher.
So in your view, it should be reduced to 2.2.
Yeah, I think that's a comfortable position for us and the wider health of the lagoon, I think.
Yep. And
I only today the other changes in consent to have a staged consent trigger level. I just saw that come through this morning, but I've been working today, so I haven't had a good read of it. But yeah, I think that's a possibility, and I'm sure everyone can work to a more staged change, and so long as some good monitoring and science is done around those positive and negative impacts of those gradually creeping up levels. But at some point, we're concerned for our hut if we get to 2.5 meters and then we're flooded.
Yeah. Okay, thanks. That's very clear, Mr. Sims. Thank you very much.
Thank you. And I just wanted to acknowledge the Southland District Council, who now own the land that our hut is on. We're only there through the goodness of people and organisations. And I just want to thank them and the Crack family for allowing us to have our hut there. It's really important to our family. Thank you.
Thank you. Right. We are now moving back to, we're not going to take a break now because we're going to finish Mr. Measures, then we're going to take a 15-minute break and then we'll go to Ms. Thorne. So we'll finish with Mr. Measures now, and it's Mr. Boothroyd. Questions for...
Thank you, Mr. Measures. I don't know if you were listening actually to that recent presentation.
Yes, I was, yes.
Yeah, and that question of the wave action and how that has been built, has that been built into your model there?
So you're referring to the effect of wind, sorry, rather than waves?
Sorry, yeah,
Yes.
the wind, wind pushing the water, yes.
Yes, so our modelling is based on horizontal water levels, so it doesn't consider those wind effects. So if you like, it's for a given lagoon level, what we've mapped as inundated would be kind of on average inundated, and there would be some variation around that as the lagoon water moves from one end to the other.
Okay, thank you. Actually, I don't think I've got any other.
Okay. So I'm just going through my questions, some of which potentially have already been answered. So that's done. You might have heard me ask Mr. Rabel about the alternative gauge if the gauge at Waghorn Road is not available for whatever reason. That there's an alternative to be used, certified by the council. Sorry, what alternative gauge?
Sorry, I'm not sure I'm following the question.
Is what being used to determine the lake when the lake level reaches up to 2.5 or the transitional period up to there, correct?
Yes, that's my understanding. Yeah.
So, in the conditions of consent, it says when that gauge is not available, an alternative gauge can be used to determine what the level would be. I want to know where the alternative gauge is.
Yeah, so I'm afraid that's not really within the scope of my evidence. Yeah, I would have thought Environment Southland or DOC would be better placed to answer that.
So as that there was no, you haven't used any other gauge in terms of for modelling the lake level.
Yeah, so all the modelling, both the water balance modelling and the inundation and drainage modelling, is kind of independent from the monitoring, I guess. So we're applying a 2.5 meter water level.
Right.
You know, that is a mean water level within the lagoon. It's not at a specified monitoring location, so it would apply equally sort of wherever that monitoring takes place.
Okay. Thank you. Could you just explain for me a bit more about how flooding is, in terms of, I'm talking additional fresh water coming down the creeks, is allowed for within the modelling?
Yep. So yeah, so the inundation modelling we did was it was done in 2 stages. So the first stage is just what I would call bathtub modelling. So we just take a completely horizontal water level within the lagoon, and that was kind of an initial sort of screening level assessment. And then it was recognised that within the creeks, because the creeks are flowing, there's a backwater effect, and the water level of those creeks is obviously sloping towards the lagoon. So if you raise the lagoon water level, you're going to raise the water level for some distance upstream in the creek. So for each of those 3 creeks, for Waituna, Moffat and Carron Creek, we built a one-dimensional hydrodynamic model. So that's the model consists of sort of cross sections of the stream, which have been surveyed. It has equations for the flow of water through those cross sections, an allowance for the friction of the bed and the vegetation in the stream. And we ran those models for different lagoon water levels and different stream flow rates. So we ran them for a mean flow, so a sort of average day-to-day flow, and we also ran them for a high flow, which we calculate as a 90th percentile, so a flow which is only exceeded 10% of the time. And we actually ran it for two different sort of levels of vegetation in the creeks. So a vegetated scenario and a scenario where the creeks had recently been cleared of vegetation, recognizing that that vegetation clearance process happens periodically. So perhaps if I share my screen, can I do that? Can you see the document I'm sharing? So this is one of the figures, figure C7 in the Waituna Lagoon inundation and Waituna Lagoon level impacts on land drainage and inundation. So that's in an appendix to the submission. So this is mapping for Moffat Creek. I've got it up because I was looking at it during the last presentation. I think that the huts that we were being referred to in the last presentation are somewhere along the, maybe in this area here on the bank of Moffat Creek. And this is the mapped inundation under different lagoon water levels. And the other thing I wanted to highlight, because of that sort of sloping water level going back up the creek, these red lines mark the distance the backwater effect propagates up the creek under those different lagoon water levels. So for a 2.5 meter lagoon water level, there is a backwater effect extending up to this red line. So upstream of that, the lagoon has absolutely no effect on inundation. You could obviously still get inundation during high creek flows, but that would be irrespective of what the lagoon water level is. And below that, there's a gradually increasing effect of the lagoon. So it might only affect it a few millimeters here compared to a low lake level, whereas down here, you know, obviously if the lagoon level is 2.5 compared to 1 meter, the water level will be 1.5 meters higher in the lagoon. So there's a sort of sloping degree of influence of the lagoon on the creek water levels.
Okay, that's clear. Thank you. I don't have any further questions from Mr. Mears.
Just to confirm, so that's page 57 of Appendix N.
All right. Thank you. Thank you, Mr. Measures. That's so we're now going to take a 15-minute break, as it were, and reconvene at 5:30 for Ms. Thorne, who's going to be online. Right. Okay. Thank you.
Thanks.
Thank you again, Mr. Measures, and thank you for splitting your evidence into
Yeah, don't touch the stuff. No. Yes, yes. Yeah. Not really. Excuse me. Ms. Thorne. Okay, we'll reconvene in the hope that it might mean we're able to leave 1 minute earlier. It would appear we're down to wee hardy few, and we've now got Ms. Thorne for the applicant.
Yes, we do. So we have Ms. Thorne. So your full name is Lisa Thorne.
Great. And can everybody hear me okay?
Yes, but you might need to just speak up. And you're a partner at Taylor Planning Limited. And you have prepared evidence along with actually the application and the further information responses and a lot of other information, but in particular your evidence, which is dated the 11th of July 2025.
That is correct.
And you've set out your qualifications and experience in paragraphs 3 to 8 of your evidence.
Correct.
And then at paragraph 12, you've stated that in providing this evidence as an expert witness, you are doing so in accordance with the Environment Court Code of Conduct. You acknowledge that you have an overriding duty to impartially assist the commissioners on matters within your area of expertise, and the views expressed are your own, and you do not speak for the applicants.
That's correct. I confirm that I've reviewed and will abide by the code.
And you've actually attended 2 sets of expert conferencing. So prior to filing your evidence, you did expert conferencing with Ms. Petrisevich, and that's addressed in your evidence.
Yes, that's correct.
And subsequently last week, you and actually I think this week as well, have I got that right? You and Ms. Petrisevich and Ms. Sanazaro also did further expert conferencing.
That's correct. We undertook expert conferencing on Friday and then again yesterday, finalising our joint witness statement late yesterday.
And that's the joint witness statement. It actually says that the hearing date's 29 to 31 August, but it does mean 29 to 31 July, and which all of you have signed, and which I think is dated 28th of July. Is that correct?
That's correct.
Great. Thank you, Ms. Thorne. Are there any matters in terms of your executive summary or other matters that you would like to cover off? I'm aware that you've been sitting through or listening to the hearing today, so you may have some matters that you'd like to address.
Thank you. If it assists the panel, I'm happy to skim through my executive summary relatively quickly. And then I've been making notes throughout the hearing with regards to some of the questions you've been asking about the experts that you've advised you would like to hear from me on. So I'm happy to then delve more into discussion around conditions of consent, particularly around location of opening, some of the management plan conditions, and particularly conditions regarding cultural values as well.
Yep, certainly the front part of skimming through your executive summary and responding to the questions that we've already put, that would be helpful. And then we've probably still got some questions for you.
Thank you. So the planning evidence you have before you from myself, the purpose is essentially to provide a further evaluation of the resource consent to provide for periodic openings of the lagoon. Having considered the submissions received, the Section 42A officers report and the expert evidence that's been provided to date as well. So what my evidence details, and I won't go into any further detail on it unless you have specific questions, as it provides a description of the application alongside the activities that require resource consent, so things that trigger rules in the Land and Water Plan and in the National Environmental Standards for Freshwater Management. I provide an update to my previous assessment of effects in the application. I then go on to provide an update and further consideration of Section 104(1)(b) of the Resource Management Act and the Section 104(d) gateway test. The recommended conditions of consent from the Section 42A report, I've reviewed that when preparing my evidence, and Ms. Protasevich and myself have made further changes to that condition set agreed through the joint witness conferencing. I can take you through those in a little bit too. Essentially, with the further evaluation, my evidence, the recommended term conditions of consent and my overall conclusions as to effects are largely unchanged. I consider the application is not contrary to the objectives and policies of the planning documents. Both limbs of the gateway test are passed, and I do have some comments that I can make on suitability of conditions, if you'd like me to do that now, or if you'd like other questions first.
Okay. We probably, if you can, before we go to questions, could you respond to any of the matters that we raised during the day that may have been deferred to you? And we'll start with that, and then we'll make a call. Having done that, we'll then make a call about what we'll step through next.
Certainly. So some of the questions that you've had of other experts relate to the opening location and the conditions of consent that relate to the opening location and the application. So to be clear, and I think this is set out in, I think it might be Section 3 or 4 of the application AEE, the application seeks to open at Walker's Bay. There is a plan that's attached to the application that delineates essentially the spatial extent within which that opening can occur. And the conditions of consent also provide for alternative opening locations, so that's not necessarily limited to Hanson's Bay or the fence, it can be anywhere along the bar, but only where a risk assessment has been undertaken, and that risk assessment has then been provided to the consent authority and been certified. There's a couple of reasons for that.
Excuse me. Hello,
Yeah.
I've got a question, sorry. If it's opening anywhere along the bar and it's subject to a risk assessment, isn't that just the same as another assessment that's already been undertaken and you're just going to do it again? Don't you need a resource consent for that?
So the proposed condition 1 is to open just at Walker's Bay. The risk assessment sets out a number of parameters that would need to be considered to open at a different location, and they would have to be satisfied through that certification process. So in essence, the application seeks consent to open anywhere along the bar, but that is limited to Walker's Bay unless a risk assessment for another location has been certified.
And where in the application does it say what you've just said, just so that we can check that?
Yeah, sure. I'll just bring the application up in front of me, let me know when you have it up in front of you as well. So the section of the application is so it's under proposal, section 3. Section 3.3 sets out the parameters for proposed conditions and monitoring, and the opening location is specified in section 337. So section 337 sets out that proposed condition 1 contains the parameters regarding the Walkers Bay opening site. But then it also sets out that the lagoon can be opened in another application if the conditions of consent, I think in the application it refers to condition 19, in the updated set I think it's 20, which sets out that a risk assessment must be undertaken before an alternative location is certified and the lagoon can be opened there.
So I'm looking for the bit where it says the other location can be anywhere along the bar.
So section 337 sets out that should the consent holder seek to open the lagoon at an alternative location to Walkers Bay, a risk assessment must be submitted to the consent authority. So the AEE then sets out what those risks, what the risks are that must be assessed. So that relates to ecological and cultural values of the lagoon, including habitat, migration pathways, fringing wetlands, the suitability of the location for managing water quality and protecting ecological and cultural values, and the overall benefits of the alternative location compared to Walkers Bay. So the intention with these conditions is the alternative locations essentially respond to concerns that were expressed by the community through the pre-hearing process, pre-application process regarding the Walkers Bay opening. I think if you turn to Appendix B of the application, which is a Science Advisory Group report, there's a more detailed assessment in section 6.8 that essentially sets out why Walkers Bay is preferred and alternative locations are not.
My question was, where does it say in 3.3.7 that it just means any alternative location along the bar?
Where it says should the consent holder seek to open the bar, seek to open the lagoon at an alternative location. It's the first line of page 26.
Don't discharge consents, which is one of the consents you've applied for. Doesn't that require some sort of point source, like point location at which the discharge is going to occur? And I agree, it's there for Walkers Bay because it's been identified, but the alternative locations for opening, I'm trying to understand where they are.
So the alternative opening locations that have been, or alternative locations where the lagoon has been opened in the past, is Hanson's Bay and the Fence. Those opening locations have been used very infrequently though, so there isn't as much data as there is for Walkers Bay to understand the level of effect that would occur at those openings on the environment. That's why the applicant's preference in condition 1 is for Walkers Bay. But there is provision for a pathway for somewhere else only if that risk assessment determines that that location would be appropriate, having considered those effects.
But aren't you doing an effects assessment on the alternative location after the consent's been granted?
It would, if I can direct you to the updated condition, which is Appendix A attached, Appendix 1A attached to the joint witness statement.
sorry, is that the track, mine doesn't have Appendix A written on it.
1A.
It's a page before, I think.
Page 4. Mine's got the signed version, and then it says draft conditions of consent. I don't have an Appendix A. I've got a track change version.
It's the track change version, sir.
It's
So turn to attachment 1B. That will be much simpler to look at because it won't have so much tracking.
And
so in Appendix 1B, that condition is now condition number 26. So there's a number of essentially risks that would need to be assessed in terms of being able to be satisfied that the overall environmental benefits of the proposed alternative location relative to other potential locations, including Walker's Bay, is taken into account if any alternative location was opened, or sorry, if the lagoon was opened at any alternative location. Similarly, what's been added to condition 26 as well is that same risk assessment be undertaken if opening at Walker's Bay hasn't occurred within the preceding 5 years. So that the purpose of this condition is essentially to direct the applicants to open at Walker's Bay, but that an alternative may be available only on the basis that those risks can be addressed and satisfied, and that the overall environmental benefits relative to Walker's Bay have been considered and evaluated.
Yes. Could you direct me to, in terms of condition, certified location, and the location certified by the consent authority, sorry, certified as to what?
So certification that the risk assessment has been received and that they've provided certification that the consent can be opened in that alternative location. Condition 26.
So, right.
Yeah.
Sorry. Sorry. When it says in condition 1 at the end, the consent authority in accordance with 23 and 24. That's not, sorry, 23 is about review, monitoring and effectiveness of effects, correct? And
that's correct.
24 is about accidental discovery.
That's correct. It should refer to condition 26. Some of the cross-referencing, obviously I'll need to update that.
So should it say 23 and 24, sorry, what should it say?
26.
Just 26.
Correct.
Yeah.
Thank you, Ms. Thorne. I'm a little puzzled by that 26, actually, and what you've just expressed. Should the consent holder seek to open the lagoon at an alternative location to Walker's Bay, or if an opening at Walker's Bay has not been undertaken within the preceding 5 years, my understanding of the regime requires that it's opened at least every 2 years for fish passage. So it would never reach that 5-year limit, presumably.
So if it was opened at an alternative location for the preceding 5 years, then it may not have been opened at Walker's Bay. That would then require this condition to be engaged to essentially sense check whether Walker's Bay is an appropriate location compared to essentially the previous opening. The reason for the previous 5 years for Walker's Bay and the inclusion in that relates to the fact that the coastal environment is fairly dynamic. So the nature of the environment and the bar in Walker's Bay and any location for that matter can change. And so coming back to sense check, is this the best place from an effects perspective to open the lagoon, and undertake that evaluation to have confidence in that is important to ensure that wherever the locations are occurring, preferably at like Walker's Bay, that minimises adverse effects from openings as far as possible. Is it helpful to the panel if I provide a bit more context around why the alternative open locations are within the conditions of consent?
Not at the moment. I think we're having some difficulty understanding that the application, what has been applied for, and what's now being put to us in terms of conditions of consent to provide for that. So Ms. Williams, just we'd like to know whether we'd like to know from a legal perspective whether the application is certain as to what has been applied for and to what the alternative. We understand for opening it at Walker's Bay, and then I understand when we said that we understood. Wait for these people to nod after what I just say. Next is that the alternative locations were going to be either Hanson's Bay and where it is narrowest, or at the fence where it is narrowest, and that there was a process to go through for the selection of that, rather than it was Walker's Bay and then you could open it wherever else you like, subject to a risk analysis that doesn't quite match. And I have no idea at the moment, other than in reply, where you're going to tell us that at the moment. And Mr. Duisberg, we'd probably like you to Thursday afternoon to address the same matter, again from a legal perspective, as to how that might work, and whether we have the ability to grant a consent to permit that. I have not. Thank you. But, before going to the conditions, Ms. Thorne, what it might be better, if there were other particular matters that came up today from a planning, if you could go, before going to the conditions, that you could, that came up today, if you could address those, then what I think we'll do is we'll then ask you questions which we have on your planning evidence, and then we'll leave the conditions to the end. Okay. All right, and that way we might get through some parts a bit quicker, and we can leave the conditions to the end. And so that you know, when we're talking about conditions, or at least when I'm talking about conditions, because I didn't receive the hard copy of the JWS till this afternoon, all of my questions are going to be on the clean version that attaches to your evidence. Okay, so if there are some changes that you've made since then, you might have to direct me to the JWS. And when we ask you questions about your planning evidence and whatever, if there is something that's material that you've changed your opinion on, and it's recorded in the JWS, could you help us by highlighting where that changes? Or if for the most part it's the same, then we won't need to worry about that.
That's correct. Is it okay if I offer one further clarification on opening and what's sought in the consent?
Certainly.
So the proposal section is clear that openings are recommended to continue at the long-term opening site at Walker's Bay. This is in section 3.2 of the proposal section, how openings will occur. It sets out that that's based on the knowledge of the effects at this location, and that a condition that relates specifically to opening that enables alternative openings can be considered if a risk assessment has been submitted and certified. So that has always been the application. That has never changed. That's the application that's lodged. There have been a few changes to the risk assessment condition, but other than that, the opening location has remained unchanged.
It's where the alternative locations, if they're used, where they might be, that's our area of concern.
Yeah, correct. And just to clarify the alternative locations too, and nowhere in the application AE does it state that it would only be Hanson's Bay or the fence, only that these locations have been used in the past and potentially could be suitable in the future if that risk assessment process is followed.
Yep.
Thank you.
When you talk about the location, is there a map that's attached and forms part of the consent to show the location?
There's a map that's attached to the application, and that is provided at Appendix D, which indicates the map, the location and coordinates for the Walker's Bay opening location. And then Appendix D also illustrates sites where the lagoon has been previously opened.
Okay. Thank you. If you can go carry on with responding to the matters that were raised earlier, and then we'll ask you some questions on your evidence.
So on the conditions of consent, I thought I might just spend the next few minutes taking you through the changes that have been made or agreed to the conditions between Ms. Petrosevich and myself since my evidence was prepared. So those changes relate to removing the Undertaking for Reserves Act authorisation from the consent implementation plan.
So which condition is that you've removed?
So that's just an amendment to the consent implementation plan.
Condition
8. Is that condition 8?
Condition number?
So the consent implementation plan is Appendix 4 to the conditions, and the condition number is condition 8.
Right, sorry.
So
where's the bit that's being removed is what I want to know.
So that's within the consent implementation plan in Appendix 4. So no specific change to condition 8, but to the content of the consent implementation plan.
It might be helpful to look at Appendix 1A for the track changes showing
consent.
It's Appendix 4.
Yes.
Appendix 4.
Yep. So the Reserves Act Authority, so it's in Appendix 4 and it's been taken out. Right.
That's correct.
Page numbers would be helpful.
Apologies for that. So the other changes that have been agreed since the preparation of my evidence are those detailed within my evidence. So a number of those changes relate to addressing duplication or errors in conditions, but there are a number of key changes that have been made that relate to the management of effects. Those primarily are additions to conditions 5 and 6 to include the consideration of at-risk and threatened bird species when making decisions regarding opening the lagoon. And to condition 20 regarding, in addition, to include 5-yearly fringing wetland monitoring and to record observations of fish stranding during opening events.
20 ABC.
So 20B includes how recordings will be kept following each opening event to provide comment regarding observations on fish stranding.
BB. Okay.
And then condition 20F now includes a requirement for the monitoring of fringing wetland vegetation within 6 months of the commencement of the consent and thereafter at bi-yearly intervals.
Thank you.
Some of the other questions that I recorded that you had asked other experts to related to responding to the transparency and accessibility issues around the communications management plan. So the communications management plan is provided at
17.
conditions provided in 17, but I'll just bring up the document that includes it. So it's provided in the package of further information that was provided to the Consent Authority in May 2025. And it's entitled Communications Management Plan. It's dated 6th of May.
Yep.
So
does it need updating?
Not at this point in time, but the condition requires that it can be updated and resubmitted within, I think it's within 6 months of approval of the application. So what the communications management plan does is it sets out essentially the communication undertakings that the consent holders would need to do in exercising the consent. So what the communications actions are listed in section 4, and what that does is set out a series of actions that must be followed in terms of quarterly e-bulletin updates, and that's particularly for any community catchment committee meetings that may be undertaken. The establishment of a web page where all information relating to the exercise and monitoring of the consent will be held. It also includes a one point of contact and a liaison with the Waituna Catchment Committee and attendance and representation at those committee meetings if they request that. It also has communications actions relating to media releases and information that must be provided when the lagoon is opened. And it also includes a requirement for a stakeholder email that reports on various things, including the quarterly bulletin, annual monitoring reports, notification of opening decisions, and that there will be community liaison meetings held, including not limited to updating on science state, performance of consent holders in terms of exercising the consent, the status of the lagoon, and any other relevant information on 6 monthly or annually intervals, depending on community feedback. And that communications,
So should any of that information be that's in the communications plan, which you're now reading from, correct?
Yes.
That you're reading from it. Should any of that be in the conditions of consent as to the requirements for the meetings or that sort of thing, or is it all just sitting within the communications plan?
So if I can refer you to condition 17 in the conditions of consent. So that refers to the Communications Management Plan dated 6th of May, and it sets out what the purpose of the Communications Management Plan is. So it sets out that the consent holder will make matters related to the exercise of consent publicly available, that interested parties are to be kept informed, and interested parties can make inquiries or raise concerns and how these will be responded to. That it must be reviewed in consultation with the community within 12 months of commencement and then at 5-yearly intervals. And that consent holder must provide the updated communications management plan to the consent authority for certification within changes being made, within 1 month of changes being made.
My question was, though, is there anything that's in the communications plan that should actually be sitting within the conditions of consent as a requirement rather than sitting within the communications plan?
Well, at the moment, the way condition 17 is worded is that the consent holder must exercise the consent in accordance with the communications management plan. It hasn't been provided as a draft. It was prepared in partnership with the catchment community. And so therefore that what is within the communications management plan must be undertaken. If it was a draft, or if that detail hadn't been worked through in consultation with the community, then certainly that would need to sit in the condition, but the condition requires that it must be implemented.
So when the application is, when the communication plan, if it's updated, including correcting of the conditions in that, which I think it needs, and it's supplied to Southland Regional Council as the regulatory authority for certification. Does that require consultation with the community when those amendments are made?
Yes, condition 18 requires that it must be reviewed in consultation with the catchment community. So that's within 12 months of commencement and then every 5 years thereafter.
Okay. Right, carry on.
I just have one question on this, sorry. Ms. Thorne, I just have one additional question on that. So I do read that there does need, so you've got 6 months to make amendment to the communications plan from the day that you get, if the application is granted. And it does say here clearly that it must be reviewed in consultation, but consultation doesn't say agreement. And so, yeah, to what extent do we have certainty that this is actually agreed and that any changes between now and 6 months' time will actually be an agreement with the community, and it's not going to be something that's going to be fundamentally changed and then be said, but we've consulted? What gives us that certainty?
So the 6 month time frame that you're referring to, I think might be for the consent implementation plan rather than the communications management plan. That's final and is specifically referred to in condition 17.
Yes, yep, no, you're right. Yep, that makes sense now. I was actually thinking I was getting confused between the two. Yep.
Yes, and that communications management plan was developed through a series of meetings that myself and other members of the steering group held with catchment community representatives, where we worked through what the content should be, how it should be structured, what it should look like, the frequency of reporting that's appropriate, and there was a refinement process where amendments were made to get it to the final point that you see before you.
Yep, no, that's really helpful. Thank you.
Are there any more questions on that, or would you like me to move on to other conditions?
Move on, it's fine.
So some of the other questions that you've had or comments that you've made to other experts are related to tighter conditions for operational matters, in particular spill management plan and refueling. I agree the conditions are fairly light in regards to spill management plan at the moment. It's typical standard condition that you would see on a resource consent that's of much lower risk. So I agree that a spill management plan and condition would be appropriate to the application, and happy to take some time and come back to the panel in writing on drafting for that. Similarly with shorebird nesting along the bar of the coastal marine area. You would have heard from Mr. Jacks earlier that shorebird nesting primarily occurs at a time where the parameters of the consent would mean that the consent is open less frequency over those summer periods. But that's not to say that it never would be. So I agree that it's worth exploring a potential to have some shorebird nesting conditions or reviews around that as well. The next thing in terms of conditions that I'd like to comment on is the questions around the use of adaptive management and adaptive management approach. You would have seen that in some of the technical reports and heard about that from some of the experts today. In a planning sense, in a resource management act sense, the conditions of consent do not take a purely adaptive management approach in terms of what a planner would anticipate adaptive management plan conditions looking like. It is adaptive in terms of the best opening location, depending on risks and values, and the timing of openings based on the multi-values approach, and the indicators in Appendix 1 and 2 to the conditions. And it does enable updates to the consent implementation plan, communication management plan, and monitoring plan. Condition 5A in particular also includes an ability to open to prevent or mitigate any emergency situation where the ecological and cultural values of the lagoon are under an imminent risk of significant decline. So there's essentially in addition to ensuring the opening parameters accommodate fish passage and multiple lagoon values, including primarily water quality, there is a backstop built in that if there is another ecological or cultural value that is at imminent risk of decline that isn't picked up through those other conditions, that condition 5A would enable openings to occur under those circumstances. I think.
Can I just interrupt there and just ask? I did ask some questions about adaptive management. I think I just want some clarity that adaptive management plan is not referenced in the conditions.
That's correct. It's not, and that was my the next part of my corridor is that I do see that there's value in adding an adaptive management plan condition in. As you would have just heard, the conditions of consent enable adaptation in response to a range of triggers, but certainly not every trigger. And I think having that ability to be able to adapt if the environment changes or observations from effects through the monitoring requirements change, that adaptive response can be triggered. Relying on a review condition to be exercised by the consent authority. If there's an appropriate adaptive management framework in place as an alternative, is a much better way of managing effects.
Yes, that probably wasn't what I was expecting in response, actually.
So, yeah, sorry, the 128 review condition, you mean?
Correct.
Correct. Yeah. sorry, what about the 5-yearly internal reviews? What's the outcome of those?
Yeah, so that's it. At the moment, there are monitoring requirements and monitoring reports that must be submitted annually. A review would then be undertaken at that 5-year mark. But then the outcome of that review, if that requires an adaptive management change, that's where the benefit of an adaptive management condition can come into play. And the conditions don't currently provide for that.
That makes sense to you?
Sorry.
I must say, I'm not sure that won't confuse matters more, actually, in my view, but that's a view that I hold. We've got the conditions that allow for an opening. That's what it's for. I don't think the application is suggesting any other form of management that might be adapted to. So I would suggest it would confuse matters to do that and stay with this view. My questioning was to make sure that there wasn't an adaptive process. I see Ms. Wilson nodding her head there. I think perhaps you're understanding what I'm saying.
Yes,
and I think it would confuse things, in my view. We may deliberate on that a little bit ourselves and rely on the review clauses, conditions that you already have in the condition. If that makes sense. So I'm not seeking a condition for an adaptive management plan.
That makes sense. So the review condition, and so this is condition 23, requires a review to be undertaken within 5 years of commencement of the consent. And that sets out a number of parameters regarding review of the effectiveness and protected health. And it sets out some minimum things that must be considered there. The opening locations, the methodology, whether the conditions of consent are adequate, etc.
And it's the consent holder that's undertaking that, correct?
That's correct.
And then, as I asked Ms. Williams earlier, what happens after that 5 years and they've done that report and it requires something to be amended? What happens then?
So that's where the consent implementation plan, communication management plan, and monitoring plan can be updated to accommodate any changes necessary.
But what if the changes mean that you're outside the scope of the consent you've applied for, and outside the scope of the conditions? What do you do then? Or if you need the conditions amended, how would you do that?
So there's a condition included that. Here we go. So that would come under the consent review condition, which the consent authority may choose to exercise.
I'm not talking about the consent authority. I'm talking about the consent holder.
That's it. So most of the parameters would be able to be changed through those management plans, but that's where I think my suggestion for a adaptive management plan condition to be able to respond could be that backstop to the other parameters that may exist that are unanticipated by those management plans. And if that was in place, then you wouldn't necessarily need to go through a Section 127 application to amend the consent itself.
Sorry, that seems like you're giving yourself quite a bit of license there to do that, but it's a consent with an application just as anybody else applying for a consent. Generous is the term that comes to mind, but yeah.
So I'm not implying that the consent holders could change any condition. Only parameters that related to the matters set out in 23A to G. And only as they're related to existing conditions within the consent. So it would be responding to any unanticipated effects as a result of the exercise of the consent in accordance with the conditions.
When it says whether 23A, whether any amendments to the consent are required to better protect the lagoon and ecosystem health. So what amendments to the consent are you suggesting?
So that might be things like amendments to the secondary indicators or the critical indicators that the science advisory group would use to provide advice as to whether an opening is required or not. They're fairly comprehensive at the moment, so I would see that would be a backstop. I wouldn't anticipate it. I don't think it would be likely that it would need to be utilised, but if there were backstops like that built into an adaptive management approach, then that would provide some additional benefit in ensuring that those environmental backstops are built into the conditions.
So, do you think that some of those parameters that are identified in the appendices, which that they are performing in the same way as a performance standard might do within a consent condition, that they're actually a performance standard, and that you wouldn't be able to amend them? Wouldn't they need to be, you'd need a 127 for that?
Are you referring to the primary and secondary indicators in Appendix 1 and 2?
Yeah. So wouldn't they fall within a performance standard, and that they need to be set out in the conditions of consent, not determined later? Sort of following the Environment Court's practice note 10.4.
Yes, no, I do agree with that. It would be difficult to change them without being explicit in the applications as to what was a performance standard and what was something that could be subject to an adaptive management approach.
Do you have anything else that you, in terms of what we've talked about already, that you wanted to discuss this with before we move on to our questions to your evidence first?
Yes, there were also some questions around the conditions of consent and whether they need to take, or whether Tauranga Māori cultural considerations for monitoring and exercise of the consent, whether those can be undertaken through the conditions. So reflecting on that, and just to provide some context to the conditions that you have before you, as a co-applicant, the conditions of consent have been prepared in partnership with Awarua Rūnanga. So that includes all of the drafting of the conditions and their content. But I agree that additions to ensure Tauranga Māori and cultural values can be incorporated as mandatory considerations into the monitoring plan if Rūnanga considered that was necessary and valuable, could be accommodated in those conditions. Equally though, that wouldn't compel Rūnanga to undertake that additional monitoring if they didn't consider it necessary either. So that's something I'd like to reflect on with Rūnanga representatives and confirm with them whether they would like any changes or not to address those values. My understanding is that they're satisfied with the conditions of consent that have been drafted, but undertaking the exercise would be beneficial.
And look, I just want to clarify, I might be misunderstanding what I'm seeing in front of me. So I'll just take the opportunity to clarify because I'm not a planner. I want to make sure I understand that. So what I saw here in front of me was it's a resource consent to say if these triggers in Appendix 1 and Appendix 2 equal this, then we do this, right? Which is open the lagoon potentially. There is really clear what the Western science was. When I read then condition 23, which is review of monitoring, which we've just gone through, I didn't read that as giving anyone authority in any way to change the consent that we have in front of us. And so for me, I'm thinking, so where is Mataranga Māori in this? Because all we've got in here is Appendix 1, Appendix 2. There's no Appendix 3, which actually says from this point, if there is good Mataranga Māori available,
So-
I see that the A, 23A, it is saying we're going to do an assessment on whether or not the consent will better protect these things, including cultural values. But I just didn't read that as giving anybody any authority to make any changes to the consent after that assessment. And I was still sat here going, and so what if you do an assessment? Because ultimately, what does it mean? And so I was on a cultural value. Have I misunderstood that? Have I seen something wrong and missed a condition there?
No, you haven't entirely, but the genesis of the primary and secondary indicators comes from the Science Advisory Report. So that's the report that you've heard has been referred to a lot in evidence of others. That's attached to Appendix B of the application and was a report prepared by the Science Advisory Group that includes cultural expert representation. So the Science Advisory Report sets out how cultural values have been considered in determining the primary and secondary indicators. And the Science Advisory Group also includes a member that has cultural expertise feeding into the advice that's provided or that would be provided to the consent holders. So the genesis of those appendices comes from taking that multi-values approach in that report that considers the ecological and the Western science lens and values, but also that Mātauranga Māori perspective as well. And that the Science Advisory Group, there's a role for that cultural expertise in that movement forward. And that's been incorporated into that reporting as well.
I appreciate there's an opportunity to participate. I get that opportunity to participate, but then what we also heard from the cultural values expert earlier today is that there has been a disconnect from being able to truly understand Mātauranga Māori. It's not stagnant, it doesn't stand still, and there's a desire to actually learn more and bring it in. And so that's what I'm potentially saying. There's a gap here. If the true intent of or purpose of the opening is ecological and cultural values, then I can't see participation is totally separate than recognising in the consent that it must be taken into account if it is available to be taken into account. But I go back to what you opened with on this particular discussion, which is you're going to give further consideration to that and come back with something. So that's helpful.
Great.
Could I, Ms. Dawn, if you're going to be talking, I'm just going to suggest we leave conditions now because I'm going to talk to you about conditions certainly at the end. I think it might be, given the time and that, we might move just to questions that we have regarding your evidence and go through that and then come back to the conditions at the end. Okay, so I'll start and ask you a couple of questions in relation to the your evidence. The information that was, I'm on page 5, Roman 3 of your evidence and sheet. And I understand you're talking about this is additional information, and this is the stuff provided on the 23rd of June this year. So, where is that a Section 92 request, or is that a request for something that came out of information that came out of the request for that came out of the pre-hearing meeting? I just wanted to.
It's a Section 92 request that came out of the consent authority's peer review of the application.
Right.
So
I don't appear to have a copy of the Section 9. I've got the response. If someone could provide to us on code so that can be given to us just a copy of the actual request itself, that would be helpful.
So the request for further consideration is set out in the peer review of those experts, and I think it's available on the website as well.
Hard copy will be fine. Page 6, paragraph 17. I just wanted to clarify that in minute 1, we didn't direct the expert conferencing, we just requested it, just in case anyone asks. In page 8, paragraph 25, with the proposed opening under AB's CD, but just confirming that that's the latest version of the proposal. Is that correct?
That's correct. Thank you. So that will defer to what is in the application AE.
And that's a result that moved from what was in the application, and you had the pre-hearing meeting, and this is a response to some of the issues raised in that pre-hearing meeting.
That's it, and that was a package of updates to the application that was submitted to the consent authority in May.
So in terms of activities requiring resource consent, so we've got all of the it's relatively clear about which ones are in covered by the Southland Water and Land Plan and the Regional Coastal Plan. It's just in terms of the New Zealand Standard for Freshwater Management, I'm just confirming in terms of that, those standards, what breaches it and under which category is the application?
If I can refer you to section 4 of the application. Resource consent requirements.
Right.
In section 4.4 within that National Environmental Standards for Freshwater. So that section of the application sets out the regulations within the NES for freshwater that apply to the application.
So
with
38 and 55, all the permitted conditions can't be met, therefore it falls to
a restricted discretionary activity under Regulation 39 for the purpose of natural inland wetland restoration and wetland maintenance.
So that's the activity class that just appears in the italics at the top and makes it very difficult for anyone to decide.
That's it, and then refers you to other other clauses. Yeah. Yeah, and then on page 33 of the application, there's a bullet pointed list there that sets out why not all permitted conditions under Regulation 38 that relate to restoration can be met. So those are the conditions in Regulation 55.
Paragraph 47, page 14.
Of my evidence?
Yes, yep. Just in terms of the historic heritage, natural character, natural features, landscapes, sorry, could you, how does landscape work here within the Southland plans where we've got the regional coastal plan, and then on the landward side we've got the other regional plan, the land and water plan. I'm trying to, where does the landscape come into it?
So the only statutory document that schedules outstanding natural landscapes would be the district plan.
Right. So when it refers to natural features, there's no submissions about it. I agree with that. You've adopted, I'm just trying to understand where does, there's reference to landscape in the application and that sort of thing, but is it in the landscape within the coastal marine area? Or, sorry, if it's,
yes,
if
so
it is,
it's
coastal marine area, the lagoon is not in the coastal marine area, so.
no, so it's a landscape within the coastal environment overlay of the district plan.
Of the district plan.
That's correct. Yeah, the lagoon isn't within any landscape that's mapped in the regional coastal plan. It's the district plan.
And it's not, there's no regional plan that addresses landscape, it's all within the district.
The land and water plan has an outline of landscape values, but it doesn't categorize whether those values are outstanding natural landscapes or significant natural landscapes or outstanding natural features, for example.
Does it have any rules?
No.
So it's just policies?
Just policies and a schedule.
Thank you. Paragraph 56, page 17. The conditions of consent under 108 is fine. Is there any conditions being offered or that under 108 AA, capital A?
Really? Is there? No, I don't think so, but if I can come back to that and think about that a bit further.
Now, this is your opportunity to answer our questions and speak now. It's not, there isn't another opportunity, unfortunately. Unless you're suggesting that Ms. Williams addresses it in reply.
No, just thinking through whether I would have any. I think probably the only condition that would be a Section 108 AA condition would relate to the alternative opening locations, which we've already discussed. The Science Advisory Group report, particularly section 6.8, clearly sets out why Walkers Bay is a preferred location for opening the lagoon. So alternative opening locations were requested by the community through pre-application engagement. That would probably be the only condition.
If I read it, when it says alternative locations, again, it's not alternative. The alternative location to Hanson Bay is anywhere along the bar, I assume within the land that the department manages there.
Alternative to Walkers Bay, yes. And then, yes, that is all within conservation estate.
Paragraph 57, in terms of the duration of the consent, is there any policies that provide guidance as to duration of consent within the Southland Regional Land and Water Plan?
There are. So the policy reference is policy 40, and that's at page 49 of the Southland Land and Water Plan. So when determining resource consents, consideration will be given but is not limited to a range of matters. That includes granting a shorter duration that is sought by the applicant where there is uncertainty regarding nature, scale, duration of events, etc. Relevant to federal values, duration sought in the application and reasons for the duration sought, the permanence and economic life of any capital investment, desirability of applying a common expiry date for similar water permits, which wouldn't apply in this case, the applicant's compliance with conditions of previous consents, and the timing and development of a future FMU setting process.
The rest of my questions are going to be about the consents. So I'm going to, Commissioner Booth, would you have anything in terms of
evidence? Probably not in terms of evidence.
Yeah.
I have with the GWS.
Oh,
it's just
yep.
Yeah, Ms. Thorne, thank you. I really only have one question or one sort of seek some clarification. In the joint witness statements that we received today, the most recent one, there was obviously some disagreement over the classification of the lagoon. In essence, it's kind of wetland status. And I know you put your views there. My question is really quite simple. Have you relied on any technical advice informing that view on what the Waituna Lagoon is?
I've relied on the classification of the lagoon within the Southland Land and Water Plan, and that has relied on technical assessment to determine what is regionally significant wetland. So it is scheduled as a regionally significant wetland within at the time the application was lodged. I held a pre-application meeting with the consent authority where that matter was discussed, and the consent authority agreed that yes, it was a regionally significant wetland and consent should be applied for on that basis. Since the matter over its status was raised in the evidence of Ms. Sanazaro, I sought further clarification again from the consent authority on its status, and again that they've confirmed that it's a regionally significant wetland and a sensitive water body within the Land and Water Plan.
Thank you.
Haven't relied on any technical advice in terms of a wetland delineation protocol, for example, having been applied.
No, thank you. That's what I was getting to as well. And presumably the advice to the SWLP has been from wetland experts.
Presumably, yes. And I think that's it. In fact, it's footnoted as such in the appendix.
Thank you. Thank you. I'll follow that up. Thank you. Yeah. Thank you.
Mine were just how to respond to Federated Farms, and I think you've done that through that process in any event.
Right. So I'm the one keeping us here, so I'll try to make this quick. So the conditions I'm referring to are the ones that are attached to your evidence, and it's the clean version, although it says draft proposed conditions, section 42A tracked changes on the heading. It's not, my version is not page numbered, so I'll put page numbers on it so it might be able, we can more quickly go through. Right. Throughout the conditions, there's a various usage of will, shall, must, may. Which is it?
Should be must. Should be
must, yeah. So expectation is that the conditions would reflect that. In condition 1,
I'd agree.
This consent authorises. Who does it authorise?
The consent holders.
Shouldn't it say that?
Yes, I'd agree. It should say that.
When it says or at another location, isn't that a reservation of discretion?
Yes, I'd agree with that.
In condition 2, the water level of the lagoon will be measured at the bridge, or if that's not available, an alternative location.
Yes.
Were you here for my questions of Mr. Rebel and Mr. Measures as to where the alternative location happens to be?
Yes, I was there for that. And this addition to condition 2 was at the request of the consent authority through changes of conditions recommended. I'd have been through the section 42A report, which is prior to preparation of that report.
I'm in a position where I don't, I haven't heard from the consent authority from their expert, who's apart from legal matters, Mr. Duisberg's probably going to address us on some things. Whether it's there or not, I want to know for you as planners whether that should be in there, where nobody appears to know where the alternative location is. So what would they be certifying?
That's a valid point. My understanding, based on the information of not evidence, but the information that Environment Southland holds and the evidence of Mr. Rabel around the appropriateness of the Walkers Bay gauge location is that is appropriate location for the gauge. So I would think that could be relied upon in condition 2.
Okay. Do you think that maybe a series of abbreviations or acronyms at the front and a table might assist?
That would be helpful. I'd agree with that.
Just where through the conditions it says things like in number 6, the lagoon may be opened to the sea, again, by whom?
Yes, I'd agree with that. And that the same would apply at conditions 4 and 5, and potentially in a number of other locations and conditions.
In terms of the, and you may have corrected some of these just by the way, but I'll just get off this one because this is where all the questions are. In condition 8, the consent holder must have and implement a consent implementation plan. Shouldn't that be, they have to prepare one to start with, and it's got to be prepared by a suitably qualified person?
Sorry, can you repeat the condition number?
Condition 8, which is the consent implementation plan.
And the question, please.
Rather than just have one, shouldn't the condition require that one's prepared by a suitably qualified person in terms of the standard our management plans, which this has a lot of similarities to?
It does, yes. Yeah, so that would be changing the term have to be prepared. I think that the reason it says have is simply because a consent implementation plan has already been prepared. Keep scrolling through those conditions to condition 12. That's where within 6 months of the commencement of consent, the consent holder must update the consent implementation plan to ensure it meets all conditions. So if a consent implementation plan hadn't already been prepared, then that would say must be prepared. But I think it says must have because that implementation plan has been prepared.
Just generally, I think that the management, all of the plans in here which look like management plans probably all need to be updated, and because quite a few of them are all got references to these conditions which are all incorrect, and that probably within a certain amount of time of the consent being granted and before the openings are exercised, that might be a more appropriate way of having a consent that would actually address the effect. You could be opening it under this potentially ahead of opening the lagoon before you've actually got the implementation plan in place. So just in terms of management plans, and this applies to all of them, it's generally accepted there's got to be a requirement to prepare it, prepared by a suitably qualified person. It's got to have a purpose, which in some cases that's been identified. There's a process for certification which needs to be set out, and a process for amending the plan if you're required to amend it, and a process for that. And that needs to sit there either for one or all of the conditions. And there's got to be once the plan's in place, you've got to have a requirement to comply with the management plan. In some places it says that a number of these things, in other places it's silent. So all of that would need to be fixed. Condition 11, the CIP must detail how all the representatives of the scientific advisory group are to be compensated for their time. So I'm just trying to understand the adverse effect that condition relates to.
That might be something that Ms. Patricia is able to respond to in more detail. That was at the request of the consent authority. That isn't.
I think our request would be that whatever the consent authority wants, right? If it's not a lawful condition, then we're not that concerned about it. All the conditions need to be ones that would be lawful. So
that's it. So that would be another condition that the applicant's accepted under section 108AA.
I was going to say exactly that. That was one of the matters that submitters were concerned about in terms of having those independent representatives on the science advisory group, was making sure that their costs were accounted for.
Well, if it was going to be something like that's going to be included, then an explanation of why it's there would be would be helpful.
So I agree, it would be a 108AA.
In terms of page 4, condition 15, the science advisory group, I couldn't see where it said how many people were on it. You've got a science advisory group, how many? It's got to include, it's got a list of people here, but I was wondering whether it might say something like, well, of 10 members, 5 members, whatever it is, just so that everybody knows.
Yes, the condition isn't explicit in that regard, but the minimum membership would be 5, because it would be a representative, or sorry, a suitably qualified expert representative of the Director General, Awarua Rūnanga Environment Southland, a suitably qualified expert chair, so that would be member 4 that's independent of those organisations, and nominated suitably qualified representative from the catchment community as well. So that would be member number 5. And then the condition also provides that that may include other experts that have necessary scientific knowledge too. So minimum 5, but there could be more representatives if that's necessary to ensure that the science advisory group has the expertise.
Condition 15C, Roman numeral 2, other suitably qualified experts, scientific or cultural knowledge of the lagoon approved by the consent holders. Reservation of discretion. The consent holders are going around appointing people. The next one is the note. Isn't it an advice note?
It's an advice note, yes.
Then it should say so. And then the advice note refers to the Environment Court's Code of Conduct is going to apply to these people. How? It's not a court session. It's not a hearing. So I don't understand that. In terms of the conditions, also wondered about, is there any biosecurity matters or that sort of thing that need to be in terms of, I don't know, washing vehicles that have been digging the thing out? Is there don't have any evidence, but if there is anything in there, should that be included as a condition of consent? You probably heard me go on about all those other things, and you've acknowledged that already. Refueling, a spill management plan that is a requirement. Again, all to be done. Conditions to say that it has to happen before the any works are undertaken. Should Appendix 1 and 2 in particular, possibly the other parts, do they lose anything by being an appendix to the conditions? Or should they, if they're limits and that sort of thing, should they actually appear in the conditions? I'm trying to understand some of this from both a enforceability perspective. Do you have a view?
My view is that as long as they're explicitly referenced as being the primary water quality and ecosystem health indicators and triggers in the conditions, that having them in appendix would be appropriate. And I think condition 5 does that. So I think in this instance, having them in appendix is okay. If it wasn't so explicit in condition 5, then certainly that would need to sit in the body of the condition.
The other issue is just about in condition 20, I think it is, in terms of the monitoring and that sort of thing. There's nothing in here about what the frequency of the monitoring, and that's all devolved to this monitoring plan. Surely some of the things like that about how often it's done, what frequency, what you're monitoring for, and what you're going to do with that once it's finished and with a reasonable time frame, that should all be sitting within the condition of consent, not within the management plan.
I would agree with that. That would make the condition more certain, yes.
So there's probably quite a bit to that, because we asked quite a few of the experts about the monitoring and how that was going to be included. 22, just as an example, the information gathered shall be provided in writing to the consent authority annually or on request. I'm trying to see what the connection is between the decisions and timeframes that people are making in terms of when they're opening the consent. Is annually sufficient in terms of providing that? I don't know. The applicant, other people to explain how that might all fit together. The closing off of access and any conditions around that, they don't, there's nothing in here about that. Would have thought somebody might suggest to us that health and safety is a Section 5 matter and that it should be included in there. But,
so just to clarify, you're referring to public access along the bar?
While it's along the bar, while it's opened, should there be some conditions in here about how that's managed, signage, whatever, all of that type of thing? That should be in there.
I consider if at an alternative opening location, yes, where it's close to public access points, certainly. At Walker's Bay, their location's very remote though, so the public being able to readily access that without doing a 3 to 4 hour hike to get there from the car park, it's a pretty inaccessible location.
Could ride a motorbike.
Not in the reserve, you can't.
Yes, they may not be permitted to do that, but there's lots of things we're not permitted to do.
That's true. Feasibly, a boat could. Yeah.
So, yeah. Should there be a map attached to informing part of this consent, which is the terminology I prefer? Should the map where the location is be attached to the consent?
In terms of the Walker's Bay coordinates. Yes.
And potentially the other locations, but I don't know the answer to that yet. This is just the conditions of consent, and there don't seem to be consent certificates as such at the front saying this is a consent under this to carry out this activity in this location, and it's a coastal permit or it's a land use under section 13, and that what the consent lapse period and the term of the consent are not things that you're able to change under the 127, for instance. You can't change the duration. So they're like things above the line, and here's what you're permitted to do and at these locations, and then after that, and here are the conditions that you're required to do it under.
So sorry, is the question that the proposed conditions by the applicant should set that out?
The conditions from the conferencing of the planners should cover all of those things off. So my questions and whatever, Ms. Thorne, are not directed just to you, it's to the other planners and that as well, particularly if potentially we're getting through to the end of this. It might be that we suggest that conferencing to do that might be useful.
I would agree that would be very useful. We might be of a mind that we think that might need to be, or that would be advantageous if that was facilitated, conferencing. So that's just our initial thoughts. But I think you've got a clear idea of what our concerns are with the conditions. Yes.
Okay, thank you.
Thank you.
I don't have anything further at this stage, and hesitating to ask the other commissioners. No, excellent.
Got loads.
Oh,
No, I haven't.
It would appear that you're going to have to reappear at 8 o'clock tomorrow morning. Oh, you're kidding. Okay, yeah. Sorry. Okay. No, fortunately, we're all finished now. Thank you. 7 o'clock. Yeah, no, very good. We're going to, that ends
ends
presentation.
at this point, because of course we still have Dr. Robertson to go.
Yes, yeah.
So yes, so that certainly at this point ends the
yep.
applicant's evidence in support of its application, or their application.
Yes.
I will be back here tomorrow, but not sitting at this.
No. Okay, that's great. So we're adjourned 8 minutes past 7, and we will reconvene at 9 o'clock tomorrow morning. Thank you.
Thank you. Thank you, Mr. Thorne.
I think I'll give the groceries for this.